The Committee on Criminal Jurisprudence will come back into order, and the clerk will call the roll.
Chair Smithy,
Aye. Here.
Vice Chair Wu, Representative Bowers, Representative Cook, Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
So a quorum is present. We're ready to take up bills, members, and I would just remind the audience, I've already announced this once, but if you intend to testify, first of all, we're glad you're here, but we would ask that you fill out a electronic witness affirmation on the kiosk out in the hall if you haven't already done so. Once again, if you don't wish to testify, but you wish to register your support or opposition to any particular bill, you can also do that on the kiosk as well. Just indicate that you are not testifying. One thing that we've got a lot of bills, a lot of witnesses today, so we're imposing a 2-minute time limit. We would ask that you would voluntarily comply with the 2 minutes. We'll have a timer up here. That doesn't include any questions that might be asked. And we just as a courtesy to the other witnesses to try to limit your testimony to the 2 minutes. I may be rude and interrupt you, and I apologize for that, but we try to keep the hearing moving along. So if there's nothing other that we need to deal with, the chair at this time would lay out House Bill 2617 and recognize Representative Anchia.
Thank you, Mr. Chairman and members of the committee. I know you've been working hard today. I was watching earlier today and appreciate your favorable consideration. Mr. Chairman, Vice Chair Wu, members of the committee, last session we passed this bill out of the House with overwhelming support. And regrettably, it ran out of time in the Senate. The overarching policy principles of this bill are judicial economy and efficiency in the administration of justice so that more Texans can find the criminal justice system accessible. I love this bill because I get to brag on my friends and colleagues in Dallas, both at the District Attorney's Office and the University of Texas, Dallas College of Law, because we're utilizing specialty courts, including veterans courts, for diversion programs, and they've been very, very successful. And the learning that we've done after 8 years of these courts, we're bringing to the legislature as a best practice for the whole state. Currently, members, if you're a low-level nonviolent offender and you want to expunge your records, you are able to go through pretrial diversion. And now these are not, easy programs. These last anywhere between 18 months to 2 years. They include being embedded in a veterans treatment court. They include access to social workers, counselors, attorneys, the judge, and participants not only work during the day, but then they show up in the evenings to attend life skills classes. And it's reduced recidivism in Dallas substantially. At the end of the diversion course, however, where hundreds of people are celebrating completion of the requirements, they're graduating, and despite warnings to the contrary, in Texas, we have an incredibly bureaucratic process that requires individuals to come back to the court to actually file for expunction. This requires an application, at least $290 in fees, a mandated return to court, and most oftentimes the costs related to hiring an attorney. So this leads many of the graduates to never receive the expunction that they actually earned. And legal scholars have studied Texas, and they've dubbed this the Texas Second Chance Gap, which is the difference between the number of Texans who actually earn the records relief and the number who actually receive it. And this is not a small number in the state. It's estimated that about 670,000 Texans were left behind in the second chance gap. And what does that mean for them? It's people who go in for a job interview or for a promotion at work, and they think they've had an expunction, and it turns out that the expunction was never completed. And so it costs them money. It's estimated that about $3.5 billion in cumulative earnings are lost every year as a result of this gap. In Dallas County, we've seen that 50% of the people who go through the diversion program spend 18 months to 2 years of their lives in these programs, never get their records expunged. So this problem exists all around, and this bill, what it seeks to do is make the highly bureaucratic and complicated process much more straightforward and easy, so that the counties that do pretrial diversion programs, including the veteran programs that are very, very successful, can have virtually automatic expunctions. And these, I'll just give you a quick list of counties in your areas that are doing this really, really well. We've got Randall County has a pretrial diversion program, Harris County, Vice Chair Wu, Dallas County, Tarrant County, Hunt County, El Paso County. This is a non-exhaustive list. So again, this closes the second chance gap by streamlining the expunction process. So members, I hope that you get that you give this favorable consideration and help Texans more easily access the expunction process. And Mr. Vice Chair, I humbly ask for the opportunity to close.
Thank you. Members, are there any questions? Seeing none, we'll call our first witness.
Thank you.
Reserve the right to close. Chair recognize Speaker Moody here as present. Call up Mitch Fuller. Okay. Hi, Mr. Fuller. I have you as Mitch Fuller representing the VFW Department of Texas, and you're representing them and yourself. Is that correct?
That's correct, Mr. Vice
And
Chair.
you are for the bill.
That's correct, Mr. Vice Chair.
Please proceed.
Good afternoon, and I want to thank Representative Anchia for introducing this bill. Veterans treatment courts have absolutely changed lives. I live in Williamson County, which has a great program. Judge Laura Barker is the judge there, and she invited me to come speak at the graduation 2.5 years ago. And I met 2 people I served with, including one person I served in Iraq with. And to hear those stories when they graduate, and it's a tough program, as the rep said, it's a 5-step program, and it's not charity. If you hold the line, the judge is going to work with these veterans, and it is absolutely transform lives. And so if you're successful in completing the program, that expungement is absolutely critical for getting your life back. So we fully support the bill. Thank you again for carrying it, sir.
Thank you so much. Members, are there any questions? Thank you so much.
Thank you.
Recognize that Representative Rodriguez Ramos is present. Call up M. Page Williams. And I have you as representing the Dallas County Criminal District Attorney, John Crusoe. And you are for the bill, is that correct?
That is correct.
Okay, please proceed.
My name is Paige Williams. I'm here representing Dallas County Criminal District Attorney John Crusoe in support of House Bill 2617. I am part of the expunction team in Dallas County. We run the Expunction Expo, and over the last 8 years, we have reviewed over 10,000 applications. And I am in charge of all the data. So in 2022, we discovered this trend with these specialty courts, particularly with the Veterans Program, where these individuals were not taking that next step to get their records expunged, even though they were 100% qualified under the current statute. And we worked with Representative Anchia last session to craft this language so that we could move them to an expedited expunction process, so that before the court loses its plenary power over the case, that judge can grant the expunction for the individual that has successfully completed the program. And I'm happy to answer any questions.
Thank you. Members, are there any questions? Rep. Lauterbach.
Thank you for testifying today. Give me an idea of how many systems like this are in the state?
Most of your larger counties are definitely going to have a veterans program. Then we have mental health court, which is part of these identified specialty courts in the expunction statute. And then we have what's called drug court that are supervised by CSCD. I can't speak for all of the counties, but I know at least in Dallas, we have 5 that fall under this category. Of the 18 that we have total, 5 of them are under this category. I know that there is a board of specialty courts inside the state that runs the gamut. And then it is my understanding that we also have regional specialty courts for the smaller jurisdictions that can't run a solo court on their own, so where multiple counties, I think y'all passed that a few sessions ago, where multiple counties could join forces and run one specialty court, particularly Veterans Court, which is usually what most counties go to first. They start with a Veterans Court program and then develop from there.
Give me how many veterans are we talking about?
many?
What's the numbers for a year
Across the state or within Dallas?
within Dallas?
Within Dallas, at any given point in time, we're running between 25 and 60 veterans. Now, understand that they are all in different stages of their program, because as Representative Anchia did point out, these are rigorous programs to get their lives back on track. And they usually take 18 months. I know particularly in Montgomery County, our counterparts there, their program starts at 2 years. So you have to do a 2-year commitment to get into the program.
So they have to successfully complete up to 18 months of a 2-year program in order to have their record expunged from the arrest that they're arrested for.
Correct. And so what that means is that initial interaction with law enforcement is completely removed from their record. No one would have access to it after the fact, not even law enforcement. And any future employment, everyone those records are destroyed.
Which for an expunction, whoever gets an expunction, that's what's covered, correct?
Correct.
Okay, all right, thank you.
You're welcome.
I recognize that Chair Cook is here. Members, are there any other questions? Thank you very much.
Thank you.
Oh, I'm sorry. Just one more thing. We have you registered as M, the letter M, Paige Williams. Is that correct?
That is correct.
Okay, thank you. Next is Angela Downs. Hi, Ms. Downs. We have you as representing UNT Dallas College of Law and yourself, and you're for the bill. Is that all correct?
That is correct. Thank
you
you
very
so
much.
much,
Please
Vice
proceed.
Chair Wu, members of the committee. My name is Angela Downs. I'm a law professor at UNT Dallas College of Law in Dallas, Texas. And we have worked hand in hand with the Dallas DA's office, the district clerk, the public defender's office, and other community entities with the expunction fair for the past 8 years. It's truly been a labor of love for us and falls in line with our school mission of not only educating the next generation of law students, but also ensuring that we're providing legal services to those who might not have access to lawyers. So one of the things that Ms. Williams did not share in her testimony to you this afternoon is that in order to have an expunction fair, you must have lawyers. And you have to have lawyers that are volunteering their time. And so UNT Dallas College of Law has really worked hand in hand, has focused on working on the paperwork for those that come through, those 10,000 folks who have registered, who filled out the paperwork, who desperately need these expunctions. We have done the lion's share of the work. And so it's been me, a very small team of student lawyers under my supervision, and a few others on our staff at the law school who've worked on these cases. One of the things that we've discovered is that we can never provide all the legal services that folks need. And so this bill would be critical with ensuring that folks that have earned that expunction, that have done the work, that have gone through this very rigorous program would have the opportunity for their cases to be expunged.
Thank you very much. Any questions for Ms. Downs? Appreciate you being here.
Thank you so much.
Chair calls C.J. Grisham. And Mr. Grisham, your affirmation shows that you're here on behalf of yourself and you're for the bill. Is that correct?
Yes, Chairman. And thank you for this time. Thank you, Representative Anchia, for bringing this. And I'm going through a skin cancer treatment, so I apologize for my unusually ugly face. So I'm a veteran. I'm also a civil rights attorney. I've been doing that for about 2.5 years now. I'm so thankful for what UNT does. I'm glad to see that there are other people out there doing these expungements because I do them also. I do them at cost. In other words, they just pay me what it costs for me to file stuff. But even that's expensive. And a lot of people don't even realize, I'll talk to clients, they don't even realize that this is an option to be able to get stuff expunged, even though they qualify for it under the current law. As was mentioned before, you've got not only just the fees associated with trying to file this that fall onto these people who are entitled, that's the word in the law, entitled to an expunction. Not that they may get one. And then they have to hire people like me to do that. And not all attorneys are in a position to be able to or want to do this kind of work for free because there's so much of it. I wanted to answer, I'm not going to repeat what's been mentioned before. I wanted to answer some of your questions, Representative Louderback. There are 34 veterans courts as of last year. 500, and these are all from 2024 numbers. 576 veterans have completed Veterans Court, and there are currently around 831 active veterans in Veterans Court. What this does, what these expunctions do, is it allows people, everyone makes a mistake. Not everyone makes a mistake that rises to the level of a crime, but people do, even in criminal worlds, make mistakes that they get charged with criminal activity for, and they never do anything again. And when you give them this opportunity to get those criminal charges reversed, they're less likely to be recidivists, and it allows them to move on with their lives. And so I urge the committee here to pass this bill and make this law. So thank you.
Well, thank you. Any questions for Mr. Grisham? Okay, appreciate you being here.
Thank you.
Is there anyone else here to testify for, against, or on House Bill 2617? If not, Representative Yanchia, you want to close?
Thank you, Mr. Chairman. For those of you who just arrived, we passed this bill out of the House last session overwhelmingly with over 125 votes. It ran out of time in the Senate. There are 670,000 Texans who have earned and who are entitled to expunctions. Only about 50% in Dallas County receive them because of the bureaucracy and the cost. This bill seeks to eliminate a lot of that bureaucracy and cost and make it easy for them to get that expunction that they deserve and have earned.
Well, we appreciate you bringing the bill. Ms. Jones has a question.
So I want to thank you for bringing the bill.
Thank you.
I've done expunctions. They cost a lot of money. I can remember doing an expunction in a small town, and the person had to pay thousands just to pay all these agencies for wiping their bills, which I was like, there's no way there's that much wiping in the world. And the truth is, even if you have a case that's dismissed, when they run your records, people are now asking, have you ever been arrested for something? It used to be convictions, now it's like, no, we just want to see. So I think that this will allow people to move forward, because having arrests on your records and dismissals, most people think you got away on a technicality, even though you really didn't do it or you jumped through the hoops. And so this will stop creating a barrier for employment, for housing, and other things for people. So I thank you for bringing this bill, because I know that it can work. And there are not enough expunction clinics to get this done.
Thank you.
Okay. Anything else from Ms. Branch? Mr. Louderback?
Representative, can a Veterans Court take any charge?
No, this is for low level. Let's see, it has to be two things. It has to be low level and nonviolent. So not just any charge.
Not just any. Okay, thank you.
Thank you.
Okay. Anything else, members? Okay. Thank you.
Thank you, Mr. Chairman.
If there's no
Thank you,
other
members of the
questions,
committee.
The chair will leave House Bill 2617 pending for now. Mr. Turner, you ready? The chair lays out House Bill 1347 and recognizes Representative Turner.
Thank you very much, Mr. Chairman and members. Good afternoon. Too many vulnerable Texans in assisted living facilities, residential care homes, group homes, boarding homes are unfortunately being exploited through deception and coercion that our laws don't get fully addressed. And we must strengthen protections and close those gaps to allow bad actors to operate unchecked in those types of settings. So currently, Texas law lacks a clear definition for terms such as coercion, deception, and isolation, and this creates a loophole that's been exploited in these settings. I could give you a lot of stories. I'm just going to briefly share one. Diana Acox, who's a 76-year-old woman from Fort Worth, and after being diagnosed with dementia, She was placed in a Arlington boarding home operated by a woman named Irika Hamilton. And subsequently, Ms. Hamilton filed documents in probate court and gained ownership of Ms. Acox's home, which is, of course, her most significant financial asset. And as a result, Ms. Acox resides in a memory care unit while her house sits empty amid ongoing legal battles. And this bill aims to protect Texas' most vulnerable, like Ms. Acox, but also children, individuals with IDD, and others. So in my work on this issue over the last few years, I've talked a lot to local law enforcement agencies, and they've reported that they frequently encounter cases of exploitation targeting vulnerable individuals, but they often lack the legal authority to charge offenders with a crime. And so what this bill does, expands and clarifies the legal definitions of coercion, deception, exploitation, isolation to reflect modern forms of manipulation, and thereby hopefully providing better protections for vulnerable Texans. And that would ensure that situations like the situation I just described, and as well as many others, could be resolved through law enforcement action. So the bill defines that the offense if the person through exploitation, deception, coercion, or isolation knowingly appropriates the resources of a child, elderly, or disabled individual for the person's own monetary or personal benefit, or for the monetary or personal benefit of another person other than the child, elderly, or disabled individual, that's an offense. And the goal of this legislation is straightforward: to expand the definition and clearly define these acts, deception, coercion, isolation, to modernize and clarify these definitions to protect vulnerable Texans. In closing these gaps, we give local law enforcement officials and prosecutors the tools that they need to crack down on these bad actors. And we have, I think, at least one witness who can speak more to the law enforcement perspective on this, but I'd be happy to try to answer any questions the committee may have.
And so, any questions for Mr. Turner? Okay, we'll call the witness.
Thank you. I think I knocked something off.
Gregory New. And according to your affirmation, you're Officer Gregory New, here on behalf of the Grand Prairie Police Department, and you're for the bill. Is that correct?
Yes, sir.
Thanks for being here.
Thank you, sir. Chair Smithy, Vice Chair Wu, and the members of the committee. My name is Greg New, and I'm a police officer for about 36 years. I currently work for the city of Grand Prairie, proudly serving them for over 30 years. I hold a Master of Peace Officer certification, and I'm a mental health peace officer as well. Currently, I'm assigned to the department's crisis support unit, where I work alongside a licensed mental health professional. Together, we respond to the calls involving individuals, crisis, and many of the people I encounter suffer from cognitive disorders, such as intellectual development disorders, Alzheimer's, dementia, to mention a few. Tragically, many of these individuals are taken advantage of, not by strangers, but by the people who claim to care for them. Time and time again, I've witnessed the consequence of exploitation by those who are supposed to protect them, their caregivers, their family members, even in isolation, or institutions, excuse me. The current legal tools available often fall short when it comes to recognizing and prosecuting these offenses. I'm here today to express my strong support for House Bill 1347, strengthening the Texas Penal Code by clearly defining what exploitation looks like. If I may, just like Representative Turner did, share a quick story with you. Individual named John. John was placed in a house where he knew no one. He was isolated from his family, friends, and on several occasions a friend attempted to visit with John, bringing him his mail, to check on him, and was repeatedly denied access to John. He continuously got excuses from the caretakers that they weren't at home or John didn't want visitors. This incident took place over several weeks. Once again, John's friend attempted to visit him and was denied this time, wanting to hear from John. He didn't want to just take it for their word. He wanted John to tell him. The homeowner responded with a video of John in pain, and when asked if he wanted visitors of John appearing in pain, replied no. This video was sent days after John's death, and he did not know John was dead. The charade continued as the caretaker continued to send text messages as if John were alive, allowing the caretaker time to access John's personal accounts, his home, his cars, getting those put in their name to sell off his property. The same friend had noticed a will before all this happened John had handwritten for his daughter, leaving everything to John. So prior to John's death, the caretaker was able to remove approximately $30,000 out of his account, $60,000 after he died. The will, leaving everything to his daughter, was not taken care of. John, a veteran, left a will leaving everything to his daughter, wanting to be buried in the National Cemetery. Unfortunately, this did not occur. John's personal property was stripped from him, his daughter, sold while John's body was donated to science, and not allowing for his daughter's closure. With this, I respectfully urge the committee to support House Bill 1347 and to stand with those who cannot stand for themselves.
Any
Thank you
questions?
for your time.
Thank
Sorry.
you, officer. Any questions for Officer New? Thank you for being here.
Thank you.
We also, the chair calls C.J. Grisham. And is it Dr. Grisham?
Just CJ.
C.J. Grisham, you're registered on behalf of yourself and against the bill, correct?
Yes. So I want to give you a kind of, my name is CJ Grisham. Yes, I'm here to testify against the bill. I do like what it's trying to do. I'll explain why I'm against this, and hopefully I can work with the author to fix the issue. I have a client right now who's charged with exploitation of the elderly. We've got a motion to quash coming up, but how did he exploit the elderly? He was filming in a post office, not filming anyone in particular, just filming the way some of these people do. And an elderly person didn't like it. And the elderly person got the police involved. And both of them ended up going to the police to file a report, and she claimed that because he has a YouTube channel and he makes money off of the YouTube channel, that's where the monetary gain comes from, and therefore it's exploitation of the elderly because you're harassing this woman by filming her in a public place, which she has a right to do. There's no expectation of privacy. At first, I thought, when I started reading through this, I thought it was great because, you know, it's removing the section that says for monetary or personal benefit, but then it was adding the word harassment. But then later down in section 2, it re-adds back for the person's own monetary or personal benefit. The problem I have with the current law and the bill as written is simply because now I've got a client who's also a veteran, by the way, who is charged with felony exploitation of the elderly for doing nothing more than filming somebody in public, and wasn't even filming her, just filming in public, but she happened to be there, and she's the one that approached him, created a scene. All of a sudden now she's being harassed because he's filming her. The way this law is written, when we talk about monetary gain, anybody that's got a YouTube channel, if you film somebody and they don't like it, they're now going to be considered felons. My client can't have a gun because he's under indictment. Again, I think the motion to quash is going to be quite successful, but this is the side effect that I don't think is being recognized. The law needed to be changed. That section did need to be added out, and I think if we can remove that or at least somehow clarify with maybe a clarifying amendment, I can come into this because I understand and we want to protect our elderly. But the way that it's being interpreted by law enforcement, especially those people who like to film the police or film public officials, is just unconstitutional. And so I respectfully disagree and ask that you not pass this bill.
Any questions for Mr. Grisham?
Yes, ma'am.
Ms. Jones?
What exactly do you think is unconstitutional?
So people have there's no expectation.
Just like what you're saying, filming somebody in public.
And then being
is
charged with exploitation of the elderly because the elderly doesn't like it.
So you're saying because your client got charged with this, that this bill is unconstitutional? 'Cause
No, I
it
think-
seems distinguishable to me.
Well, so I'm doing an as-applied challenge. I don't think the law on its face is unconstitutional. But as applied here, and the way that that particular section that says for the monetary or personal benefit of another person, just because someone's got a YouTube channel and might be monetized, that's what they're using for this.
So this is, I'm not the bill's author, but I'd be curious to know what do you think would fix the problem?
Like I said, I think just that's a good question because, like I said, I'd be willing to work with the author and figure out a workaround. I actually didn't know this existed until today when I was going through all the bills. I'm here for other bills, and then I read through it, and I'm like, hey, I've got a client. So
I would suggest you work with him. I think that I won't say that. I don't think this, I mean, your client currently, this isn't a bill yet, so your client's not charged with, under this bill, because it's not a bill yet, or it's not the law yet.
He's charged with the law as it is right now, which
Right.
is this bill doesn't change the circumstances for which he's being charged with. It does. It actually, Initially, it does, because if you look in subsection 2 of section 1, you'll see that he marks out for monetary or personal benefit, profit, or gain. That's where the problem comes in, because that's being interpreted as if you're harassing somebody and you have a YouTube channel, there's your monetary gain, even if you're only
Okay.
making $3 a month on YouTube.
Right, but, okay, I just was trying to figure out, I still like the bill, but anyway, thank you.
I like the bill too. Like I said, I just think there needs to be some tightening up.
And any other questions, members? And hopefully you can get with Mr. Turner's office. And
I do plan to do
Okay,
that,
Okay,
because
thank
it is a good bill. I don't want to kill it. I just
Okay.
oppose it as written.
Okay, thank you very much. Anyone else here to testify for or against or on House Bill 1347? If not, Chair recognizes Representative Turner to close.
Thank you, Mr. Chairman and members. Again, this bill is about trying to protect vulnerable Texans in facilities like an assisted living facility, a group home, a boarding home. And the type of, exploitation we're talking about is what you heard from Officer New, where financial assets are basically appropriated inappropriately. And used for the financial benefit of the proprietor of the facility or the caretaker in the facility. Isolation, we've heard horror stories of people taking away cell phones and other ways to communicate with the outside world. So someone's loved ones do not know what's happening to their elderly parent or grandparent inside that facility. That's what we're trying to crack down on with this measure. So, I
Ms.
appreciate
Jones?
it. Yes, ma'am.
Quick question.
Yes,
Would
ma'am.
this apply to a situation where a senior owns a house, doesn't want to move out of her house? Some people move in and purport to take care of her. Next thing you know, all of her stuff is theirs.
I
This is
I
only
believe
a
it
facility.
would.
So
I believe it
when
would
you said a
address that.
faci-
Yes.
Okay, thank
Yes.
you.
Yes.
Anything else, members? Okay.
Thank you, Mr. Chairman. I appreciate the committee's
And so
favorable
if there's
consideration.
no objection, the chair will leave House Bill 1347 pending for now. See, Ms. Perez, are you? Okay. The chair lays out House Bill 3110 and recognizes Representative Perez.
Thank you, Mr. Chairman, Chairman Smithy, Vice Chair Wu, and members of the committee. Thank you for allowing me to lay out House Bill 3110. This is an identical companion to SB 1498 by Senator Nichols. HB 3110 gives law enforcement the necessary tools to combat financial crimes involving digital currency. Digital currency has become a popular method for money laundering. It is frequently used in contraband sales on the dark web and in scams that target vulnerable elderly victims who are deceived into depositing money into crypto kiosk. In many of these cryptocurrency fraud cases, asset forfeiture is the only way to recover stolen funds. HB 3110 establishes clear definitions and procedures for the forfeiture of digital currency. With us here today, we have Adam Colby, who's the Director and Chief Investigator of the Texas Financial Crimes Intelligence Center, and Thomas Wilson, Assistant District Attorney in Tyler, Texas, to speak in favor of the bill and answer any questions you may have. And with that, Mr. Chairman, I respectfully request the right to close.
Thank you. Ms. Perez, any questions? Mr. Little has a question.
This bill is an expansion of civil asset forfeiture, right?
That's correct.
Okay. As someone who's worked on SEC receivership cases where there is cryptocurrency that's seized, oftentimes there's an inability to access it. It might be on a jump drive or hard drive, and impossible to monetize unless you have the key to open it. Like, do you have a sense, Representative Perez, of what law enforcement obstacles are to turning cryptocurrency into something that's fungible or monetizing it? Or like maybe you've heard from law enforcement agencies about what challenges they face when they get it or encounter it.
I appreciate your question, but that's exactly why I have actual law enforcement, because
Okay.
I'm far from law enforcement, to be able to answer that question.
Thank you so much.
Okay, thanks. Any other questions? Okay, we'll go ahead and call the witnesses. Chair calls Thomas Wilson. Your affirmation shows that your name is Thomas Wilson. You're here on behalf of the Smith County Criminal District Attorney's Office and self. and you're for the bill. Is that correct?
Yes, that's correct, Mr. Chairman, and thank you for being here, Mr. Chairman, members of the committee. My name is Thomas Wilson. I'm the Chief of the Civil Division at the Smith County DA's office, and I'm here to strongly support HB 3110. This bill would clarify Chapter 59 to give prosecutors in the state of Texas the necessary tools to combat digital crimes involving digital currency. Our office has worked with local law enforcement agencies, including our local TAG unit and the Financial Crimes Intelligence Center, and we have seen the firsthand effects of crimes that are facilitated by digital currencies on our community. House Bill 3110 gives our office the ability to seize cryptocurrency and digital currency from criminal enterprises that are that are profiting from narcotics trafficking, theft, fraud, and even human trafficking. Based on the previous and ongoing investigations, we have determined that, or we believe that millions of dollars in cryptocurrency and illicit currency is being gained from those illegal activities. We also know that our victims are local, but the profiteers are not. They're usually out of other states or international criminal organizations. Currently, there is a jurisdictional gap under Chapter 59 that provides that asset forfeitures are to be filed in district courts in the county where the tangible or intangible property or money is seized. Cryptocurrency and digital currency has no location. The servers can be in another state. The servers can be international. They're usually not here. But this bill gives us the authority and the ability to fight the ever-growing cryptocurrency problem, and that continues to allow the procedural due processes and safeguards that are currently in place under Chapter 59 to ensure that the money is not seized inappropriately. And I'd welcome any questions.
Thank you, Mr. Wilson. Any questions? Members? Ms. Jones has a question.
So here's my constitutional concern about civil asset forfeiture. You take the asset, in this case crypto, because you think they did something, right? So they're charged maybe by indictment of some felony. And you have it, it's evidence. And without the need of a conviction, they literally can take your stuff, even if you don't end up getting convicted. So I am concerned that asset forfeiture happens before someone is convicted and not after, because what if I'm exonerated? You've already taken my stuff. And so I've got concerns about that. So are you guys waiting until the adjudication of the matter, or you're taking the money or cryptocurrency before someone is actually convicted? And I get that civil means by preponderance. Again, but the only reason you got the money is because you thought something criminal was going on. So that's my concern.
So under Chapter 59, we have a 30-day window to file our asset forfeiture once it's seized. So we have a very short window to file these cases. So unfortunately, there are times when the asset forfeiture is seized, but the individual is not indicted or the criminal case does not go forward before the asset forfeiture goes forward. So that's the way the legislature, y'all have written the bill, but unfortunately, that's the mechanism that we have right now.
So I mean, I'm just going to say this: if the bill stays like it is, I've got grave concerns that my stuff can be taken unconstitutionally. I literally could be exonerated, and you still took my stuff, and there's no remedy for me. I would feel much better if they could hold it till the criminal case is over, right? If I'm convicted, then take it away. But if I'm not, I mean, is there a mechanism if I'm exonerated for me to get my stuff back that y'all, I mean, I'm putting it in very simple terms. My assets back?
I will tell you what happens in Smith County. I cannot tell you what happens across the state, but usually, or most of the time in Smith County, we will allow the criminal case to go before the asset forfeiture. So we basically put our asset forfeitures on hold, and we will allow that criminal case to go forward if there is a criminal case that comes out of it, that arises out of it.
And another question that goes along with that. So say you file it because you've got a short 30 days, as you said,
Yes.
and it's on hold. Are you proceeding with the criminal case because someone charged with a crime has a constitutional right, Fifth Amendment right to remain silent, and for them to potentially testify in a civil asset forfeiture could affect their ability to exercise their Fifth Amendment rights? Or are you holding off on the entire court proceedings related to the seized assets?
We usually hold off, if there is a contested asset forfeiture, we will usually hold off on moving forward with the asset forfeiture seizure until the criminal case. So yes, we usually do not move forward with it in that sense.
We usually do not. Does that mean sometimes you don't?
Yes, there are some times that we move forward, we move for default judgments as well.
Wow. So maybe if I'm locked up, because I got charged with a crime, and I can't get out, I don't have any money, I can't afford a lawyer, and I get sued to seize my assets, and I just don't have the money to do it because the government took my money. And then a default judgment is filed. See, I'm just like having problems with the Constitution on this, but thank you for answering
Thank you.
my question.
Yes, ma'am.
Okay, any other questions? Oh, Mr. Little?
Mr. Wilson, right now, do you not seize or forfeit cryptocurrency currently?
Currently, we do not. We have not filed a case to seize or forfeit cryptocurrency.
But you want to?
Yes.
How many cryptocurrency seizures do y'all have out Smith County way?
Because of the FCIC, we have a substantial number. They are working tirelessly to combat financial crimes, and they have found that there is a substantial amount of illicit activity that occurs using cryptocurrency or digital currency.
So you do seize them, or you don't seize them, or
We don't seize them under Chapter 59. There are mechanisms that we have worked with our sheriff's department to do turnover orders for situations where fraud occurs, where they know that the cryptocurrency has been, let's say somebody called up their grandmother or claiming to be their grandson and they're in prison somewhere and they need money to get bonded out of jail. And so they will say, if you go to the kiosk and put in $10,000 of cryptocurrency in the kiosk, then we can use that to get bonded out. They fall for that currency, or they fall for that scam, and then we have gone to district courts, in federal district courts, to turn over that money when we can grab it. But that becomes the problem, and that's on the law enforcement piece, is us trying to get that money.
if you seize it in a digital wallet, whether it's a external USB drive, whatever, if you don't have the key, you can't monetize it anyway, right?
I believe that Mr. Colby can answer this question, but I believe there is a mechanism for them to be able to obtain that information. And what we do, and what this bill allows us to do, it allows us to put the money in the funds or the digital currency in a cold wallet. So it basically freezes it. It's an offline wallet that they can't have access to.
I'm familiar with that procedure, but you have to be able to access it first.
Yes.
So are you seizing it in the hands of someone else? It's traded on an exchange?
Mm-hmm. Yes, sir.
Okay. So I'm envisioning a couple scenarios. One, you do a drug bust, there's a USB drive that has cryptocurrency on it that you can't access because you don't have a key. In another scenario, you're seizing it because you know that the perpetrator of the crime or the alleged perpetrator of the crime has essentially an account on a cryptocurrency exchange that you can seize.
Yes.
Am I tracking with you?
Yes.
Okay.
And I would let I think Mr. Colby can better explain this than I can. He is more well-versed in this, and he has traced, and his team has traced numerous transactions on the crypto market from illicit funds.
Okay.
So,
Thank you.
thank you.
Okay, any other questions, members? Okay, thank you for being with us today.
Thank you very much.
The chair calls Adam Colby. Mr. Colby, your affirmation shows that you're Adam Colby, the director of the Texas Financial Crimes Intelligence Center, and testifying on that capacity and on behalf of yourself, and you're neutral on the bill, correct?
That's correct, sir. I'm neutral due to my position as the director. Mr. Chairman, representatives, good afternoon. My name's Adam Colby. Again, I am the Director and Chief Investigator for the Texas Financial Crimes Intelligence Center. I had prepared a script for you or a statement. I'm going to go off of that to try and explain to you what we do and what we're seeing. And I'll tell you that I'm not looking at this from the standpoint of seizing money from narcotics, from somebody that got stopped on a traffic stop. I'm looking at it from the standpoint of organized financial crime, which primarily targets Texas senior citizens. So typically we're talking about fraud where a senior citizen is tricked into depositing through various different means large sums of money into a crypto kiosk, which is just basically a crypto ATM. We get over 100 requests for assistance from various Texas law enforcement agencies a month to try and trace that money through the exchange. It's a matter of time is really what we're talking about. As you said, Representative Little, once it hits that cold wallet, we can't touch it. The only thing we could do then is flag it and hope that it comes back onto the exchange where we can seize it. But what we do know is that by tracing it, we're seeing exactly, if it's $10,000.12, then we are seeing that $10,012 move all the way through the exchange. It's broken up by bots, it's removed, it's sent back into various accounts, it's being hidden, it's structured money laundering until it winds up in a cold wallet. Typically that cold wallet, when you do KYC, know your customer, that cold wallet belongs to somebody on the other side of the globe, not an American citizen. So the only thing that we can do, and what we seek to do at the FCIC, is to claw that money back, to try and get it back for that victim that has lost potentially their life savings. And what tends to happen is that once they fall for it once, they keep going at them until there's nothing left to get out of them. So this really isn't about what you mentioned, Representative Jones. I agree with you. I don't like asset forfeiture. I don't like taking money for the government for the sake of taking money. But what I do like is taking money back when we know it's stolen from a senior citizen and putting it back in their pocket. Thank you very much, sir.
Thank you, Mr. Colby. Any questions, Mr. Little?
Thank you, Mr. Colby. I've worked on many, many cases like this of financial fraud, securities fraud. Oftentimes the proceeds end up as cryptocurrency. They get offshored. When we talk about civil asset forfeiture, normally what I'm thinking about is the district attorney's office filing a lawsuit in Ray, $5,000, bag of cash in a car that was seized in the middle of a drug deal. How does this money get frozen and then recovered by your agency or by a district attorney for purposes of bringing the civil asset forfeiture proceeding? Because it's typically not seized in, as part of an arrest, for example. So if you could just walk me through the mechanics of it, I'd appreciate that.
Sure. So, Representative, typically the way this starts is another agency comes to us, because we don't take reports from the general public. We're here to assist Texas law enforcement. So they come to us and say, we just had a victim who deposited 10 grand into a cryptocurrency and fell for a scheme of some sort. As long as that victim has the receipt and that kiosk gives us certain information that we need, the KYC, so that we know where the money went to which account, then our analysts can very quickly track that money through the exchange. And hopefully, and what we're hoping is that we have found the money before it's been removed from the exchange and goes onto a cold wallet. Once that happens,
Tracing it through pieces of the blockchain?
That's correct, sir.
Okay.
It's a process that only a handful of Texas law enforcement agencies can do. So it's basically us, Secret Service, and probably 2 or 3 other agencies in Texas can do this. It's expensive because it requires specific training, hardware, and software.
Okay.
So, but once we do that, if we find that money, because we're not talking about random money where we found a bank account that might belong to a drug dealer and we don't know for sure if it's clean money mingled with dirty money, we're tracing the exact amount of money from the point that it hit the crypto exchange through that kiosk all the way through the exchange to wherever we stop it. The problem that we have is that while we're doing this for other agencies, so we'll get to that point where we say, okay, it's sitting at this point in an exchange. Now we go back to the agency and say, all right, you're going to have to file paperwork, a subpoena, or asset forfeiture or seizure paperwork, depending on the way this individual exchange works. And each one is different. You're going to have to file that, and you're going to have to do it quick, not so much because the exchange won't cooperate, but because that money's going to move into that cold wallet eventually. So the problem that we run into, and the reason why we've only had a handful of successful seizures, is because on the other end, the mechanics that it takes for that agency to then react, who typically doesn't understand what we're talking about. We typically have to write the go-bys for them, for a subpoena, for the seizure paperwork. It just takes too long. So what this bill seeks to do, really for us anyway, is change venue, because there is no real place where it's seized. It's in the ether of the internet or on that exchange, so that we can do it quickly on behalf of that agency. And the way it works when we do it is we have our own cold wallet where we have agreements with various exchanges. Once we present the correct paperwork, they move it onto our cold wallet.
What are you doing right now without this statute? Like, how does this statute help you any?
The statute allows us to seize it instead of that other agency, because it gives
Us being who? I'm sorry. When you say us, who are you talking about?
the FCI, the Financial Crimes
FCIC.
Intelligence Center.
Okay.
So it's just a matter of speed. That's really what it comes down to. So, XYZ Police Department requests our help. We get to the point where we find the money. It's still on the exchange, but now we tell them, you're going to have to file this paperwork with the exchange. You have to do this, this, and this. There's a series of steps, and we try and lay it out for them as cleanly as possible, but they still then have to do all these things that typically they're not used to doing. They don't know how to do. We kind of have to hold their hand from a distance to get them through it. Whereas if we're the ones that are seizing it on behalf of that agency and the victim, we can do it within an hour.
I'm trying to figure out where in the statute does this empower the FCIC to do it?
It's the change of venue. That's all it is. It's the agency initiating the seizure.
Will you show? Can you tell me where that is in the bill, just so I can understand?
I think it would be easier if Mr. Wilson did that for you, simply because he's the one that wrote it.
Okay. A change of venue from where to where?
Well, I'm sorry, maybe I'm not using, it's not really a change of venue. It's the jurisdiction for the seizure, which currently allows for where the crime occurred or where it's going to be prosecuted. We're just simply adding where the seizure is initiated. For the FCIC, that's the big part.
Okay, so I'm going to say this back to you in terms that I can understand and hope that I'm grasping this. Because cryptocurrency is an asset without really a fixed location, it can't be treated like that in-ray $5,000 of cash, the bag of cash that was found in the back of a car. It's because it's not fixed in a certain place. We have a difficult time acquiring jurisdiction over it.
That's correct, sir.
I hope you're not just saying that because I said it, but I mean,
no, you said exactly.
Okay.
You said exactly what I'm trying to say. Maybe not quite as eloquently, but that's exactly what we're talking about. Is that we don't have the authority to continue that seizure. We can trace that money to a point where another agency can seize it, but until this bill becomes law, we don't have the authority unless it happened in Smith County, because that's where we are located.
Does anyone have the authority over it?
The agency that took the report or is going to basically, within the jurisdiction of where it's going to be prosecuted or where the report is taken.
Okay. I had a situation where I had a client who was a victim of phishing, and he had several $100,000 wired from his bank account to Ohio and then offshore, where it was turned into cryptocurrency. And Secret Service at one point interjected itself and said, we caught some of it. We froze some of it. I didn't know how they did it. I don't really know how they acquired jurisdiction over the money, how they freeze it in place. I was just thankful that they did it. So what you're saying is this will give Smith County the ability to seize and forfeit the asset in a location where the victim is.
That's correct, sir. And any other law enforcement agency that has the ability to do this. I know Houston PD is standing up a crypto unit right now. I believe Dallas PD is doing the same. There's a handful of agencies. It's just it costs a lot of money to buy all of this equipment, the training, hardware, software.
Okay. Thank you for being so patient with me as I try to get this. Thank you.
You're welcome, sir.
What's your staffing like?
Currently 16, sir.
So we have Houston, we have Dallas, who else? Who else is standing up a unit like
Secret
what you do?
Service. you have if you have an agency that has a task force officer, that's a Secret Service task force officer, they'll be able to do it through Secret Service. But as far as I know, there's probably only 3 or 4 agencies. I believe DPS has or is about to stand up a unit, but only a handful of agencies have this ability.
So how many calls you get in a month?
We're around 100 is what we're fielding right now as an average.
Just FCIC?
Yes, so what we're kind of triaging as it comes in because of the amount of time it takes to do this. You know, you only have a very small window to grab that money before it leaves the exchange. So a lot of these cases that are coming to us, 2, 3, 6 months old, there's no hope of recovering that money. So we just tell that agency that, I'm sorry, we can't help you, just because we don't have enough staff to try and trace that money to a point where we can at least see where it left the exchange and try and put a flag it so that if it hits the exchange again, we can grab it. We just don't have the bandwidth to do that.
So wouldn't you agree with me that we just don't have the resources here for most agencies?
Absolutely, sir.
Thank you.
Ms. Jones?
So y'all might be moving me a little bit in the direction. So I guess so I do see that there's a difference, right? The senior citizen has, I don't know, $12,576.32 in her bank, and you see that go. So you can directly link it. And now they're saying, she's saying, somebody in her family saying, they took this like I didn't mean, they tricked me. So I guess my only concern, as Rep. Little said, is not the same as NRA $5,000 because it wasn't seized in the car, in the house, or whatever. But I guess it's put in the section where there's NRA $5,000. So there's really like not a meaningful distinction. So I'm just trying to figure out how to recognize the uniqueness of it and the technology of it and make it available so that it can get stopped before it's gone. Because I still see that where it's placed allows it to be done the other way. And then I just have one other quick question. So you stop it, let's say this, so before this, well, if this bill doesn't get passed right now, you've got to explain it to whatever law enforcement agency is coming to you. They could mess up because they don't know exactly how to do it because they're not used to doing it. And by that time, it may be lost.
Correct.
But with this bill, then you can stop it as soon as you find it and put it in a cold wallet.
In less than an hour.
In less than an hour. So I see the value in that. So once you get it in the cold wallet, what happens to it?
It goes through the normal asset forfeiture process from there.
And are we saying that if we take this kind of money, cryptocurrency, that we can give it back to them immediately? Is that what we're saying now?
That's
Or
not
you
for
don't
me
know?
to say,
You
ma'am.
don't know?
That's for a prosecutor to determine. We're simply just trying to get that money off the exchange, put it into that cold wallet, so that there's at least a chance the victim can get their money back.
And so you just, right now, what are you doing with it? You're just holding, well, since you're not doing it,
Well, what's happening is in a handful of cases, anytime that we see the money still on exchange, we're immediately notifying the agency that brought us the case that, hey, this is where it is, this is what you need to do in order to seize that, because we can't seize it for them. The only thing that we can do for them is that if they get all that asset forfeiture paperwork or the seizure paperwork into place in time, we can store it on our cold wallet for them. But the asset forfeiture hearing will not happen in Smith County. It will happen in whatever jurisdiction it happened in. So the real thing here is just the time that it takes.
so you're just, I get that. So you're holding it until there's a resolution about whether they can take it.
That's correct, ma'am.
Okay, thank you.
Any other questions, members? Thank you for being here.
Thank you, sir.
Is there anyone else here to testify for, against, or on House Bill 3110? The chair seeing none, chair recognizes Ms. Perez to close.
Thank you, Mr. Chairman, members of the committee. Thank you for your time. I would greatly appreciate your favorable consideration. And with that, Mr. Chairman, I close.
Okay. Any other questions for? Oh, yes, Ms. Jones?
I'm going to come to your office and talk to you about some of my concerns. I'd like for this to work, right? I understand the value in it. I'm just concerned about a few things, but I'll come speak with you.
Okay,
All
I'll
right,
get you the
thanks.
answers.
Okay.
Anybody else?
Okay. Thank you very much. If there's no objection, the chair will leave House Bill 3110 pending. And Mr. Bojani, you ready? The chair lays out House Bill 1801 and recognize Representative Bojani.
Thank you, Chairman Smithy and members of the committee for the opportunity to lay out House Bill 1801. HB 1801 seeks to clarify that an investigator authorized by the Commissioner of Insurance under the Insurance Code is an authorized peace officer. Under current law, TDI investigators who may be investigating fraud or arson have to go to an outside law enforcement agency to request access to certain communications and tracking information. As you can imagine, this greatly slows down the investigations and puts unnecessary work on those other law enforcement agencies. It does not expand the powers or duties of peace officers. Rather, it ensures that investigators who are already performing critical investigative work are legally recognized as having the authority to request and use tracking tools, helping to avoid procedural issues and reliance on third parties to seek necessary authorization. This is simply a clarification that aims to promote legal consistency and enhanced coordination among law enforcement entities. This designation is central to determining which law enforcement personnel are legally authorized to access certain communications and tracking data during criminal investigations. These surveillance and tracking tools are typically used by investigators to detect fraud. I believe we have a witness from the Department of Insurance here to further explain the department's use of those tools. At this time, I'd be happy to answer any questions, and I reserve the right to close.
Okay, let me ask you one question. Is this something that TDI has asked for, or where did the idea for the bill come
That's from TDI, that's right.
Okay, all right. Any questions, members? Okay. And I don't have anyone to testify, but I'll call witnesses to see.
Okay, sure, thank you.
Okay. Anyone here to testify for, against, or on House Bill 1801? If not, Ms. Bojani, if you wish to close.
Sure. Thank you, Chairman Smithy and members for the committee. Oops, sorry. Thank you for helping me laying out this bill, and I humbly request your favorable consideration, and I close.
Okay.
If there's any questions? happy
Any
to-
questions? Mr. Louderback?
Representative, tell me what are the status, or what are you looking to do?
So what happens is, let's say there's a Department of Insurance person that's investigating fraud, insurance fraud. So they need, in order to get access to phone records.
Are they civilian? Are they just civilian? They're
No.
civilian investigators?
I think they're not civil investigators. They're trained to investigate fraud in the system.
So what is their status? What are they? Are they any kind of peace officer at all? Are you asking for the committee to expand more law enforcement powers in the state?
Just to request tracking data and mobile devices, so that way they can track fraud much better. Because right now they have to go through certain third-party agencies to request that. This will make the process more efficient, basically. That's what, Department of Insurance also has said.
So just to be clear, you're not asking for them to be peace officers?
We're not asking for peace officers to expand authority in terms of they can go out and arrest people or anything. They can just request information so that way they can get more, they can directly get information.
I don't know that TICO has that. I don't know if TICO has that classification to do
Yeah,
that.
see, right now in the statute, it has like other people that can be peace officers. So it has like 15 people that can be, or so, like sheriff, marshal, ranger, law enforcement officer appointed by certain organization, Department of TICO, I guess. Law enforcement officers appointed by Texas Juvenile Justice System, the investigator commissioned by Attorney General is also part of it, right? And so we're just adding, and then a member of an arson investigating unit commissioned by the municipality, a county, or the state. That is already in the statute. What we're adding is an investigator commissioned by the Commissioner of Insurance under Section 701. That's all we're adding. So that way they can get direct access to data that they need to solve fraud and sort of issues in that, and arson.
Okay, well, TDI they have police right now.
Yeah, I think we have a resource witness. That's what I thought, but maybe they didn't sign up. They said they're registered as well.
Okay, what do we need?
They need to go register on the.
Yeah, I would need to get them to register first outside,
No, it's not showing up.
not testifying.
I'm still not seeing it.
Do you know
It's
the name
still
of the
not-
person?
We're showing.
W. Tyler Hampton, do you see that?
I don't know why it's not showing on mine. Katie, is it showing on yours? I would just ask that they do it again, because
Yeah, I think you did it right, but the problem is it's showing up that we had someone registered neutral, but it doesn't reflect on our witness list. If you could, Katie, if you could help them, the committee will stand east for just a moment. Yes. Well, no, so we'll go ahead and while we're waiting, Ms. Jones has a question.
You want them to be able, you want them to have direct access to what?
To cell phone data
You
and
want-
tracking
you want-
devices.
You want the investigators from TDI, if they think I committed some fraud, to be able to go into my phone and see what's there. Is that what you're asking for?
I'm not sure if they can go directly to your phone. They have to go through some agency or some point of contact. And maybe the TDI witness can talk about that. Yeah.
I don't want TDI or anybody being able to go through my phone without a search warrant. I think it's a violation of the Constitution, but so I will wait until they register
Yeah.
so I can ask them that question.
This could be somebody suspected of arson or committing
I
fraud,
don't,
maybe, yeah.
I'm sorry, respectfully, I don't care what they suspected of.
Yeah.
There's a whole bunch of wrongful convictions, and they think you suspected of something, and they convince people, and you come back and find out they didn't do it. So I really don't think that what you're charged with, even if it's really, really bad, then you get to violate the Constitution because you think they did something really, really bad.
Sure, makes sense.
Okay, thanks.
Ms. Rodriguez-Ramos has a question.
Thank you, Mr. Chairman. This kind of goes back to what Representative Louderback said. Your bill specifically says authorized peace officer means, and then it has a list of rangers, marshals, and then an investigator commissioned by the Commissioner of Insurance. So it appears you are asking them to broaden it and to include one of these investigators as an authorized peace officer.
Right.
That has the ability to track you and to get into your cell phone and all of that. So you are asking for a department investigator, Department of Insurance investigator, to become an authorized peace officer that has access to tracking you and obtaining cell phone data and all of that.
I mean, there are other investigators from like the Attorney General's office or from
Yes,
the
but-
city.
But you're
as well.
asking specifically to include an investigator commissioned by the Commissioner of Insurance as, to have the same authority and power as an authorized peace officer.
Right.
Yeah, okay. Okay, thank you.
Mr. Moody has a
I'll
question.
try to do this as a question answer. Because I'm looking at the cross references in your bill. Section 701, 104, the Commissioner of Insurance can already commission peace officers, is that correct?
I think so, yes.
Yes, okay, so just say yes. They can commission peace officers. The statute that you're touching has to do with certain types of warrants to deploy this type of tracking device, this kind of information. When this was created, certain peace officers, certain agencies could do this, and it had limited scope of what they could do. There are warrants in these situations. There are warrants in these situations, to be clear. These aren't being done without warrants. This is saying, rather than TDI coordinating with one of the enumerated lists there to get a warrant to do this, to investigate something they can already investigate as a commissioned peace officer, they can now seek those warrants on their own. Is that correct?
That's right, yes.
Okay, I just want to clarify. There are warrants in this process. TDI already has commissioned peace officers. They do investigations currently. This is a piece of something they cannot do on their own without collaboration, and I guess TDI can come up and tell me where I'm wrong.
Right.
Your bill would permit them to do it directly, and goes back to your point of efficiency in the
Efficiency,
investigation.
exactly, yeah.
Okay.
As somebody that serves on the DOJ, I felt like this would be an efficiency, bill that would sort of cut out the middleman, but, we can discuss.
Thank you.
Okay.
So we've got the witness now. Chair calls Tyler Hamilton. I'm sorry, Tyler Hampton, excuse me. So you're registered as W. Tyler Hampton, here on behalf of the Texas Department of Insurance, testifying neutral on the bill, correct?
Yes, sir. Yes, sir. I'm Tyler Hampton. I'm a captain with the Texas Department of Insurance. First of all, Mr. Chairman, committee members, thank you for allowing us to come here and.
I apologize for the mix-up. You were signed in, but it just wasn't picking up on the
That's all
other
right. That's all
information.
right. So the TDI fraud unit does employ 24 full-time peace officers, sworn law enforcement, badges, carry guns, arrest powers. We protect the public from economic harm through investigation of and enforcement of a variety of crimes, ranging from insurance fraud, money laundering, organized crime. Despite the fact that we are sworn law enforcement commissioned by state law enforcement agency, fraud unit peace officers are not currently included in the definition of authorized peace officer under Code of Criminal Procedure 18B001. Our exclusion from that list of peace officers authorized to obtain electronic customer data poses a significant challenge to our investigative duties, as most offenses we oversee now involve some element of electronic communications or other online activity. That's everything from insurer, policy application portals, claim submission, email communications, things of that nature. Currently, our investigators have to rely on outside support from other law enforcement agencies as a workaround to obtain the necessary electronic customer data. That can be used to either prove venue, to identify a suspect if all we have is, say, a IP address or something of that nature. This needlessly prolongs investigations and allows criminals to continue victimizing Texas insurance consumers and companies, causing greater economic harm to both. It also creates a burden for assisting agencies' investigators who already have heavy caseloads of their own. The DA's offices are also reluctant at times to assist in providing a grand jury subpoena, which is authorized under the statute, if there's no guarantee that venue will be within their jurisdiction, which we can't always determine without the very information that we're trying to get through the subpoena. The amendment will bring the TDI's fraud unit in line with statutory authority provided to other agencies employing licensed peace officers, including arson investigators, within the TDI State Fire Marshal's office.
I've got a question. Ms. Jones has a question.
So you're saying that your officers are law enforcement officers, but they're excluded under current law?
Yes, ma'am, that's correct. We are recognized as, I believe Representative Moody cited the statute earlier, but the Commissioner of Insurance can commission peace officers. We're sworn law enforcement. Under 18B001, we kind of affectionately refer to it as the laundry list of peace officers specifically who are authorized to obtain the electronic customer data.
So if the commissioner, so if I work for the Department of Insurance, can the commissioner commission me to be a police officer?
Yes, ma'am, she can. There are requirements. You have to hold a TCOL license, obviously go through the, have been through training. We pretty...
You go to an academy or something?
So when in our hiring process, without going into too much detail, we look for a lot of experience specifically in white-collar criminal investigations. So typically we have investigators who have, somewhere...
I'm sorry, I just want to get
Yes,
to the
ma'am.
crux of it. Did you go to a police academy?
Yes,
and you're
ma'am. I
like
was law enforcement for 10 years before I started with TDI.
Right. I'm talking about somebody who's not you. Would I have to be a certified peace officer before I work for TDI? Does the I guess the Department of Insurance, do they have the ability? I start working there and they think I'm really good at what I do, and they can literally certify me as a peace officer.
You would still have to go through the requisite training for a basic peace officer license through TCOL.
Which is what?
Could honestly, as far as like training hours requirements, I don't know that specifically. If you're starting from scratch, you're having to go through a law enforcement academy and graduate.
And before you go into somebody's phone, you got a search warrant first?
Yes, ma'am. You'd have to get a search warrant.
Okay, thank you.
Okay, any other questions? Mr. Little?
Just, Explain it to me like you would a seventh grader. What is it that you want to be able to do that you can't do?
Yes, sir. For us specifically, the benefit would be being able to get subscriber information and information about use of a platform, not the message contents, but just the so name, maybe a payment method, an address, a phone number associated with either an IP address, could be a username from an online application, something that would either help us locate physically where, from where an action was taken, like a false claim submission.
Get it how? Like go to get a grand jury subpoena?
Grand jury subpoena, administrative subpoena. There's some, I believe those.
Hold on, let's press pause here. Administrative subpoena. So you were, let me walk through this slowly. You want to go to a SOA judge, like an administrative judge, and get a subpoena because you're a peace officer?
No, there's, I believe.
Like where do you go when you want to subpoena stuff and you're a TDI peace officer?
For us, currently, the commissioner has subpoena authority under 701.
So you go to the commission?
To the commission, I believe there's a delegation designee contingency in there.
Walk me through it. I want to understand how, if you want to subpoena something, we make you, the legislature passes this bill, you're a peace officer now, you want information that you're going to obtain through subpoena. Walk me through it step by step.
Specifically for the electronic customer data.
Yeah, the stuff that you want.
That would be have if I'm doing it from a line investigator perspective, articulate my reasonable suspicion. We have a subpoena application process that goes through a supervisor review initially, which is my current role, is reviewed through our chief fraud counsel, and then again through the, currently the designee is the chief investigator. It's a deputy commissioner, or associate commissioner, I'm sorry.
You lost me. I want to make sure I understand this.
Sure.
If we pass this bill, you're going to be able to obtain customer data through a subpoena. It's never going to touch a court. It's never going to touch a district attorney or any outside law enforcement agency. Right?
I guess that depends on the, I guess how the other provisions in the statute for the administrative subpoenas would apply. I'm sure we can, it's escaping me at the moment. If we need to get you more information, we absolutely can.
I'm trying to figure out what this does, and I don't do what you do, so I'm trying to understand it. It sounds like to me, to be able to get the information that you want to prosecute insurance fraud or money laundering, you're going to be able to, if you're designated as a peace officer, you're going to be able to get that data without ever touching a court or grand jury or DA or any kind of outside law enforcement agency. You're going to have the power to go get it yourself through your commission, right?
Potentially.
Am I wrong about that? Do you have to go to court?
Under 18B, I think there is an application process, so that I believe that would have to go through a court.
All right. I just want to know for sure. I'm trying to understand what the bill does, so thank you for explaining as best you can.
So let me clear up right quick, a couple things. So they're almost fully certified peace officers, TCOL authority credentialed peace officers, but they lack certain things to do by statute, correct? And you're wanting to go back and try to restore that or get that put in place?
Yes, sir. So if on that list under 18B 001 of authorized peace officers, it lists most every, I believe it's, I know attorney general's investigators, fire marshals, which we have a state fire marshal's office under the TDI umbrella as well. So they're another law enforcement entity within the regulatory agency that has the ability to get that information, but the fraud unit does not. I believe county sheriff's office.
Real quick,
officers.
if you
Yes,
work
sir.
for TDI, you
Yes,
have
sir.
full authority as a Texas peace officer, except under certain things you
Yes,
can't
sir,
do.
under that
All right, thank you.
section.
I just want to make sure I heard what I heard. You could go to TDI, the commission, and they can give you subpoena authority. Is that accurate?
The commissioner has subpoena authority under Chapter 701 of the Insurance Code.
Is that a
use
yes?
Yes, ma'am. We use it for bank records currently.
I'm
other records.
I'm gonna ask these leading just so I can hear up and get to the end of the story quick. So you can go with this law and get somebody in TDI to give you a search warrant to go through my stuff. or your
Not a
mama's
search
stuff.
warrant, no, ma'am. We'd still have to go to a judge for a search warrant. There's a probable cause standard there that's, yeah.
So I can get a subpoena, well, so in criminal stuff, like a DA, maybe the law enforcement agency, like, I don't know, HPD, Collin County Sheriff's Department, they think somebody committed a crime, they actually can go and they can investigate, right? And it's gonna get to a judge or it's gonna get to a DA, right? That makes sense to me.
Sure.
But I think to grant TDI the ability or the equality of a sheriff's department or a police department to be able to go into anybody's stuff, including your daughters or your mothers, without having to go through a district attorney or somebody, I think is problematic because there are just a bunch of opportunities to have access to information that before this bill is passed, you'd have to jump through, for the most part, constitutional barriers.
If I may,
This is to the bill. This is
subpoena is current law. I mean,
This is just putting these
I
TDI under the same.
701.106 is very.
And I don't disagree with there's already a law that says certain peace officers can do this. I'm trying to figure out, when I vote on this bill, there are concerns I have about TDI. And I mean, I don't know why they were left out of it initially, but I'm actually trying to think through this because I didn't know before Rep. Little asked who has the authority to grant you the ability to do these things. And I just think that, and then you also said that you don't get you don't get, I guess, text, but you can get subscriber data. You can get who it is, you want to get where it comes from, I guess, when it came in, what's linked to an IP address. Anyway, all right, you've answered the questions to help me figure out where I am on this.
Thank you, ma'am.
Thank you.
Mr. Hampton, I have one other question. That is, by virtue of asking you to sign another affirmation, you've got two on record. Can the committee clerk have permission to delete your first one?
yes, sir, that's fine with me.
Okay. Any other questions, members? If not, we appreciate you being willing to come up here, Mr. Hampton. Anyone else here to testify for, against, or on House Bill 1801? If not, Chair recognizes Representative Bajani to close.
Thank you, Chairman Smithy. So it seemed like, you all had great questions, but what's already in the law, we're not changing that. These are already peace officers. They already have to go through all the processes to get a warrant, to search all that. Right now, they have to go to another third-party agency to get those records. All we're doing is, or to apply for a warrant, so we're not bypassing the court process. So the courts are still involved, the warrant is still involved if needed. All we're saying is bypass that third-party agency because they themselves are peace officers, right? So it's not like they don't have any training or know how police officers work. Does that make sense?
Mr. Little has a question.
See, I'm confused about that because the bill adds these folks into the definition of authorized peace officers. So you're saying they're already a peace officer. This is adding them into a definition. And I was just trying to suss out through the witnesses, what do they get when we do that for them? And I'm not sure it's totally clear to me still.
So this part of the statute only deals with the law governing installation and use of tracking equipment and access to certain communications. That's what the peace officer is for. Like, for example, if you look at the second last line, it says, a peace officer commissioned under section 37 point something of the education code. That was the last thing that was added to this. This is already law right now, of the education code. Before that is investigating unit commissioned by municipality, a county, or the state. An investigation committee commissioned by the Attorney General. So Attorney General also has officers that are trained and have the certain standards like TCOL. And so all we're doing, like they already have this right to get tracking data. So TDI right now does not have that right to get the tracking data. Whatever the threshold to get the data still remains the same. We're not saying that we're bypassing that, right? So their authority, they already are doing all the stuff, all the investigation, everything. They just have to go to a third party to obtain these tracking records. And what we're saying is, if you can make this process more efficient, they can directly reach out to the people that they're getting this tracking information from. If they need a warrant, they will themselves get the warrant. They will go to the court and get the warrant. So that's not changing, right? Does that make sense?
The thing that I was struggling with is I know how the Attorney General's investigators get the stuff that they want. They've got to go. They've got to either obtain a warrant from a judge, got to get a grand jury subpoena, and I was struggling to suss out with the witness how TDI accomplishes the same thing. Do they go down the same path
They would
that
have
everyone
to.
else does?
By law, they would have to. Do you see my point?
I would think so, but I asked him about that, and it was unclear to me through his answer.
Because there's so many people that probably work at TDI. We can get you that information in writing and send that to your offices, so that way you know exactly what the process would be.
Okay.
Because we're not changing that process. We're
I
just
think if
adding.
we could get a little clarification,
Sure.
between now and
Absolutely.
next
Would
week.
like to.
Well, thank you.
Thank you so much for
All
the
right.
questions. I appreciate it.
The chair needs to recognize that Ms. Bowers is present. Any other questions, members? If not.
Thank you very much, and I close.
If there's no objection, the chair will leave House Bill 1801 pending. Mr. Curry, are you ready? Okay. So the chair will lay out House Bill 4933 and recognize Mr. Curry to explain the bill.
Hi, and good afternoon.
This is a tough committee. You better.
Pardon me?
It's a very tough committee.
Oh, I know. It's not my first time in front of this committee. I'm happy to be here. No, it's not. I've been here before. Mr. Chairman and esteemed members of the Criminal Jurisprudence Committee, I'm pleased to be here today laying out HB 4933 relating to the disposition of a seized weapon belonging to a person who is not prosecuted or convicted for an offense involving the weapon. This was brought to me by a constituent that has never been convicted of anything and actually needed this handled. Under current Texas law, when a weapon is seized in connection with an alleged offense, but no prosecution or conviction occurs, there are specific procedures governing its return, forfeiture, or destruction. A significant number of weapons are seized without resulting in criminal charges, yet procedures may delay or prevent their return to the rightful owner. According to data analyzed by the Texas Tribune, of all people, in many Texas counties, 40 to 50% of property seizures, including firearms, were not accompanied by any criminal charges. The existing process allows law enforcement officials to dispose of unclaimed weapons through public sale, destruction, or forfeiture for official use. Many individuals are unaware of their rights or the process to reclaim seized property, lending to default forfeitures. Nearly 60% of those individuals whose property is seized do not contest the action in court, resulting in automatic forfeiture, often due to lack of awareness or access to legal support. Current statutory procedures delay and complicate the return of firearms to rightful owners, even when no prosecution or conviction occurs, which undermines due process and property rights. Purpose of HB 4933 is to ensure that when no prosecution or conviction occurs or results from the seizure of a weapon, the process for returning that weapon is clear, timely, and fair, reinforcing the individual's right to reclaim property and ensuring confidence in the state's criminal justice system. This bill would require a magistrate to notify in writing a person whose weapon was seized that they are entitled to its return if no prosecution or conviction occurs. that the magistrate order the weapons returned within 60 days of notification upon written request by the owner, and that the weapon cannot be destroyed, sold, or forfeited if not claimed within a certain time frame. These provisions aim to strengthen property rights by preventing the state from permanently seizing firearms from individuals who have not been found guilty of an offense, and increase transparency in the claiming process. Chairman and members, I respectfully ask for your favorable consideration of this bill. I do believe there's a few witnesses here. I will be happy to answer questions after my witnesses go, and I reserve the right to close.
Certainly. Any questions? Okay. Okay.
So it sounds like he's refusing to answer questions.
Yeah, he's refusing. Yeah, you have the right to remain silent if you wish. So the chair calls Stephen Williford. And your affirmation shows your name is Stephen Williford. You're representing Gun Owners of America and Self, and you're for the bill. Is that correct?
That is correct. I am for the bill. For the committee members that do not know, I am the man that ran across the street in Sutherland Springs and engaged an active shooter. And he had on Class 3 body armor, ballistic, bulletproof helmet, and I was barefoot. I engaged that shooter, and I can't see a more cut and dry case where I was justified. I never went to a grand jury, never arrested. My gun was taken for evidence, and I understand that 100%. But it took me 11 months to get my firearm back. And when asked about it, even the Texas Rangers said, "Why do you want the gun back?" Because it was my gun. I built the gun for competition. It's like a tool. A firearm is a tool. And I bet my life on my tool, and I won. And I believe I served my community with it. And for it to be kept from me for 11 months was just a little bit of extended time. It was never used in court for any kind of evidence or anything. I truly believe, and I went to Frisco, Texas. Texas Rangers took me up there, and they awarded me and recognized me. And when I was leaving, that was a thing that they do every year. It's called Riot, Robbery Investigation Texas, and it was like 1,500 officers were there. And when I was leaving, the two men that stopped the Oklahoma shooting at the birthday party at a restaurant, the law enforcement officers that took their guns came up and said, "You don't have your gun back yet?" It was 2 weeks, and we got them their guns back. And Oklahoma had the policy, I guess, that got them their guns back right away. And I waited 11 months for mine.
Okay, let me see if there's any questions. Anybody have any questions? Mr. Little?
Mr. Wilford, I just want to say thank you. You and your carbine saved a lot of people's lives that day.
Thank you.
I'm sorry for the hassle that you've endured. And no Texan should have to endure that. And this is something we ought to be able to easily fix.
Thank you very much, and I don't see why anybody should be against this.
Well, Mr. Louderback?
Mr. Williford, we go back a ways, don't we?
We do.
So I
Great to see you, sir.
Appreciate what you did. Good to see you. Thank you for testifying today.
Thank you.
Glad you were there that day.
Thank you.
Any other questions? If not, we appreciate you being here, Mr. Wilford.
Thank you.
We also have C.J. Grisham. Now, Mr. Grisham, I need to ask you a couple of questions. One, we've got two affirmations for you. One where you're testifying just on behalf of yourself, and the other one where your affirmation says you're testifying on behalf of Texas Gun Rights and Self.
So I found out, yes, it's Texas Gun Rights and myself.
Okay.
When I did the bulk, I think that was included in there, so you can delete the one where it's just self.
Okay, the clerk has your permission to delete the one where you're just testifying on behalf of yourself, correct?
Yes, sir.
Okay.
So my name is CJ Grisham. I'm the lead counsel for Texas Gun Rights, here to testify on behalf of 4933 for the bill. This creates well, first let me explain. This does not change in any way that if you are a prohibited person, this is not going to get you your gun back. If the gun was stolen, this is not going to get you your gun back. If the gun is an illegal type weapon, in other words, automatic or short-barreled rifle, and this does not change that. What this does is all it does is it changes the law where a guy has to hire me to go and get his gun back because a judge refuses to turn it back or the prosecutor refuses to release it when a person has been dismissed, all his charges have been dismissed. One of the reasons I went to law school at 46 years old when I could have been enjoying my retirement is several reasons. I wanted to provide legal services to people who couldn't afford legal services on these little minutia things like expungements and getting people's guns back. Because it's a very expensive thing to have to hire an attorney. And I'm blessed, in a way, that I got blown up in Iraq. I'm 100% disabled because of my back. So I get that income. I've got my retirement income. And my law school was paid for. I have no debt. So I could afford to help people pro bono get their guns back in these kinds of cases. But let me tell you about one story. I've always got a story about these bills. There's a reason. Harris County. I go to Harris County, and I'm doing everything I've got to do, which I've done everywhere else. I file my motion to restore property because all the charges were dismissed against my client. He doesn't have a criminal history. He's not a prohibited person. It's not stolen. I go and I argue my motion to the judge. The judge literally says, "Are you done?" I said, "Yes, Your Honor." And he says, "I don't care. There's no way in hell he's getting his gun back." Now I'm fighting Harris County judges, even though that's what the law says. This makes it much more clear, and you don't even need me. This requires judges just to do what they should be doing anyway. And again, it doesn't change Article 18, 19, Sections 1, 2, and 3 that talk about if it's an illegal weapon or a prohibited person. So I ask that you pass this bill.
Thank you, Mr. Grisham. Any questions, members? Okay. Thank you for being here.
Thank you.
The chair calls Kyle Caruth.
Thank you, Mr. Chairman. Thank you, committee, for having me here today to testify on behalf of 4933. My name is Kyle Caruth, and I am here to testify for House Bill 4933. And I say thank you to Representative Curry for filing this bill. It is something that is needed. Many of you are aware of at least some parts of my situation and story that I went through in my self-defense. And of course, my firearm was in fact taken as evidence that day as well. It took me, of course, I had an attorney engaged from the beginning, and it still took me 6 months to get that firearm back eventually. Of course, again, the same thing with me. I was never arrested, never charged, found that everything that I did was justifiable. And it still took me thousands of dollars in 6 months to reclaim my rightful property. And so I urge all of you to favorably pass this bill on out of committee and move forward. Thank you very much.
Okay, thank you, Mr. Caruth. Any questions? Thank you for being here. So is there anyone else here to testify for, against, or on House Bill 4933? If not, Mr. Chair recognizes Mr. Curry to close.
Need I say more?
Mr. Cook has a question.
Mr. Curry, I definitely like your bill here and like the notification process, but what happens if someone doesn't follow through or respond to the notification process? What do you suppose happens in that situation?
Well, I mean, I think that with the changes in the way again, it's a relatively short set of changes, but I think the way it works is that the person has to be notified within 60 days, under 60 days, and then within 60 days after that, then the magistrate has to order that the weapon be returned.
But if there's not a response to that notification, then what?
Stand by just 1 second, please.
Sure.
That's a great point. I think they're probably there's a section that was deleted out on page 2 of the bill, starting with line 1, going down to line 9, that probably needs to be reevaluated. There should be a way for something to happen if there's no response or if the person is non-responsive. I guess I just didn't realize that was taken out that way.
Okay. Well, I mean, obviously, like I said, I support House Bill 4933, but I want to make sure it's effective and accomplishes the purpose that you're intending. And so, I mean, if you need to work on a committee sub or anything like that, I'm happy to work with you on it.
Yeah, I'd love to do that. I will definitely do that, and I'll get back with you and the committee as well on a substitute for that, because I agree with you. I want to double check that and make sure, but I'm just looking at what's done here, and I want to make sure that there's not another part to the statute that handles it somewhere else as well.
Perfect. Thank you.
Thank you for bringing that up.
Because, I mean, to follow up on Representative Cook, you've got the set where a judge just says, no, you're not getting your gun back. What happens then?
There is another section of the law. Again, I think that kind of goes to, at least this requires the judge to give a notice and then place an order. And they're based on what Representative Cook said, and I don't think he's wrong. There probably needs to be a mechanism for dealing with that. Okay. But then again, if you get into the situation like one of these gentlemen did, where you may have to go before a judge if the judge is just being obstinate about it.
Okay. Ms. Jones?
So I deal with this. I've dealt with this on many, not few occasions. And most times when they seize your gun, they put it in evidence. I mean, fully expecting like a trial maybe. And then the case gets dismissed. And I literally, here's a problem for people who own the guns. They literally have to go hire a lawyer and file a motion to return evidence, right, to them, which is a whole big ordeal because it's just money that they don't have. And so I guess I'm curious about the mechanism. When you say magistrate, right, so when a dismissal happens, normally the DA will file it and the judge of the presiding court will sign the dismissal. Are you saying that is a magistrate the judge is my question, and is the judge on his own motion or the magistrate on his or her own motion has, like maybe, I don't know, have a handout in the court for a case that's dismissed that involves a gun? And then my question would be, how would the judge know there's a gun, right? Most times judges don't know what evidence there is. If the case gets dismissed, they don't know. So I would wonder, how would the judge know?
So Representative Jones, currently under Article 18.19C, it allows for the magistrate. I mean, that's how the law currently works. And I don't know the answer to that question. When it comes to, I just know that requiring the magistrate to do something in this case, I think, is what this bill's trying to do.
I don't disagree
You know
with
of a
that.
better way to do it?
Well, I mean, I'm happy to work with you
I know.
and Rep. Cook about it. What I'm saying is...
Can you say that again? You're happy to work with me and Representative Cook?
I did say that.
Okay, I just...
Don't fall out.
Okay.
But, I mean, guess what I'm saying is, most times the judges don't know what the evidence is. Like, they just don't. And so how does a judge know that? I mean, should the DA have to tell the judge, hey, there's a gun in evidence in this case? So I guess that's a pickle. And then normally a person who owns the gun, at least from what I see, they have to get somebody to file a motion before the court to say, give me, return my gun. That's just supposed to happen. I just wonder logistically how a judge or magistrate is going to know there's a judge in evidence that belongs to somebody.
I don't know if I'm supposed to ask you questions back or not, but to clarify what you're saying, I would imagine that a person that is up on criminal charges or dealing with the possibility of criminal charges either has an attorney that they've hired or a court-appointed attorney, or they could be representing themselves. in which case they are, in one way or another, have the ability to notify the magistrate of what they're wanting. Am I incorrect about that?
So first of all, if there's a lawyer, the person can't talk to the judge. I mean,
I'm
they're not
saying either
supposed.
one of those three. I mean, either they represent themselves or they have a court-appointed lawyer or hired a lawyer.
So,
right?
or yeah, so are you saying that the person whose gun it is, who owns the gun, has to somehow notify the magistrate or the judge through their lawyer?
I would think so. I don't know what you do. I'm assuming if one of your clients was doing this, that you'd be notifying the judge, correct?
My client's like, I want my gun back.
Yeah.
And then I have to, if I'm court appointed, I'm like, dude, you got to hire me for that, right? That's not a part of my
Right.
court appointed representation.
I don't know how you
it's
could clarify
retained-
that any further. I mean,
Well, all I'm saying is, most times, at least in Harris County, they don't even bring the defendants out, right? There's so many people. If the case is dismissed, it's just dismissed. So, and the judges don't know what the evidence is. They generally learn what that is if there's a trial. So if there's not a trial, judges don't know. So that's all I was trying to figure out, the mechanism by which the judge is going to know that there's a judge that there's a gun that needs to be returned to the owner. That's all. But we can figure that out.
okay.
Okay, any other questions? Mr.
Representative
Louderback?
Curry, I know what, I've got the answers on what you need. Just get with me.
Say again?
I have the answers on what you need if you'll get with myself and Representative Cook.
Great, thank you.
Okay.
With that, I close.
Okay.
I close.
And the chair needs to note the presence of Mr. Verdell as well. So if there's no other questions, if there's no objection, members, the chair will leave House Bill House Bill 4933 pending for now. Thank you, Mr. Curry.
Thank you very much.
And the chair would lay out House Bill 4237 and recognize Representative Hayes.
Thank you, Mr. Chairman, members. Texas law provides that criminal cases from justice of the peace courts and municipal courts may be appealed to county courts at law. When these appeals occur, they are generally tried de novo, that is, as a new case. However, sometimes there is a record made if it's a court of record at the lower court. However, there have been significant disagreements across the state regarding what options county courts have before that trial de novo occurs. Some county courts have taken the position that they have the inherent power, when sitting as an appellate court, to rule for or against the plaintiff or the state, remand or dismiss the case appeal from JP court or municipal court. These courts believe that the authority to remand is a fundamental power of any appellate court necessary for efficient case management. Other county courts, however, interpret the law differently, believing that they must treat these cases as if they had originated in their court. These courts will issue warrants or forfeit bonds instead of remanding cases back to the originating court when procedural issues arise. Accordingly, the Texas Center for the Judiciary says that this split in practice is fairly equal across the state. The lack of clarity has created inconsistency in its practices and administrative challenges. For example, in Denton County, at least one justice of the peace has refused to accept cases on remand due to the uncertainty in the law. House Bill 4237 addresses this issue by amending the Code of Criminal Procedure to explicitly clarify that county courts, acting as appellate courts on JP and municipal court criminal matters, do indeed have the power to remand it back to the originating court. Specifically, the bill, number one, amends Article 45A.204 to change must cease to shall cease. And secondly, amends Article 44.17 to add specific language stating that the county court may dismiss a case appealed to the court or remand the case to the justice or municipal court. This simple clarification will ensure consistent practices across Texas courts, promote judicial efficiency, and prevent confusion about the proper handling of these appeals. Thank you, Mr. Chairman and members, and I'll be happy to answer any questions.
So one question that comes to mind is the ultimate disposition of the case, obviously, under this bill, could either be a dismissal or a remand to the justice court. But are those the only options that that you're intending to leave the county court?
No, they can still make a ruling. That is, if they,
Okay.
sometimes there's jurisdictional questions. It's causing the problem, it seems.
Okay.
That is, the municipal court or JP court may have dismissed the case because they don't think they have jurisdiction for whatever reason. So then it gets appealed up, and then the county court would say, yes, you do have jurisdiction, and then remand it back to the other court.
Okay.
But if they have a trial de novo, they can make a ruling on the basis of the evidence to either, since these are normally criminal matters, find the defendant, not guilty, or, find them guilty.
So county court here would include a statutory court as well as the constitutional court, wouldn't it? For instance, a county court at law?
County courts at law.
Okay, all right. In those counties that have county courts at law?
In the
Okay.
counties that have them.
Okay, any questions, members? Okay. We have no witnesses, so let me see if anybody's here to testify. Anyone here to testify for, against, or on House Bill 4237? So there being no one, Chair recognizes Representative Hayes to close.
I'll just close.
Okay, thank you, Mr.
Thank you so
Hayes.
much.
If there's no objection, the chair will leave House Bill 4237 pending for now. Ms. Jones, you want to do yours really quick?
Oh, for sure.
Okay.
Okay.
So the chair recognizes Representative Jones to lay out and explain House Bill 867.
Mr. Chair, members, I'm laying out HB 867 is filed. A committee sub is coming. I'm working with Ledge Council. They haven't gotten it back to me yet. In any case, under current law, prosecutors often dismiss cases without stating a clear reason or use vague terms like "see file" or "in the interests of justice." That prevents people from getting an expunction even when they legally qualify under Article 55.01. A dismissed case can still block jobs, housing, and education. In cases dismissed due to police misconduct, some prosecutors avoid putting that on the record, keeping the misconduct hidden and allowing the officer to avoid internal investigation. HB 867 requires a specific reason for dismissal to be stated on the face of the judgment. If due to police misconduct, that phrase must be included. The misconduct must be referred to the appropriate law enforcement agency, although the referral is not, doesn't have to be on the judgment. Well, I won't talk about the committee substitute. So I'll yield now for any witnesses or reserve the right to close.
Okay, any questions for Ms. Jones? Okay. We'll go ahead and call the witnesses. We have C.J. Grisham. Mr. Grisham still here? Okay. Other than Mr. Grisham, let me go ahead and ask, is there anyone here to testify for, against, or on the bill? We'll give him just a minute if someone can find him. It's a shame to wait all day to testify on a bill and then miss it. Here he is. It's Representative Jones' bill, House Bill 867. And I show you once again as C.J. Grisham testifying on behalf of yourself, and you've indicated that you're in favor of House Bill 867.
Oh, yes.
Is that correct?
Yes, thank you. And this is Ms. Jones's bill. Is she? Oh, there you are. So thank you for bringing up 867. My name is C.J. Grisham. Again, I'm I call it innocent defense attorney. And civil rights attorney. One of the things I like about this bill is right now we have a problem where no matter how wrong a charge is that has been brought against a defendant, the prosecutors don't like to be honest about the reasons for dismissing the case. Because a lot of the cases that I take, it's because the person was falsely arrested, there was no probable cause, there was no reasonable suspicion. They're what I call pop crimes, pissing off the police. And so once you admit to them that, look, you have no case here, this isn't going to go anywhere, please dismiss this, you get the case dismissed, and they call it interest of justice. Well then, if the person's got a civil issue or a civil case, when you go to sue to regain some redress for those civil rights, the state's attorney or whoever their defense attorney is in the civil side will look and go, well, hey, this was only dismissed in the interest of justice. I mean, they didn't dismiss it for a lack of evidence, even though that's exactly what it was. It was a lack of evidence. The person was actually innocent. And this is just a cheap way for prosecutors to get out of bad charges and save face. So what this bill does, I think, is it adds more accountability to our court system. It makes sure that prosecutors are honest about why they're dismissing cases, and therefore defendants, when they have to go and explain themselves to employers or whomever else, they can literally say, instead of this nebulous interest of justice, well, it's because I did nothing wrong. There was no evidence, there was no probable cause, et cetera. So I would ask that that you pass this bill. It's a great bill, and it just puts more accountability on the system. Thank you.
Any questions for Mr. Grisham? Okay, thanks again for being here. And
Thank you.
for
Sorry for the
sitting.
tardiness.
That's okay. Anyone else here to testify for or against or on House Bill 867? Seeing no one, Ms. Jones, if you wish to close.
What he said. And I will say this, that a lot of times, even sometimes when there's not enough, when there's no evidence or there's no probable cause, sometimes you just have prosecutors that just hold on to cases. And they figure out you might beat this rat, but you ain't gonna beat this ride. And there are people that are lawfully entitled to expunctions, but sometimes you have to be able to tell on the face of the judgment of dismissal why the case is being dismissal and why the case is being dismissed. And sometimes you see where it says see file, which is not on the face of the judgment, or like I said before, in the interest of justice. And it denies people the opportunity to wipe these off their records. And let me be clear, people think that if it gets dismissed, that resolves all your problems. It does not. It will still cause you problems accessing housing or getting a job or sometimes scholarships or just other things. So I respectfully request that this be accepted, and I close.
Okay.
No question.
I want your favorable
Mr.
consideration.
Cook has a question for you.
Does somebody have a question?
Yeah, just a quick question. Rep. Jones, do you think this will have any any unintended consequence of less cases being dismissed if you're making this requirement? Like as far as
Actually, I do not believe it'll be more cases dismissed, but if it does, for shame on the DA's office.
no, I said less cases being
Right,
dismissed.
but that's fine, and they can go to court with no evidence, and they'll get whooped, and the person is found not guilty, and then they're automatically entitled to an expunction and everything. I think that we shouldn't have prosecutors that, if they have to put the reasons that they dismiss a case, if they'll stop them from dismissing it, this isn't about justice, it's about something else.
Is it about proving up a civil case as the prior witness testified? Is that the purpose of your bill? I mean, that's what I heard from the witness.
Oh, no. This is about respecting the Constitution. This is about if you are entitled to an expunction, obviously that the legislature believes under certain circumstances, then you're entitled to an expunction. If the expunction statute requires that the reason for the expunction be on the face of the dismissal, then the state should have to put the reason for the dismissal on the face of the dismissal. Otherwise, the state is preventing people, maybe preventing people who are entitled to an expunction from getting them because they won't put it on the face of the dismissal.
Well, I guess I'm taking a step back. I mean, a
Okay.
step before that. I mean, I know your focus, and I understand that your focus of the bill is the expunction, and I guess my question is focused on, in the interest of justice being used as the reason for the dismissal. And so I'm just saying, and I do not practice criminal law. I think I've maybe was in front of a criminal court long ago,
should hire me.
one time. But anyway, I mean, I have seen, in the interest of justice, dismissals, and I'm just saying it seems like that's part of prosecutorial discretion, and I just wanted to see if you thought it would have any chilling effect or, would result in less dismissals if it took something more. Because a lot of times it's, it's in the discretion of the prosecutor to decide whether or not there's sufficient evidence, or there's probably lots of reasons that go into making those types of determinations. And so I just was asking you as an experienced criminal defense lawyer.
I don't think that it should, but I've also had many occasions, not few, where a case was dismissed. The state didn't want to dismiss it, except for they were gonna lose, and they didn't wanna put why they were gonna lose, and they just put in the interest of justice. But what I'm saying is, if you're charged with a case and you can prove that there's no probable cause, right, why shouldn't that be on there? If there's no probable cause, then you're entitled to an expunction. And so I believe that this stops DA's offices from being mean-spirited in some instances. And I think that it actually protects the Constitution, and it just causes district attorneys to be transparent in what they do and why they do it.
Thank you.
Thank you, and I ask for your favorable consideration.
Anything else from Ms. Jones? Okay, if not, the chair will leave House Bill, if there's no objection, the House will leave House Bill 867 pending.
Thank you.
Thank you, Ms. Jones. And until Mr. Moody gets back, it's time for the Cook legislative program here. Okay. Is there, Ms. Bowers? Oh, yeah, let me do Ms. Bowers first. She just has one witness. Okay. And so there's no such. That's the way. Okay. So the chair would recognize Representative Bowers to lay out and explain House Bill 1820.
Thank you, Chairman Smithy and Vice Chair Wu and members of the committee for the opportunity to lay out House Bill 1820. This legislation was developed in response to the unnecessary barriers that individuals face when they have been arrested, but a grand jury has determined that there is insufficient evidence to support probable cause. It addresses the lengthy waiting periods required before these individuals can clear their records, even when they've been no-billed by a grand jury. HB 1820 makes the expunction of arrest records immediately available by adding a fifth condition under which a person is entitled to expunction to the Texas Code of Criminal Procedure. Currently, individuals must wait specific time periods before becoming eligible for expunction of their arrest records, even when a grand jury has already determined there is insufficient evidence to proceed with prosecution. These waiting periods create unnecessary barriers to employment, housing, education, and other opportunities for individuals who a grand jury has already determined not to have sufficient evidence against them. HB 1820 is a needed change so that innocent Texans can move forward with their lives without the stigma and limitations of an arrest record hanging over them after a grand jury has determined there is insufficient evidence to support probable cause. This bill would apply to the expunction of arrest records and files for any criminal offense before, on, or after the effective date. I reserve the right to close, and if the members have any questions, I'm willing to.
Certainly. Any questions for Ms. Bowers? We've got a witness. Okay, we'll call witness.
Thank you.
Chair calls Alan Place. Mr. Place, your record shows that your name is Alan Place. You're representing the Texas Criminal Defense Lawyers Association, and you're registering for the bill.
That's correct, Mr. Chairman. I'll be brief. This bill by Representative Bowers is just a fairness bill that basically says, excuse me, if a grand jury fails to find probable cause, then that person can move forward and basically have their record expunged, of this arrest taken off of the record. So that's all it says, and we think it's sufficient to do what it needs, what she set out to do. That's all we have.
Any questions for Mr. Place? Yes, Mr. Riddell has a question.
Thank you, Chairman. Just so quick understanding here, what we're saying is because they haven't been charged with anything, because they were no-billed in a grand jury, all it's saying is that the fact that they were arrested is removed from the record. Is that correct?
That is all expunction ever does. Basically, it's just removing arrest. Yes, sir.
Okay, roger that. All right, thank you, sir. Appreciate it.
Okay, anything else? Yes, Mr. Louderback.
So thanks, sir, for testifying, but you can be arrested 4 or 5 times and not have probable cause and have that arrest expunged?
If you, in terms of, I don't think it bears on the number of times one has been arrested. In terms of one at a time, if there is an arrest, and this section that she is tracking here talks about time periods, this adds a little bit different twist on it and says if the grand jury has acted on this and has found no probable cause, then you don't have to wait for the time period under that particular section of the expunction law.
Thank you, sir.
Sure.
Okay, any other questions? Okay, thank you, Mr. Place. Is there anyone else here to testify for or against or on House Bill 1820? Seeing none, Representative Bowers, if you want to close.
Yes, sir. Thank you, Mr. Chairman, and thank you, Representatives Verdell and Representative Louderback, for your questions. One, for your clarifying question, and then Representative Louderback for your, I guess, clarifying question as well. I know your concern was with the time period on and repeat offenses.
My concern is that you could have an individual that's having bad behavior, making bad decisions, being arrested multiple times, but for whatever reason the DA doesn't take it, or there's found to be insufficient probable cause, then it automatically be expunged from records that the arrest was ever made. So I think I'm not sure that that's the way we want to go. That makes
Thank you
sense.
for the question. This piece of legislation was filed in previous sessions prior to now, so this isn't the first time that we've brought this before the body.
Mr. Wu?
The section on expunctions is very specific, and it's very, very limited to what can be expunged. It has to be like, this is completely the wrong person, it was a complete mistake, things like that. Things where it's like, they charged you, but there might not have been enough evidence is a different kind of thing. And it's generally excused. I think what her bills is, these are grand juries that have chosen not to indict. I don't think if someone's having multiple cases taken to the grand jury and they're not indicting, that we need to have a talk. I think that's more indicative of something else. So I think this is for people who this is their only time they've ever been taken to the grand jury, and the grand jury come back with nope. And I think, if the grand jury says no, you can't be indicted, that's it. You're done. That charge, right? So.
Okay. Anything, Ms. Jones?
I want to thank you, Rep. Bowers. Let me be clear. In Texas, you can indict a ham sandwich. So, and I very rarely go to the grand jury because in Texas, you can indict a ham sandwich. So if a grand jury looks at all the evidence, and I just want to remind people that in the grand jury, there is no defense lawyer in there. There is the state there saying whatever they want to say about your client or an accused person. So if a grand jury comes back when there's literally no defense by the defense most times, or even if the defense sends in a written statement, if they find that there's no probable cause and it's not them and they no-bill it, you should be able to run immediately and get an expunction. Because I'm going to say for the third time, you can indict a ham sandwich in Texas. And very rarely are there no bills. Very rarely are there no bills. So this is a unicorn. And again, some people may think about it as being mere arrests, but mere arrests with no convictions cause you problems in your life, and they affect your ability to achieve the American dream, to get an apartment, because people presume you got off on a technicality. If the grand jury says you didn't do it, it's not a technicality. It's not. And so thank you for this bill. As a practicing criminal defense lawyer, I think it's needed. I think it's far too difficult for people to get expunctions when they qualify for them.
Thank you.
You're welcome.
Thank you, Representative Jones. And like I said, this isn't the first time this bill has been presented, so I'm grateful that it came across my desk, and I felt like it was worthy of a refile.
Anything else, members? Okay. Mr. Louderback. Oh, Mr. Louderback.
I was just wondering if there's any evidence ever presented in the grand jury. We hear evidence today that there's not any. I just wonder if there is any. Do you think there's any evidence in the grand jury?
I would think so. I would think.
Thank you.
Absolutely.
Ms. Jones?
I know I didn't say that. The state presents evidence in the grand jury, telling the grand jury why they think they should indict you so that you can move forward and the state can prosecute you. So the only people presenting evidence in the grand jury, 9 times out of 10, probably 9.9 times out of 10, is the state.
Right.
And let me be clear, the accused person does not have a right to have a lawyer in the grand jury defending them. The standard is super low, right? It's super low. For the 4th time, you can indict a ham sandwich with no defense. So, and in this case, I mean, there's no defense about the defense, unless you do a grand jury packet, which, let's say I do grand jury packets on the rare occasions that I do present them. But most times they're not granted. They're just not. So I'm going to say for a second time, thank you for bringing this bill.
Thank you. I thought you were going to mention the ham sandwich again, but thank you so much. And thank you all for the dialogue and for the questions. And with that, Mr. Chairman, I close.
Okay, thank you, Ms. Bowers. If there's no objection, members, the chair would leave House Bill 1820 pending for now. At this time, the chair would recognize Representative Moody, Speaker Moody, to lay out and explain House Bill 4629.
Thank you, Mr. Chairman, members. House Bill 4629, do I have the right one?
Yes.
Okay, good. This is just a cleanup bill for jury instructions. In recent years, the legislature has decided that certain offenses should be excluded from parole, which means if you're sentenced to prison for certain kinds of aggravated sexual assault or continuous trafficking of persons or for continuous sexual abuse of a child, illegal reentry, or refusal to comply with the order to return to a foreign nation, current law in Texas is you cannot get parole. You do not have that option. However, we haven't updated the parole instructions that juries get to reflect that. In fact, our statutes require that we give juries parole information. That is just flat out wrong, simply because we haven't updated these instructions to match the rest of the law. House Bill 4629 would fix that by correctly explaining to juries that in these types of cases, that whatever sentence they decide, whatever sentence that they decide on cannot be reduced by parole. So to be clear, this doesn't change any substantive law. These are already offenses that parole doesn't apply to. And the bill doesn't change who can get parole or what kind of sentence a jury can render. This bill is just a cleanup to make sure that juries are actually given correct instructions about what the law is. I'm certainly happy to answer any questions. If not, I'd appreciate the opportunity to close if there's any witnesses.
Sure. Any questions for Mr. Moody? Don't see any, so we do have a witness.
Thank you, sir.
Okay. The chair calls Alan Place again. And Mr. Place, once again, you are registered as Alan Place on behalf of Texas Criminal Defense Lawyers Association for the bill, correct?
That's correct, Mr. Chairman. Thank you, members. Speaker Moody is right. There have been several bills passed by this legislature in recent years that have no parole. And so it just hasn't, the jury charge for parole instruction has not caught up. Currently, you're going to have an instruction for your cases that are quarter. You're going to have your instruction for your cases that are 50%. This is simply an instruction where if in fact there is a case in front of a jury and they are assessing punishment, and if convicted, there's no parole, this simply says, whatever you assess, there's no parole. That's all it does.
Okay. Any questions for Mr. Place? Okay. If not, thanks.
Thank you, Mr.
Thank you
Chairman.
for being here. Anyone else here to testify for, against, or on House Bill 4629? If not, Chair recognizes Representative Moody to close.
Thank you, Mr. Chairman and members. This is my reelect bill, so I really need y'all to dig down deep and get this one right. This is just creating very basic principle, we should give juries accurate information when we charge them with the cases in front of them. If parole isn't eligible, if the charge isn't eligible for parole, then the instruction should probably say that and not say something incongruous to that. So with that, I will close.
Okay, thank you, Mr. Moody. And so if there's no objection from the committee, the chair will leave House Bill 4629 pending. The chair would now recognize Representative Cook to lay out and explain House Bill 3330.
Mr. Chairman, like Speaker Moody, I just have a simple little bill with very few witnesses, if any. I don't know if anyone's here to testify or not, but appreciate the opportunity to lay out House Bill 3330 in all seriousness. Do appreciate the committee's attention. This is a very important bill, and I do not take the filing of House Bill 3330 lightly. I know that this legislature, prior to my being a member of this body, in 2013 passed the Michael Morton Act, and I want to make it very clear that it's not my intent, it's not the intent of this legislation to undo or to attack the Michael Morton Act. I know that not everyone agrees with that, but that's my interpretation and how I feel about House Bill 3330. I think really what this bill does is it really goes to the crux of what happened in the Heath case, and really what I think has happened here as the term the state, quote unquote the state, that term has been blurred with the roles when you talk about prosecutor or law enforcement agencies. They've been lumped in together and are being considered in the same meaning. And I believe that that's one of the primary intentions of House Bill 3330 is to uncouple or decouple those two from one another, in my opinion. As a result of this ambiguity between the definition of the state, the Texas Court of Criminal Appeals in June of 2024, just last summer, held in State v. Heath that a trial court may suppress relevant, incriminating, and inculpatory evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. And I want to just reemphasize that this case stands for that a situation where a prosecutor had no knowledge of the inculpatory evidence of a defendant's guilt, even though there's no knowledge if there's a failure to disclose, according to Heath, there would be suppression would be appropriate. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure, according to the Heath case. Unfortunately, some defense attorneys are now taking advantage of this technicality by not specifically requesting the evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. And so, just stated another way, is lying behind the log. We've all heard that term, and again, I'm not a criminal defense attorney, but that's what I understand is happening in practice following this State versus Heath ruling. And so this, again, House Bill 3330, that's the intent of this bill, is to address that situation where defense attorneys are aware and that the law enforcement agency has the evidence, even though there's no knowledge by the prosecution, and they wait until the time of trial to invoke it, and then, of course, move to have that evidence excluded, which obviously could and would result in dismissals, most likely following this Heath ruling. In my opinion, this gamesmanship undermines the integrity of the trial process and our core principles of justice. And I don't think it's a coincidence that the defense bar is in large part against House Bill 3330 for that reason. They like this opportunity to wait and spring it on after trial has commenced. House Bill 3330 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of inculpatory evidence without a showing of bad faith by the state or any harm to the defense. This bill does not apply to, number one, exculpatory, impeaching, or mitigating evidence benefiting a defendant. Number two, nor does this bill prevent a court from suppressing evidence in case of bad faith by the state. Nor, number three, does this bill does not provide for incurable prejudice to the defense. House Bill 3330 clarifies the definition of the state for discovery purposes, distinguishing the responsibilities of prosecutors from those of law enforcement agencies. Again, that's the primary change in this bill, is decoupling the state with making a distinction between law enforcement agencies and the prosecutors. We all know that they have separate roles and they have separate responsibilities. House Bill 3330 also established new procedures for requesting discovery. It empowers courts to limit overly broad discovery requests and codifies pre-Heath legal standards governing the suppression of evidence. I want to thank the 35 elected county attorneys, district attorneys, and criminal district attorneys who have joined with Senator Huffman and myself by supporting this legislation and urging the necessity of this legislation being passed. And I would be glad to answer any questions, Mr. Chairman, when appropriate. As stated earlier, there are many witnesses here, and I would request, unlike Representative Curry earlier stating that I would defer questions, but I do think it would be more helpful. There are people, obviously, that are much more experienced and qualified to answer these questions and give you, I think, more specific situations. And I think it would make more sense for me to answer questions after those witnesses have testified, but I'll make myself available now or afterwards at the pleasure of the chairman.
Member, any questions? Representative Moody?
Just real quick. Thank you, Chairman Cook. I know you mentioned your layout, prior work, legislature, going back to probably 2013,
Yes,
Michael
sir.
Morton Act. And I know you said it is not your intention to undo the gains of the Michael Morton Act. And so I appreciate that, and I take you at your word. What I do want to do, if it's okay with you, and I've gotten to know Mr. Morton over the years that we worked on stuff. Sometimes we agree on stuff, sometimes we don't. But he couldn't be here today. But he did ask me to give a letter to the committee members, and I think that he's going to send it through the online portal as well, so it's part of the record. I don't want to belabor the point by reading the entire letter. I'll give it to everybody that's here so they can have it, so they know what his position is. He cites two specific sections that he has concerns with, being that definition related to the state, and also he states, and I'll just state it in part, it separates the burden of discovery from being on the state to solely on the attorney representing the state, which could have the effect of reducing the amount of evidence shared between law enforcement and the prosecutor. Number two, it allows the state, through individual prosecutors, to be the gatekeeper of the evidence and decide what is reasonably necessary to the defense. He also says, he goes on to say, while I will leave the more technical arguments to the attorneys who practice in the area, if these two provisions are enacted, they would unwind the protections passed in 2013. And for those of you who weren't here or unfamiliar with Mr. Morton's story, he shared this very brief description. For those of you not familiar with my case, key evidence was withheld from my lawyers. To use the language of the bill, prosecutors determined that key evidence was not reasonably necessary to disclose to the defense. Almost 25 years later, I was exonerated, and the man who murdered my wife was identified when the key evidence was finally disclosed. So I know you stated that you're not trying to turn the clock back on these things, and so I think it's important for his voice to be a part of this conversation as someone who spent 25 years incarcerated for a crime that he didn't commit. And we made some very aggressive changes in this arena to make sure that doesn't happen to anybody else. In fact, the prosecutors in this case in particular, were held to account for what they did. We've changed the law also to address that after that case. And so I'll circulate these to the members so that they have it. And I certainly appreciate all the work that you do on these cases and the attention you pay to wrongful incarceration and making sure that if we're setting up the rules, we set them up in a fair way. So
I appreciate, appreciate that, and I agree with what you said about Mr. Morton with regard to his experiences as well. And I would ask if maybe we could keep a copy of that letter up here so that when people are testifying, if they want to refer to it as well, if that's okay. Otherwise, I would
Any other
request
questions?
an opportunity to close when appropriate.
That's, certainly will. So the chair would call Jenny Andrews. Ms. Andrews, I'm showing you as Jenny Andrews testifying on behalf of Texas Catholic Conference of Bishops against House Bill 3330, correct?
Yes, sir.
Okay.
Good evening. As you said, my name is Jenny Andrews, and I'm testifying today on behalf of the Texas Catholic Conference of Bishops in opposition to HB 3330, which we believe rolls back key provisions of the Michael Morton Act. This act was passed unanimously through both chambers in 2013 as a result of a grave miscarriage of justice in the case of Michael Morton, who was wrongfully convicted and imprisoned for almost 25 years. The Texas bishops support criminal justice reform that provides for compassionate treatment of prisoners, responds to the needs of the victims of crime, and encourages rehabilitation and forgiveness for those reentering society. The strength of our criminal justice system depends on its accuracy, its ability to convict the guilty and to clear the innocent. But we know that wrongful convictions happen. Identifying and understanding the causes of wrongful convictions is critical to maintaining the integrity of our justice system, and every effort must be made to ensure wrongful convictions do not occur. Since 1989, in the United States, 3,659 innocent people have been exonerated after they have spent years in captivity. Thousands more are awaiting exoneration but lack proper representation to achieve justice. It is estimated that 2 to 5% of people in prison are actually innocent. And of those that have been exonerated since 1989, half of the exonerations were cases where the prosecutors had exonerating evidence in their possession at the time of the trial. The gravity of such a miscarriage of justice cannot be overstated. Condemning the innocent makes a mockery of justice. It robs men and women of their dignity, their relationships, time, opportunity, and their personal freedom. Wrongful convictions also endanger the public because locking up an innocent person means that the real culprit walks free. The TCCB's concerns are related to the limitations of the defendant's request for discovery if the court finds that it was unduly broad or burdensome or implicates the security and privacy interests of a victim or witness.
Okay,
And-
let me see if we've got any questions here. Any questions, members? Okay. Ms. Andrews, thank you for being here.
Thank you.
We have Alan Place, who once again, Mr. Place, you registered Alan Place on behalf of Texas Criminal Defense Lawyers Association against the bill.
Thank you, Mr. Chairman. I think you're going to hear a lot of different lawyers today on both sides of this issue. And so in terms of, first, I thought I would try to detail every single passage of the bill. I don't think I'm going to do that. I think what I'd rather do is just point out to the committee real quickly. If you look at A1 of the bill, by changing material to any matter involved in to relevant to any fact or consequence in determining the action, that changes 50 years of case law right off the bat. Okay, that was the law before the Morton Act. Okay, and by adding A2, the only reason to put A2 in the bill is it sets up a process where the state can withhold evidence. That's the only reason for Section A2. Okay, but let me just say, every now and then, this body makes a policy statement. And as Chairman, Speaker Moody said in 2013, this body made a real simple statement. And what it was is that if it's a criminal case in Texas, all the way from unlawful carrying a weapon all the way up to the top, if they bring one against you, the policy of this body that passed out unanimously was, is that the state is going to present the evidence and provide the evidence against you prior to trial, period. That's all it does. And there's nothing, in my opinion, you're going to hear today that's going to change the reason to change that policy statement at all. I'll be glad to take any questions that y'all may have.
Any questions for Mr. Place?
Very briefly.
Yes, Mr. Little.
Mr. Place, thank you for coming to testify today. I've never tried a criminal jury trial. The closest thing I experienced to that was trying the impeachment. And 2 months before the trial in that case, we received 400,000 pages of documents to assess in 60 days. There were documents that were produced on the first day of trial. The documents were still being produced. I can only imagine how terrifying that is, trying to represent someone whose freedom is on the line and documents are being produced at the last minute that you have to assess and then synthesize for someone else's treatment in a trial, right, for a jury's consideration. It has to be quite terrifying. And I think one of the challenges for this committee is, well, do we need to make any changes to the current state of the law? I see in A2 there's a modification that allows the court to limit a defendant's request for discovery if the request is unduly broad or burdensome. I just can't imagine anything more burdensome than having to fight for your freedom based on documents that are coming in at the last second. I mean, how many cases have you been involved in or your membership been involved in where cases are dismissed for the withholding of evidence under the Michael Morton Act? Lots?
I think a dismissal based on the Morton Act, in my opinion, the dismissal on the Heath case was made by a very conservative judge that I've known forever, okay?
Uh-huh.
And basically, what he did is on the fourth jury setting, there were 3 jury settings before the state announced ready. On the fourth one, within a week, they went in there and they found a 911 tape that they basically had all along. The defendant made a motion that it's too late, and the judge agreed. I think judges have independent authority over their dockets long before this case came along, kind of thing. This is not new. But in terms of, I mean, if somebody says today that they filed a Morton motion, it's to get the information, okay? And it is a terrifying thing. I'll tell you up front, I happen to be practicing in an area for 46 years. It's been an open file policy, okay? I've never faced that issue. I mean, when I got out of law school, the DA, here it is. He'd show me. If we couldn't make a deal, we'd try the case. It's not that hard, okay? But since I have been representing this association since 1999, I can tell you there's counties in this state that would not hand over stuff until, even on the death penalty case, until trial. Okay, that's what brought on Morton, among other things. But basically, until there was a soon as practicable requirement, there was no requirement that it had to be done ahead of time. Okay, and so whoever's been the DA in my career back home in Coryell County, there's not a problem, okay? But it is a problem in certain other areas. And that's why the Morton Act came into play with some time limits.
All right, thank you.
Ms. Jones, could you?
Thank you, Mr. Place. To sort of piggyback on what Rep. Little said, what people don't understand is when the state has, let me go back even before that. This country was founded because the government did exactly what they're intended to do in this unwinding of Michael Morton. The government, who has all the resources, literally convicted people because they had all the power, they had the resources to hide evidence, and then it was a little bitty guy going up against the big government with all resources. And so much so that we left England and came over here and did it. So if you believe in the Constitution, then you should believe in the Michael Morton Act. I'm going to say that again. If you believe in the Constitution, you should believe in the Michael Morton Act. And the fact that, I think they said 35 district attorneys and county attorneys have all come together, well, of course, they want the scales to be on their side, even though the Constitution says you state, you government, has to prove beyond a reasonable doubt that somebody did what you said they did, how you said they did it, when you said they did, where they said you did it, beyond a reasonable doubt. So I have issues specifically, and I'd like for you to know that Section 1A1 literally makes the state as a gatekeeper. The state gets to decide whether they think evidence is relevant. I mean, if that is not letting the fox watch the hen house, I swear on my mama, I don't know what is. Really? There isn't a case where I've seen where the state doesn't want a head start. The state doesn't get to get a head start. You don't get to do that, and you don't get to decide what's relevant. And here's what's interesting. For example, with the 911 tape, I can listen to it. Sometimes 911 tapes last for a long time. Sometimes I can tell things. I've got to go get an expert to go back first and make sure it's authentic, right? You can't evaluate what a 911 tape says a week before trial. A week before trial, I'm actually making sure that I've investigated the evidence that I received in time for me to investigate it. Now I've got to go back, shift focus to something else that should have been disclosed a way long time ago, and try to go get investigators or forensic experts or people that can listen and weed out stuff. And I literally could find relevant information in a 911 tape that may not be so obvious from what you're hearing, like with the talking. So people think it's not a big deal. And state, I don't understand why the state is whining because something was suppressed. We've always had motions to suppress. If you hide evidence, your evidence is going to be suppressed. You shouldn't get to use it. There's no such thing as reciprocal discovery. This tries to make reciprocal discovery. You know what that means? The Fifth Amendment of the United States Constitution of the United States of America says, I have a right as a person charged with a crime to remain silent. I don't have to give the state anything. I don't have to prove in trial that I didn't do it. Instead, the state has to prove that I did it beyond a reasonable doubt. So that's one thing that bothers me. The second thing that bothers me is that it allows the state to withhold evidence under Section 1A2. The state, so as a state, under this, if I don't like the judge's ruling, the state gets to say, hey, I object. Then we get to have a hearing where and let me be clear, I have literally had cases that get reset for 2, 3, 4 years because the state shows up and they're not ready for whatever reason. And most times the judges will roll with the state. They just do. I mean, I cannot even state the number of times I've had former prosecutors who are now on the defense side say, dude, I was so much smarter on the state side. The state used to uphold all my objections, and now that I'm on the defense side, I mean, the judge is overruling all of my objections. So there tends to be a benefit of the doubt given to the state when it's not always given to the defense. So the fact that the state gets to challenge a judge's ruling and request a hearing, I think is BS.
I agree. I think
that's BS.
It's a binary choice.
I mean, that's a BS. And as a defense lawyer, I don't get to do that.
Yes, sir.
I mean, please help me understand. I also don't like the state.
Can we move on with the witnesses? Because we've got a bunch of witnesses.
Well, I'm gonna get. I might be able to get it all out with him.
Okay. Well, if you can get
All
it
right. So then I've got a problem with Section 1A when it defines the state narrowly. Right? So it's the state and the investigating agency. First of all, the state relies on the investigating agency to protect me, right? And the state relies on other stuff. If they've got a snitch, right? That's not a state agency. So does that mean that if a snitch is going to be the main witness against my client, that because it's not a state agency, the state doesn't have to turn that over? That's craziness. I also... this whole Heath thing, was this the Court of Criminal Appeals?
Yes.
The 10th Court of,
No,
let me
it-
be
it's-
clear.
It's Court of Criminal Appeals.
Is this the Court of Criminal
Yes.
Appeals? Last time I looked, the Court of Criminal Appeals almost always rules against the defense. Almost always. It's like a conservative court. So if the Court of Criminal Appeals suppressed it, then you know it had to really be bad. This flies in the face of the Constitution of these United States of America, that every time I stand before this body, every time I stand up and I put my hand over my heart. So the road to hell is paved with good intentions. The state needs to do a better job. The state needs to know where they're getting information from and when they're getting information, and they should make sure that the law enforcement agency gives them everything. That ain't my problem. It's not a defendant's problem if the police are hiding information from the state. And what this will do, it will actually encourage law enforcement to hide information from the state and say, trust me, I know I had it. Right? So I just think it is a problem, and I'd be curious, what I've just talked about, do you have those same concerns? If no, then tell me how you're
I do.
different.
I think the Heath decision, it ruled on the facts of the Heath case, okay? And basically, the court made a decision to exclude evidence. It went up on appeal. The matter is still pending in Waco, as I understand it. They still intend on trying Mr. Heath. I mean, it's an old case, but they're going to go forward. And so I think what that decision did, it made a ruling on that particular set of facts. That's why I don't think anything's out of whack, as they say back home, kind of thing.
Any other questions, members? Okay, thank you, Mr. Place.
Thank you, Mr. Chairman Smith.
Oh, Mr. Place, they tell me I didn't make the record clear. You're Alan Place, and you're speaking on behalf of the Texas Criminal Defense Lawyers Association, and you spoke against the bill, correct?
That's correct.
Okay, thank you, sir.
Thanks, sir.
Okay, Brent Ligon?
My speaking notes originally said good morning, but that was at 10:30 this morning. My name is Brett Ligon. I'm here to testify on behalf of our Representative Cook's bill. I am one of the district attorneys on that letter, and frankly, I wouldn't care if I was the only one on that letter. I'd be here supporting that bill.
Let me back you up. Just say, I'm sorry. You're Brett Ligon.
Ligon.
And you have, you're here on behalf of the Montgomery County District Attorney and self, and you're for the bill, correct?
Yes, Your
Okay,
Honor.
thank
Or
you.
yes, sir. May I proceed?
Sorry to interrupt. Go ahead.
Absolutely. So I am one of the ones on that, on the letter, and of course, I have several colleagues here as well. I might be one of the few people that was actually in the room when we were discussing the Michael Morton law. And we all knew what had occurred to Michael Morton was horrible. And no decent prosecutors ever backed off of that. And at the time, we knew that Michael Morton law was not a perfect law. We knew it was something to get out there, and our agency kept saying, it's Via Muerta. It's got to be paid. We'll fix it later on. Now, what Heath says all along, so Heath is a Texas Court of Criminal Appeals case. Justice Newell says several things, and one of which is 3914, which is now referred to as the Michael Morton Act, never set out a remedy for a violation of the Michael Morton Act. There wasn't one, number one. Number two, Justice Newell continues to say, hey, legislature, I want to defer to you, whether it comes to time, whether it comes to remedies. Newell, the justice who decides Heath, says 3914 doesn't have a remedy. This bill sets out a remedy. Newell also says, let's defer to the legislature. He's asking the legislative body, if y'all want to do something different, then do something different. And that's exactly what this bill does. And what this bill does, number one, prevents gamesmanship. Number two, what it says is if evidence that's unknown to the prosecutor is utilized or is not disclosed, then it has to be either prejudicial to the defendant or the prosecutor has to withhold it in ill will, right? There has to be some type of a scienter, is what Newell refers to it.
Okay, any questions, members? Ms. Jones?
Did I just hear you say that this prevents gamesmanship?
Which one?
You just said that this bill prevents gamesmanship. Did I heard you say?
I don't think anything will eliminate the gamesmanship that criminal defense attorneys use oftentimes, whether it's through discovery, whether it's through delay, whether it's through a lot of other remedies. Frankly, I think I've testified in another hearing, I am a former practicing criminal defense attorney. So even though I've been the elected district attorney for 17 years, prior to that, for a decade, I was a criminal defense attorney. And at that point, the oath that I have taken as a prosecutor to seek justice, as a criminal defense attorney, there was no oath. The only oath you take is when you become an attorney. And so the duties as a prosecutor are completely different than the duties as a criminal defense attorney. Whether you want to call it gamesmanship or whether you want to call it strategy, the rules of evidence have been used in such a way to gain an advantage. And so weaponization, yes, of course. Of course it is being used by the defense.
So let me say this. The prosecution has gamesmanship. They hide, right. And if you use the rules of evidence, it's using the rules of evidence. And I actually respectfully take umbrage with the fact that if I keep something out of evidence because the state didn't prove its authenticity or the state withheld it, that's not using gamesmanship. It's following the law, right? And you have the burden. The state has the burden beyond a reasonable doubt. It is not my fault. It is not my client's fault if you don't have your house in order, where the police are whoever's hiding evidence. I've had district attorneys hide evidence, and then when I told the district attorney, "Oh, I'm gonna file a motion to have this case thrown out with prejudice," the DA hurriedly dismissed the case because I found out about evidence that was hidden. So I think there's enough gamesmanship to go around, if that's what you want to call it. But, I mean, this literally, do you disagree with me that this shifts the burden and the state gets to decide what's relevant?
I think that perhaps you've misread the bill, and it's clear that you hadn't read Heath, and that's not a shot at you. On the other hand, Heath, as the original witness testified to, Heath was specific to the facts of that case in Waco, and it was a 911 call. Your second question that you've asked me is, does it shift the burden? Right.
I didn't ask about Heath.
No, it does not shift the burden.
And by the way, I have read Heath.
It does not shift the burden.
What do you mean it doesn't?
You've asked me if it's my opinion. I'm telling you my opinion. It doesn't shift the burden.
It says the attorney representing the state.
Correct.
The attorney representing the state, where did it go? They can file a motion after a hearing at which the applicable counsel for the state and defendant are present that may limit a defendant's request for discovery under this article if the court finds that the request is unduly burdensome or implicates the security and privacy interests of any victim or witness, and the document, item, or information was not shown to be reasonably necessary to the defense. So why does that not shift the burden where the state gets to decide whether they think it's unduly burdensome? If there's a million pages of evidence, that isn't a burden. That's the Constitution. It requires that you turn it over. I mean, me having to go and look at something that you gave last minute is unduly burdensome for me to go try to run down all the rabbit traps that might be in all these documents. Rep. Little talked about, I don't know how many he said, 4,000 documents or, I'm sorry, 400,000 documents that they're getting stuff. That's unduly burdensome, and it flies in the face of the Constitution. So I'm just trying to figure out how you don't see where this shifts the burden and the state gets to decide whether evidence is relevant or not.
Okay. If you
Yes,
want me to
please.
address that, okay. So now that I know where you're talking, so Senate Bill 1124A2 on a motion by the attorney representing the state and after a hearing, which means a court, at which applicable counsel for the state and the defendant are present, the court may limit a defendant's request for discovery under this article. And so when you're saying that the burden is on us or somehow or another we're going to hide it, it's clear that what the state is saying is, hey, judge, this is too much. We have to then go in front of the court, and the court would then say, all right, well, how much is too much? Whether it's a quantitative amount or a qualitative amount, and then the court makes the determination at that point as to whether or not the request is unduly burdensome. And so, for example...
Curious. I was talking about HB 3330. Are you talking about something other than HB 3330?
I'm sorry, that was the Senate bill version.
I need
It's-
HB 3330.
Yes, ma'am. I'm trying to think where that was the Senate version, but I assume that the language is similar. But I would, if I can pass on that one, and
Okay.
somebody else. Thank you, Julian. Thank you.
And I
Jones.
knew your way a long time ago,
Yes,
before you were the elected DA.
Yes, ma'am.
So-
And you know, this is the weird thing about this panel is it's kind of fun. Almost several people in here I consider personal friends that I practice criminal defense law with. There's my original supervisor, Nicole Hodgeclaw, past president of TCDLA. Almost everybody in here, we're all practicing attorneys. These are things that we deal with all the time. However, the rest of this council, the rest of this committee, this is a knife fight. It's actually a pen fight between two people in a dark alley that nobody else is paying attention to. It's just you and I, because it's a discovery issue. And what it does, Heath says, hey, legislature, y'all fix this. Y'all fix this. And they do. And they just set out a set of rules that say, hey, look, if you're going to go to a suppression issue, then the court has to find that the prosecutor had the information, they held it in bad faith, or that it caused prejudice to the defendant. It doesn't affect the Michael Morton Act in the sense that now all of a sudden you talk about the constitutional rights. I was there. Nobody wants what happened to Michael Morton. Like Mr. Pleasance, I practiced when it was an open file policy. You'd come over to court. We'd be in county court 10. You look at the file. And you go, well, I don't think you got it, Brett. We go, all right, well, let's try this thing. Right? I mean, 3914 as written is beautiful, but it was flawed to begin with. And everybody knew it was flawed to begin with.
But 3330 actually does change Michael Morton. It changes things that are required in Michael Morton. It changes it. But I get if you don't want to admit it. And I understand why you're doing it, because
No,
you want the advantage.
What I want is on behalf of victims that if they have evidence that should come before a court, if the prosecutor is not withholding it in bad faith, and if it doesn't prejudice the defendant, then at that point, the court has to make a finding. I'm here for the victims. When you say I want an advantage, we don't even keep, I couldn't tell you how many cases we win and how many cases we lose. What I as a prosecutor, how I evaluate prosecutors is on preparation and presentation. My favorite prosecutor lost 7 in a row. Preparation and presentation, that's something that as a supervisor that I can look at. Hey, did you talk to your witnesses? Did you do all those things? So you say it's a victory for me. My job is to seek justice. A dismissal, to me, is just as good as a conviction, depending on if the facts are warranted. You also have to understand, not have I been a criminal defense attorney, at the very next election, I could be a criminal defense attorney again. I'm willing to operate under these rules because these rules are not unfair.
Well, I'm defending the Constitution
There's no,
and its amendments.
I respect that. I do too. I do too. I love the Constitution. I love the Fourth Amendment, the Fifth Amendment. The Second Amendment is probably one of my favorite.
Any other questions? Members, any other questions? Mr. Little?
District Attorney Ligon, I think you suggested that Representative Jones had perhaps misread the bill. Perhaps I misread it as well. Okay?
Well,
I'm reading, my understanding is this is an amendment to Article 3914, which is the Michael Morton Act. First material change appears on, to me, page 2, striking out material to any matter involved in and replacing it with relevant to any fact of consequence in determining. So let me dovetail my comments to what Representative Jones had said. I won't call it shifting the burden, but what it allows the prosecution to do is make its own determination of what is relevant before producing that information to the defendant. Will you agree with that?
I was looking for your answer.
Yeah, we're at the top of page 2 of the bill. Do you have the bill in front of you?
Yes, sir, I do.
The modification is to insert the language relevant to any fact of consequence in determining
Yes, sir, I see.
the action.
Yes, sir.
And the way I read that as a civil lawyer, I deal with the same terms, relevance, materiality. It's applied pretty uniformly across all areas of legal practice. What's happening is the prosecutor gets to make its own determination of what's relevant before producing that material. Right?
Right, because it currently says material, and this bill changes it to relevant
Right.
because of a case that came out called Watkins versus State.
I'm glad you brought that up because I got that case in front of me. It's 2021 Texas Court of Criminal Appeals case. Let me read to you from it. It says, under Article 3914H, the state has an affirmative duty to disclose any relevant evidence that tends to negate guilt or mitigate punishment, regardless of whether the evidence is material under Brady.
Yes, sir.
So my understanding of this holding in Watkins is state's got to produce it regardless of whether it's material for purposes of exculpatory evidence, right?
Yes, sir. Yes, sir.
Yeah. So when I read the modifications that are expressed in Representative Cook's bill, what I'm seeing is the state gets to decide whether this information is actually relevant to a fact of consequence before deciding to turn it over. Don't you agree?
Yes, sir.
Okay, I got a problem with that. Because to be quite candid with you, D.A. Ligon, I experienced the same thing in my civil cases when I'm seeking information and discovery and the other side says, well, I don't think that's relevant, so I don't have to produce it. Well, that's not the standard for discovery. The standard is whether it's reasonably calculated to lead to the discovery of admissible evidence in a civil case. And that's when we're just talking about money, not somebody's life. So these are the problems that are, these are the problems that surface based on my reading of the bill, which I think I'm reading it correctly, and I think you've confirmed that I do, or I am reading it correctly. Let's just move on to A2 for a second, dealing with the scope of discovery. And my understanding is the district attorney's office is asking the legislature to limit the scope of a defendant's discovery, or at least allow a court to limit the scope of a defendant's discovery, right?
Yes, Your Honor. Oh, yes, sir.
Why do you want to do that?
Because oftentimes the request is nothing more than a
fishing expedition?
Yes.
Okay.
Or not just a fishing expedition, but for example, if the request is, okay, I want every offense report ever generated by every officer in this agency, that would be unduly burdensome, right?
Yeah.
For example, if I've got a criminal trespass case and I'm a defense attorney, and if there is no way to corral the request, then a request that is not specific as to time or date or even remotely connected to it, then every request that the defense would make, now all of a sudden the state would have to comply to, regardless of the scope of it, and regardless if it had anything to do with the case or not, because what it's seeking to do is then put it in front of the court to say, okay, all right, I get it, I understand the argument. You're saying it's a trespass case. You think perhaps the officer's lying. Maybe every offense report that officer generated, but not every offense report that every officer ever generated at any time with this agency. So there has to be a way to corral the overburdensome nature of it.
I'm not sure there does. So in a civil case, I don't have a right to a speedy trial. Some of my cases, it'll take 5-6 years for me to get in front of a jury. In a criminal case, you can be trying that case like that. And of course, you're going to want the galaxy of information that you could possibly get that might help you represent your client. So very big difference there. How many bad guys are walking the street in Moco because you didn't limit their discovery? How many people were you not able to successfully prosecute who you felt like this person committed a crime? If only I had had these changes to the Michael Morton Act.
So you're saying, I'm trying to get to the heart of your question. You're saying is, hey, if I don't get this change done, is it going to affect criminal justice in Montgomery County?
Yeah.
To the degree that evidence is suppressed, then yes. To the degree for a county like Harris County, Dallas, Travis, there's an implication that all the judges are the same. There's an implication that all the judges are working with correct intent. And so when you have a jurisdiction where the judges aren't and they're looking to get out of cases, then all of a sudden you take a case like the way that Heath is and you read it in such a way. I think in Montgomery County we're doing pretty good. I hope that we catch all the offenders. On the other hand, if we're subject to a suppression issue that is not appropriate, there's no prejudice to the defendant, the state was unaware of it, and it was a child sexual assault case, and that kid didn't get a fair shot at trial, I mean, it'd be upsetting.
I'm not talking about hypotheticals. I'm talking about in Montgomery County where you work, where you've been elected. How many bad guys are walking the street that shouldn't be because of a suppression issue, do you think? Can you think of any?
We have evidence suppressed. I'm not sure what you're...
My
If
point
you're
is,
saying, do we lose cases because evidence is suppressed? Rarely.
Yes.
If that's what you're getting
can you
at...
think of one?
Can I think of one off the top of my head? Yes. I can tell you one. We're litigating one right now. It's a pro se defendant, and the judge granted a motion to suppress on, there was a, the drugs were in the court, the physical evidence. The defendant knew that the drugs were his. He knew that he was charged with, and the prosecutor had a picture of the drugs.
Uh-huh.
And the judge decided to grant a mistrial because of a Michael Morton violation,
Yep.
even though the defendant is looking at the drugs. It was the picture of the drugs that are sitting right there that the
was not
judge ruled
disclosed.
to be a violation of Michael Morton, and then granted a mistrial over that particular issue. And so had that been subject to this, hey, there's no prejudice. The defendant knew about it, number one. Number two, there's no ill will on the part of the prosecutor. So there couldn't have been any prejudice to the defendant because it was the picture of the drugs that were sitting right there.
Uh-huh.
Yes, that is annoying to no end. And those prosecutors are facing a bar grievance. Now, I don't know how far it'll go.
Sure.
But yes. Yes.
My suspicion is that for a county like Montgomery that is well-run, your office is well-run, that this is probably a solution in search of a problem. But if we're getting to the heart of the issue, it sounds like you're concerned that other counties, Harris, might perhaps have judges where they're going to go, oh, easy out, suppressed, dismissed, and you're concerned about them exercising their discretion to do that. Is that possible? Is that the heart of the problem?
You know, it's a state bill, and of course it would have an impact in Montgomery County as it would have an impact in any other county. And so as a prosecutor, I also prosecute in every county in the state of Texas in which another elected official recuses himself. And so at this point, I've probably prosecuted in 17 jurisdictions. And so the bill, if it's fair everywhere. And so whether it's a capital murder down in Del Rio, or whether I'm doing human smuggling in Bracketville, or whether I'm putting a sheriff in his own jail in Waxahachie, as a state prosecutor, according to the law now, if somebody's recused, then it has to be another state prosecutor. And I, have pen will travel. And
Yeah.
so the law, if it's applicable everywhere. And so it's not just about justice for Montgomery County. It's not just about justice for victims. It's about an equal application of the law in any jurisdiction.
Yeah. So one of my concerns is this feels like when the statute came into law, the Michael Morton Act, the DA supported that statute, right?
Of course, to the degree that we would like to, there was, heck, everything from reciprocity to it. It was supposed to be a mirror document. 3914 had the exact same discovery rights for the state as it did for the defense. And so, of course, like most bills, for example, the relevant versus material, I don't disagree with you. I don't disagree with you in regards to the relevant versus material. I think that was a committee drafting to try to reconcile it with Watkins.
Okay.
But we'd love to work with you on that issue. I don't think that is an issue that somebody's going to go, oh, if we don't win relevant versus material, take it back to material. It puts us right back where we were. So it's not a fatal issue.
My main concern is that the statute is borderline sacred right now. And there's a good reason for that because of what happened to Michael Morton. And so the pendulum swings. This was a horrible event. We must respond in statute. And then the pendulum swings back, the DAs go, this is really hard, we want to loosen it up. And I think we need to remember why this is here in the first place, that this can have cataclysmic effects on someone's life. And so I think I'm rightful in expressing some skepticism about the movement of the statute. Maybe you disagree.
No, I mean, the statute is sacred as anything that is flawed that you revere because it's a symbol. The statute, but there's a real person, but the statute never had a remedy for a suppression issue. And it's not me saying that, it's Heath saying that. 3914 has never included a provision concerning the remedy for a discovery violation.
And so what should the remedy be, DA Ligon?
Well, I think the remedy should be, at least when it comes to the suppression of evidence, there should be, number one, if it doesn't hurt the defendant first, and secondly, if there's not a showing of bad will by the prosecutor, what this is asking for is a continuance. Or it's asking for a protective order. It's saying, hey, let's get to a reasonable remedy. Ms. Jones said that she couldn't review or if you're in trial and she's like, man, I don't know if I have enough time to review a 911 call. You know, I may argue with that. Sometimes you can, sometimes you can't. Sometimes a 911 call is nothing more substantive than you need to get an officer out here. That can be reviewed fairly quickly. Other times, if it goes into something substantive and all of a sudden it lays out the elements of defense for your client, you may want to go back and investigate it. But what it's saying is, court, before you can suppress that evidence, you should consider the continuation first to give the other side the opportunity to review it before, I'm sorry.
And I will just say, I think you're right about that. Right? I mean, your comments are over the target as far as what I understand the bill to be expressing. These terms are very familiar to me as a civil lawyer.
Right.
Because when you have something that happens late in a civil case, the court turns to the questions of, is there unfair surprise and undue prejudice? And can I cure this with a continuance? We're just talking about money in a civil case. This is very different. You're talking about somebody's freedom.
Absolutely.
And it's hard to imagine getting right up to the edge of a trial where we're literally talking about your freedom. And then you're like, oh, here's a new piece of evidence. The judge just goes, oh, well, you just want a continuance, right? I mean, that's a hard conversation to have at that point.
I
At least it is
understand
to
your
me.
concerns. Yes, sir.
Thank you.
Any questions? Ms. Jones?
Now, you know there's other people behind me. You don't have to
I
get them all out.
understand that, but you
at
said
once.
something. So like even with a 911 call, let's say you give the 911 call 4 years later, right? Some kind of way you figure out you had
Sure.
something, you know you had it. There are people in that 911 call that may not even recall anything now because it's 4 years later. There may be somebody in the 911 call that maybe died that could help my client, except for I don't know that because I didn't get it for 4 years. So, like, things happening at the time they happen, you're just more likely to get more reliable information. You're more likely to track down potential witnesses in that 911 case. So sometimes it's not always obvious when you get it at the last minute that it could lead to something material or something relevant. And therein lies my problem. And I also, again, the state has, I guess, skin in the game, for lack of a better word, in that you have to prove your case beyond a reasonable doubt. And as you said, that you are fighting for the victims, and I respect that, except for justice takes society into account. Justice takes the Constitution into account, and so there's more than just that. So this bill, no matter how well-intentioned, even if it's looking for clarity, actually erodes away Michael Morton, which you said was sacred. I mean, I heard you say that it's almost sacred.
Sacred but flawed. I mean, I was there when it occurred. I was there during the negotiations. I've been there ever since as a practicing either defense attorney or as a prosecutor. And so just because it's something that was necessary at the time didn't mean it was a perfect vehicle. There was every legislator we spoke to at the time that recognized it was not a perfect vehicle and it was going to require it to be amended.
Would you agree with me that if there's a tie in a criminal case it goes to the accused.
Goes to the defense, absolutely. And
Okay.
it should.
Okay, well.
Of course.
If there's a tie and they give me some information last, the tie goes to the defense.
So I was trying to track the language that you're trying to get to with the 911 call, because my first concern was that you were saying, hey, look, if the state holds it, because my response at that point goes, well, the judge has still got to make a determination of probative versus prejudicial, right? So even if it's turned over. And I was trying to follow your train when you were talking about that if it occurred 4 years previous to it, and you just now found about it, there could have been evidence or what have you. And I understand that, but if that evidence, I'm still struggling with the part that dealt with the suppression of the issue. That would be that the tape would, or that the 911 call would be trying to come in, right? And so the prosecutor, if they don't find out about it till 4 years later and they try to disclose it, this prosecutor 6 days before the trial finds out about it. She discloses it. Defense files a motion and an appeals at that point. And so I was trying to overlay or make the comparison between what you were saying about if something happened 4 years before and you didn't discover it, that there could have been evidence that you didn't retrieve, but neither would the state.
But my point is, the state almost always gets the 911 calls. If the state didn't discover the 911 call until 6 days before trial, that's the state's fault. The state didn't do whatever the state was supposed to do to get that information. And if I'm an accused person and I've been waiting for 3 years, 4 years, 5 years to have a trial, a continuance means that I have to wait until whenever it's continued. That's
Sure.
still not fair to the defendant.
Right, and I don't think you and I are arguing about that. I mean, it's justice delayed is justice denied for anyone. I mean, we're talking about a vehicle that Newell asks for, that Heath sets up and asks this legislature to create. And so if the legislature wants to continue to defer to a judge and the judge is saying, hey, we need some insight, 3914 doesn't have a remedy. It doesn't have a remedy.
But
We've got a bunch
Okay.
of witnesses we need to call. We've kind of worn you out, I think.
I've always enjoyed my conversations with Ms. Jones, so.
Any other questions for Mr. Ligon? Okay, appreciate you being here.
Yes, sir, thank you.
Your durability.
Oh.
So the chair would call Troy McKinney. And Mr. McKinney, you've registered on behalf of yourself against the bill. Your name's Troy McKinney. Is all that correct?
That's correct.
Okay.
Some of you know me, some of you don't. I was intimately involved in both the negotiations and the drafting of much of the language that turned into the final Michael Morton Act bill. So much so that at one point I got a call from Senator Ellis's office that said, if the restrictions that are being imposed in this bill are too much, tell me and we will kill it. And my answer was, no, don't kill it. The sky is not falling because of the Heath case. Before the Michael Morton Act, the process we went through for discovery was we filed motions in every case because there was no right to discovery. We filed a motion, we went to the judge. Judges got tired of hearing the same motions over and over and over again. The judges would enter an order. And there were two kinds of judges. Ultimately, there would be judges who would say, if you don't follow my order, I'm going to exclude the evidence. And other judges that would say, no, we're going to find other remedies. That, and then some in the middle who would determine what to do based on the individual facts and circumstances. That's not any different than what's happening now. Heath is not, the sky's not falling because of Heath. Judges have always had discretion to make rulings based on the facts and circumstances of the case. And all Heath said was the facts and circumstances of that case were within the judge's discretion, the same way it was before the Michael Morton Act. I think, with all due respect, Representative Cook, this proposed amendment to this bill kills the Michael Morton Act. But prior to the Michael Morton Act, we could ask for anything we wanted. The judge granted it, we got it. This bill, the way it's drafted right now, limits the state's discovery just to anything in the prosecutor's personal possession or in the law enforcement agency who investigated its possession. If it's not there, we have no right of discovery. That's less than what we had before the Michael Morton Act. I created a list of 15 items off the top of my head, and I'll pass these out, of things that would no longer be subject to discovery in criminal cases. I don't know.
Okay, let me see, just hand it to her. It'll be fine. Any questions, members?
Yeah, I'd like to see, I don't know what he has.
It's a list, the list is 15 different categories of items of evidence that occur in lots of different cases that would no longer be subject to discovery because they're not something that was created by the investigating law enforcement agency or something that was already in the prosecutor's possession.
I'd actually like for you to go down this list because I think it's important for it to be heard by the people that aren't privy to what we have handed out.
The autopsy reports and death investigations by non-law enforcement
And
entities.
can you put this to you? You're sort of tall and it's
Okay.
hard to hear sometimes.
Autopsy reports and death investigations by non-law enforcement entities such as justices of the peace or inquest would no longer be subject to discovery requests to the state. Statements of a complainant related to the offense and the application for crime victim compensation funds would not be subject to disclosure because they weren't in the prosecutor's possession and they weren't in part of law enforcement's investigation. 911 calls, the Heath situation, would no longer be subject to a discovery request. Ambulance, fire department, other governmental records, but not law enforcement first responder records, would no longer be subject. I can't tell you how many times ambulance records or first responder records have become relevant to a case. Those would no longer be subject to discovery because they're not either in the personal possession of the prosecutor, nor are they in the possession of the law enforcement agency that investigated the case. There's a whole list in item 5 of non-law enforcement crime labs, or labs, that conduct investigations and lab analysis. None of that would any longer be subject to discovery under this amended version of the Michael Morton Act, because those are not law enforcement entities, and that's information that's not in the personal possession of the prosecutor. Juvenile cases, where the school district people interview kids and parents in the process, that would no longer be subject to Michael Morton Act disclosure under this statute. Because they're not law enforcement, they're not in the personal possession of the prosecutor. Comptroller sales tax investigations, CPS and adult protective services records, government hospital medical records and psychiatric records, statements and testimony in Title IX proceedings in state schools. I could tell you a story where that mattered. SANE and CAC records, including witness statements that are part of those records, would no longer be subject to discovery. The state could hang on to them and use them for the first time during trial without it ever being disclosed to the defense. TCOL records and personal records on offense reports for officers that did not investigate the case but were involved in the detention or arrest. It's not uncommon for be multiple agencies out there that don't write reports and don't do the investigation. And the last one is extraneous offense evidence that obviously would not be either in the personal possession of the prosecutor, sometimes it might be, or certainly not the law enforcement agency that investigated the case at trial.
There were two you sort of read over, but that you didn't say. TABC administrative regulatory investigations.
Yeah, by way of example.
Is number 7, and then Texas Workforce Commission records.
By way of example, the TABC, anytime, almost any time, there's an accident that involving a death where alcohol is involved, if TABC is notified, which is frequent, and they know where the person had been drinking, TABC goes out and conducts an administrative investigation of the establishment that served the alcohol. They interview witnesses, they produce reports. Those are discoverable now under this version of the House bill and the Senate bill are the same way. That would no longer be discoverable because they're not doing a criminal investigation. They're doing a civil administrative investigation to find out if the establishment should be sanctioned for serving somebody too much alcohol or serving an intoxicated person.
May I ask you another question? In the current version of HB 3330, what specifically, if you've looked, caused you concern?
My biggest concern is the definition of what the state is. The state has always been the state of Texas and all political subdivisions, entities, and agencies under it. That's the definition that was intended in the Michael Morton Act. That goes away with the proposals in this bill because those clearly, there's lots of things that aren't in the possession of the prosecutor or aren't in possession of the law enforcement agency that investigated the case. I can't tell you that nobody ever plays games. That certainly happens. But judges have the same discretion now with the Michael Morton Act that they did before the Michael Morton Act when it came to making a decision about whether to exclude evidence or grant continuance. Before I came up here this morning in another county, I won't say where because it doesn't matter, a 4-year-old sexual assault case that I've been asking for information for the last 4 years. We were set for trial 2 weeks from now, and a week ago, I got a list of 20 some odd different witnesses, none of whom were previously mentioned in any of the discovery I got on that case, not a one. We continued it. That's what should happen. But frankly, if I decided to throw a fit, the judge would have had the discretion to say, you know what, after 4 years, it's too little, too late. There was a case in San Antonio, not my case, somebody else's, where the defense had affirmatively, years earlier, asked for a speedy trial, and some discovery had been requested along with it as well. There had been repeated instances of, oh, we're going to produce it, oh, we're going to produce it. It never was. And finally, it got to the point where the defense lawyer in that case in San Antonio went to the judge and said, so which constitutional right is my client now going to have to give up? Is he going to have to give up his Sixth Amendment right to a speedy trial that he's been begging for the last few years? Or is he going to have to give up his right to get the discovery to defend his case? It's the Hobson's choice. In other contexts, the Supreme Court of the United States has said you can't make people give up one constitutional right to enforce another one. Yet that's exactly what would have happened until that judge had the courage to stand up and say, you know what, I'm going to dismiss this case for speedy trial violations. That dismissal of cases is an exception, not the rule. I have not seen any case, nor do I think a judge has any power to dismiss a case merely for a discovery violation. The judge does have discretion and always has, before the Michael Morton Act, now, although it wouldn't have any discretion afterwards, or very limited discretion afterwards, to exclude evidence when the judge thought it was appropriate. It's not new, but this bill wants to try and take what's been working well for the last decade plus, better than it ever had been before, and decide that because there's a judge here, a judge there, that we don't like the rulings on, let's try and change the whole thing. And that's not the way sausage should be made. The Michael Morton Act, speaking of which, the idea that there's no sanctions in it. The committee substitute, the initial committee substitute that came out had sanctions in it. It was part of the negotiations between prosecutors and defense lawyers in a room in the basement of the Capitol. We spent 4 or 5 hours down there hammering this out. It would have allowed a judge to hold a defense lawyer or a prosecutor in contempt, sends them up to 6 months in jail for failing to comply with the requirements under what was then the draft of the Michael Morton Act. Not surprisingly, neither defense lawyers nor prosecutors were really thrilled about that idea. Yeah, until you're on the losing end of it. It would have, for example, if a defense lawyer, back when reciprocal discovery was still there was a deadline for giving notice of an alibi defense, and if the defense lawyer didn't do it, the judge could find the defense lawyer in contempt. That certainly doesn't further justice, doesn't have anything to do with the person on trial. There could certainly be a way to outline lots of potential options, but ultimately it's still going to come down to a judge's discretion. As a prosecutor said to me today, and these are his words, not mine, there comes a point where the legislative branch needs to let the judicial branch just do their job. His words, not mine. That was an elected DA who told me that today. Michael Morton Act's working well, and isolated instances where a judge decides to exercise discretion to exclude evidence is not cause, is not justification for throwing the baby out the bathwater, which is what would happen if this bill passes.
Rick Little. Yeah, thank you, Chairman. Mr. McKinney, I want to make sure I understand this. You used the phrase in your testimony again, personal possession of the prosecutor, and I think that the source of your concern is the addition of the language attorney representing to the state. Did I read that correctly?
That's correct.
Okay. So you read that very differently than I did. When I was reading it, the way that I read the addition of that language was to essentially quarantine the bad actor attorney, the agent of the district attorney's office, from communicating by contagion all of his bad acts to anyone else who might prosecute the case. But when you read that, you said, I am now quarantining the discovery obligation away from the entire state who might prosecute me. Am I
Correct.
stating that correctly?
You are correct. It limits it only to the obligation being, if the prosecutor has it, if it's in their possession, then and only then do they have to produce it.
Okay. And I heard District Attorney Ligon earlier talk about we need to craft a remedy, I'm looking at the end of this bill, and the remedies are still up to the court's discretion, aren't they? I mean, that's how I read the word may. Court may suppress evidence. The court may grant a continuance. I mean, is that how you read it as well?
That's exactly how I read it. It's still discretionary.
But they've got the discretion now.
I agree.
Right?
Absolutely.
And in any case, civil or criminal, when you violated, the court is weighing the harm. They're weighing the surprise and prejudice on the parties in crafting that remedy or crafting that discretionary remedy, and then the appellate court is reviewing it for an abuse of discretion. Isn't that right in the criminal context too?
Yes, even a higher standard than abuse of discretion, but generally yes.
What's the standard in a criminal case?
If there is any factual basis to support the judge's decision, then the appellate courts are bound to uphold the judge's decision.
It's a pretty dang high standard. Okay.
There has to be evidence to support it.
Thank you.
And no matter what kind of sanctions were put, there would still have to be evidence to support it.
Okay. Thank you, Mr. McKay.
Members, Rep. Cook.
So going back to your discussions from, I guess, 2013, I mean, so if a defense lawyer or a prosecutor were to act in bad faith, you don't think contempt of court should be an available remedy?
My short answer is no, I don't think contempt should be.
Okay, tell me why.
Because we don't, absent more than just.
I said if the court makes a finding that, not you, but Attorney X, if the judge makes a finding that the attorney has acted in bad faith, you do not believe that contempt of court should be within the judge's discretion?
I think there has to be more than just that for a judge to find somebody in contempt, a defense lawyer or prosecutor. I think there has to be more than that. It has to in some way. I can conceive of a situation where a judge could do that currently. I think it would be a rare exception where that actually happened.
Would it also be rare for, like, this list that you gave here, would it be rare for, for a prosecutor not to have a 911 tape in his or her file?
It would be uncommon for them not to have it.
Okay, so that's, this seems to me to be like a misrepresentation. Maybe it's not.
How
but
so?
What I understood from you to say is that you would no longer be able to get this information. So I just can't imagine a prosecutor would have a 911 tape available and it not be in his or her file just so that they could, quote unquote, hide it. That's what you're saying, right?
No, what I'm saying is the prosecutors would no longer, if I write out a list, and let's say all 15 of these applied to my case, which would never happen, but if all 15 did, the prosecutor could now say, you know what, I don't have any of this stuff. There may be some other state agency, some other.
But let's just hone in on 911 calls and autopsy reports. You think that that a prosecutor is not going to have those types of, let's say it's a murder situation, and there's been an autopsy performed, and you just made the representation to to this committee that autopsy reports are no longer discoverable. That's what I understood you to say.
They're not discoverable from the prosecutor, yes. I tried a case in December where the prosecutor had the autopsy report and never produced it to me. I got it otherwise. I didn't raise any issues about it because it really didn't matter in the case.
But did you ask for it?
I did. I asked for the autopsy. Okay. It was a manslaughter case, and I did ask for the autopsy. It never got produced, but it didn't matter to the case.
And I have the same disadvantage that Representative Little has. I'm a civil lawyer, not a criminal lawyer. So y'all wouldn't file a motion. Is there not the equivalent of a motion to compel or something like that?
Could I have done that? Yes. I did not do it because frankly it would have been just a waste of paper because I was able to get it otherwise on my own.
Somebody's life's at risk? I mean, it seems like you would avail.
No, lawfully. There were some parts of it I could not get without a court order, but there are autopsy reports are generally public records.
So on the case that you talked about earlier, where you said that, I believe you said it was a sexual assault case. It's been pending for a long time. So, and you just got notified of some, was it witness list, things like that?
Yes, witness list plus some other things, yes.
So if that becomes, and we'll make it a hypothetical, but if that becomes a situation where it would be impractical or impossible for you to properly prepare for trial, what would be your remedy? What would you go ask the judge for?
Then I think I would go back to the judge and say exclude evidence. I didn't do that today. We continued the case. The case was frankly probably going to be continued anyways because we were still well down the trial docket. So the suggestion, do some lawyers on both sides play games? Absolutely. That is not the common thing.
What's not common?
Playing games.
Okay. So, I mean, would a continuance, I mean, you said that's basically what happened, but
Yeah.
I mean, would that be a remedy that you would also, I mean, if you weren't successful on a suppression or excluding, would a continuance be the next choice, I guess?
I think it's the other way around. I think the default option generally is that a judge, if a continuance will cure the problem, that's what a judge should generally do to begin with. But if a situation arises, I'll just give you an example. This wasn't a trial, it was a hearing. But in the middle of a hearing, I had a prosecutor, I guess it was 21, 22 during the pandemic, actually try and offer an affidavit from Toll Road Authority into evidence that they had had for over a month based on the date on it that they had never given to me. In the middle of this hearing, I said, time out, Judge, this has never been produced to me. And the judge didn't miss a beat and said it hadn't been produced, it wasn't coming in for other reasons anyways. The judge said, hadn't been produced, it's not coming in as evidence. They'd had it for a month and had never turned it over.
Do you agree with the earlier comments that, I believe it was Judge Newell, I mean, the prior district attorney, Montgomery County district attorney said that he felt like Judge Newell was asking for a remedy. Do you agree with that?
I think Judge Newell was saying that if the legislature wants specific remedies, then the legislature has to do that. Short of that, the judge is going to have a great deal of discretion to fashion the remedy they think is appropriate. And if the judge makes a ruling that is not appropriate, both the state and the defense have remedies to that.
But I'm asking you, I mean, in your reading of the Heath case, do you believe that Judge Newell was asking the legislature to take action in this regard?
Honestly, it's been a while since I've read it, and I don't know that I could answer that truthfully without rereading it. I don't know. It's a short answer. Okay.
Any other questions, members? No, thank you for being here, Mr. McKinney. We appreciate it.
Thank you all for having me. Always happy to be here. And I hope it's another 10 years before I have to come back.
And Briscoe Kane, one of our House members, said that he taught you everything you know about criminal law. Is that correct?
He was a runner in our office before he went to law school.
The chair calls Anna Vasquez. And you are Anna Vasquez, Director of Outreach for Innocence Project of Texas, testifying and on behalf of yourself, correct?
That's correct.
And you're against the bill.
Correct.
Go ahead.
Thank you, Chairman and members of the committee. We've been talking a lot about the Michael Morton Act, and I am in opposition of that. I am here as the Director of Outreach for the Innocence Project of Texas, but I also am the President for the Innocence Network Executive Board. But before that, myself and my 3 friends spent many years behind bars for a crime that never occurred. In total, out of the 4 of us, we served over 50 years. And the one thing that we don't talk about is, I know that we're trying to get things right and do things the right way, and I don't believe that we are trying to do something the wrong way. I just don't think that we are discussing it as much as we should be. So what I want to share with you, because you're going to hear from the other attorneys, I want to share with you the effects of those wrongful convictions. The fact of, spending 13 years of my life in prison. It started at the young age of 19. At 19 years old, we should start life. We should be enjoying life, having dreams, going to college, fulfilling those dreams. And at the young age of 19, my name was ruined. Going to prison, I lost family members, spent many years watching behind bars, parents, grandparents dying, children growing up, and I'll never get that back. So I firmly, humbly, respectfully ask you to oppose this bill.
Okay.
Thank you.
Thank you, Ms. Vasquez. Any questions, members? We certainly appreciate you being here. The chair calls Amy Waddle, Assistant District Attorney. You registered as on behalf of Montgomery County District Attorney's Office and yourself, Amy Waddle, and you are for the bill, correct?
Yes, sir. Thank you, Mr. Chairman, members. My name is Amy Waddle. I'm an Assistant District Attorney in Montgomery County, Texas, where I am the Chief of our Appellate Division. I want to begin by briefly addressing this issue of relevance. That's not what this bill is about. This bill is about restoring the requirement of rational remedies for discovery issues or errors that happen. The change to relevance in subsection A1 is literally just a codification of what the law already is, because courts have already interpreted the word material in current subsection A to mean relevant. So by codifying that, it is not giving prosecutors any additional power to unilaterally decide what is or is not relevant. In fact, the bill specifically requires that if prosecutors believe something that has been requested is not relevant and discoverable, they have to go to the court and get the court to decide that dispute at a hearing where both sides are represented and get to make their case for why this is or isn't relevant and discoverable. And that subsection is specifically geared towards situations involving voluminous, like scientific evidence, laboratories, where we're seeing defense requests for just a myriad of things that don't reasonably relate to the issue on trial, and it's just it's bogging us down. And then what we're seeing as a result of Heath is instead of moving to exclude the whatever piece of evidence or item, not even evidence necessarily, was not disclosed, they're moving to exclude the entire witness's testimony, regardless of whether that testimony was actually affected by whatever document they requested that might be theoretically relevant that was not disclosed. So the change in subsection A, though, is not what this is about. This is not about limiting defendants' discovery rights. It's about limiting trial courts' power to punish the community for inadvertent and harmless discovery violations. We've heard a lot about situations where a discovery violation actually affected the defendant, but this is not what this is about. This bill would still allow trial courts in a situation where the defense was actually prejudiced by a late disclosure to consider exclusion as a remedy.
Let me see if there's any questions. Any questions for Ms. Waddle? We appreciate you being here.
Thank you.
Chair calls Gary Udishin.
Thank you. I'm Gary Udishin.
And Mr. Udishin, your affirmation shows that you're here on behalf of the Innocence Project of Texas and yourself.
That's correct.
And you're against the bill, correct?
That's right. And I'll just make a few brief comments because I think Representative Jones and Representative Little have covered it. What's wrong with this bill already. I'll just tell you that I am a criminal defense attorney in Dallas. I've been practicing for 45 years. For the last 18 years, I've been a board member and a volunteer attorney with the Innocence Project of Texas. I have been involved in about 30 exonerations in the state of Texas. I was doing this work before the Michael Morton Act. I'm doing it now, and I can tell you with certainty that there are fewer innocent people being convicted now than were being convicted 10, 20, 30 years ago for a lot of reasons, but one of those reasons is the Michael Morton Act. One of those reasons is defendants getting discovery when they should get it and having the opportunity to actually defend a case on a level playing field. And what this bill appears to do is to say there's something wrong with that. that we're giving too much discovery to defendants, and we need to go back to the way it was before. And I can tell you from my personal experience that if we do that, there's going to be some innocent people who are going to be convicted because the legislature went back. And with that, I would just ask you not to do that.
Any questions for Mr. Udish? Yes. Ms. Rodriguez Ramos.
Thank you, Mr. Udishin. So I practice civil, and this is new for me. So it appears to me, and let me know what your thoughts are, that the Michael Morton Act essentially simplified the process and made everything more efficient in terms of hand over what you have and we just exchange information. It seems to me this complicates a little more, allowing each prosecutor to decide what information they wanted to produce. It seems that would make it difficult for the district attorney's office to really control all of this if each prosecutor is deciding what is relevant to any fact or consequence in determining and handing over the information. Is that how you read it as well?
That's exactly right. Before the Michael Morton Act, every prosecutor created their own standards for what they were going to give the defense in discovery. We would go sit down in front of a prosecutor, and they would flip through their file and say, okay, I'm going to give you this. Oh, I'm not going to give you this. I'll give you this. And they just got to decide for themselves. This bill takes us, it doesn't take us all the way back, but it takes us about half of the way back. And I have not, the Heath thing, the Heath issue is a totally separate issue from the provisions of this bill that directly undermine the Michael Morton Act. Frankly, this is two bills in one, because part of the bill deals with Heath, and part of the bill is a direct attack on the Michael Morton Act. So it's really just a question of, do we think in Texas defendants are getting too much discovery? I mean, do we think we need to give more power to the prosecutors to decide what defendants should get? Because back when I started practicing in 1980, for about the first 30 years of my practice, that's the way it worked. We only got what prosecutors wanted to give us. And that was a direct cause of a lot of the wrongful convictions and people that are sitting in this room today and people all over the state. And nobody has given us any reason why the Michael Morton Act isn't working as intended to try to ensure we don't have wrongful convictions.
So you as a defense attorney or representing individuals from the Innocence Project from this point on or post Michael Morton, no matter, I mean, we're licensed to practice all over the state of Texas. So this allows you to, wherever county you're going to represent any individual, there's a consistent standard and expectations and what the prosecutor is going to deliver to you and what you all are going to exchange. Prior to that, it just depended if you knew what county you were in, if you knew the prosecutor and what mood they were in that day.
That's exactly right.
Yeah.
It even varied from prosecutor to prosecutor in the Dallas County District Attorney's Office. This prosecutor was willing to give us more than the prosecutor next door. It was all just very random. And that really, I mean, you know, you heard from Anna, you're going to hear from Richard Miles. There are people who were wrongfully convicted and went to prison who would not have had the Michael Morton Act been into effect. And these provisions that are proposed, they're going to create wrongful convictions. And that should be enough to cause us pause before we go down that road.
Thank you, sir. I appreciate it.
Thank you, ma'am.
Ms. Jones?
Is there anything that you want to say that we haven't asked you?
I don't think so. And I think, Ms. Jones, I think you and Mr. Little, y'all covered it. I mean, there's nothing else anybody needs to say. Y'all covered it.
They're very thorough.
All right. Thank you.
Thank you, Mr. Udish. I appreciate you being here. The chair calls Burke Butler. And Ms. Butler, you've registered as Burke Butler, Executive Director, and you're testifying on behalf of Texas Defender Service, and you're against the bill. Is that correct?
That's correct.
Thank you.
I agree with the concerns that have been raised already, so I just will make a few points. First, this was a common sense law. In 2013, the Michael Morton Act was introduced to widespread bipartisan support. In a Republican majority legislature, this bill passed both chambers unanimously and was signed into law by Governor Perry just 2 days later, with Michael Morton himself standing by the governor's side. The governor said at that time, "This is a major victory for integrity and fairness in our judicial system. We are known as a law and order state," he said. "But with that tradition comes a very powerful responsibility to make sure our judicial process is transparent and is as open as humanly possible." In that spirit of transparency, this act ensures that every defendant will have access to all the evidence relevant to his guilt or innocence. Prosecutorial misconduct, including withholding key exculpatory evidence, is a leading cause of wrongful convictions in the United States, and the only way to effectively avoid wrongful convictions and protect the innocent is to give the defendant access to the same information the prosecution has. HB 3330 would gut the Michael Morton Act to its core. His case was a tragedy that didn't need to happen. Our justice system must focus on accuracy and integrity, not obtaining a conviction at all costs. Thank you.
Thank you, Ms. Butler. Any questions? Appreciate you being here. Chair calls Mike Ware. Mr. Ware, it's good to see you. You've registered as Mike Ware. You're Executive Director, and you're testifying on behalf of the Innocence Project of Texas and yourself against the bill, correct?
That's correct. Good evening. My name is Mike Ware. I'm here on behalf of the Innocence Project of Texas, and we are against House Bill 3330. I co-founded the Innocence Project of Texas back in 2006. And since that time, we have freed 40 Texans who were wrongfully convicted and imprisoned. Texas, in fact, leads all states in exonerations. This past year, once again, Texas had more exonerations in 2024 than any other state, with 27. Unlike Michael Morton, most of these exonerees are people you've never heard of, in cases you've never heard of. I agree, and so without repeating what has already been said, I agree with everything Representative Jones has talked about, everything Representative Little has talked about, and maybe most importantly, what Michael Morton himself so succinctly stated in his written statement. You know, I don't think, and I don't want the prosecutors deciding what is relevant to my case. I don't want them deciding, you know, what's important to me. They don't know my case. And I should get all of the evidence, and then I should marshal the evidence, and I should be able to present my case the way it best represents, I can best represent my client. We are in a position when we have these exonerations to analyze the causes of the wrongful convictions to begin with, and not turning over all the evidence. You know, in hindsight, we've studied these cases, is a major cause of these wrongful convictions and a major cause of these innocent people being wrongfully convicted and imprisoned for crimes they didn't do. In the Michael Morton case, you know, it was a well-publicized, tragic wrongful conviction, and they, you know, the people studied that case. There was a court of inquiry, an involved court of inquiry with high-powered lawyers conducting it. And one of the things we do is we try to identify the causes and rectify the causes of these wrongful convictions. That was done in the Michael Morton case, and they came up with the Michael Morton Act. And to roll back the Michael Morton Act, which is what this 3330 does, is going to cause more people more innocent Texans to be wrongfully convicted and sent to prison for crimes they did not commit.
Thank you.
We think that's a problem, and for that reason, we are against it.
Okay. Any questions for Mr. Ware? Thank you for being here.
You're welcome.
Chair calls Bay Scoggin. Have you registered as Bay Scoggin with the Innocence Project against the bill, correct?
That's correct. Thank you, Chair. Appreciate the opportunity to be here. I just wanted to, I'll be as brief as possible and not try and repeat what's already been very thoroughly discussed. I wanted to say thank you to the members of the committee for such an engaging discussion and for being here so late. Also, just have to absolutely thank the exonerees and their families for being here today. They've been here all day just for their 2 minutes to come and tell their stories, which is always, I think, a challenge. And that, I hope, speaks to how important it is that this bill stay where it currently is. The last thing, I have two final pieces to add. The one is I have also read the Heath decision, and based on my reading, there is nowhere that the Texas Criminal Court of Appeals or any appellate court encourages the legislature to take that action. It says very clearly that if the legislature desires that change, it certainly can make that change, but in no place does that encouragement gets made. And the second piece is, the only piece of the bill that I don't think that has been thoroughly discussed is the addition of a specificity requirement for discovery. As defense attorneys, or even in post-conviction, we don't always know what exactly we are looking for because we don't have a theory of the case. So to create a requirement for specificity before we know what we're looking for is hiding the needle in the haystack for us to ask for the right needle and make sure it's the right color too. So for that reason, I will stop and thank you again for your deep consideration of this bill. Thank you.
Thank you. Any questions? Ms. Jones?
So I'm glad you brought that up because I was going to bring that up. You actually, as a defense lawyer, if you would agree with me, we don't always know what's relevant. We might not even know what's important. Like we will have a bunch of evidence and we don't know why it's important because we hadn't been able to investigate everything. And then after we investigate further, we'll be like, oh, no wonder this either makes my case or it doesn't. Sometimes when we get the evidence, I have to go to my client and be like, dude, you maybe need to let me work a deal out for you. So it may actually encourage pleas, especially when your clients are lying to you, right? And then you're like, no, sir, that's not going to happen.
Right.
So thank you for bringing that up. And I'll also say that why shouldn't the defense get the evidence the state has? And I mean, why do they get to know stuff and we don't? At the end of the day, you give us both the same evidence, state, you better figure out how to convict somebody beyond a reasonable doubt. And hiding the ball isn't one of them. Why are you afraid for us to have the information that you have, which is probably why Michael Morton, that act happened, and it's probably why Governor Rick Perry, who's a Republican, newsflash, I'm not, said what he said, because it's a common sense, bipartisan bill that erred on the side of protecting the Constitution and understanding that the government has the burden of proving it beyond a reasonable doubt. So I thank you for coming, and I also, too, want to thank the exonerees for coming, because one person that's wrongfully convicted is too many.
Yes, ma'am.
Absolutely. Ms. Rodriguez-Ramos.
Thank you, Mr. Chair. The specificity you're talking about is line 16 on page 1, where the state, they have to receive a timely and specific written request from the defendant on any. Okay.
Yes, ma'am.
Thank you. I think that is cause for concern as well. Thank you. Appreciate it.
Okay. Any other questions? Thank you for being here,
Thank
Mr.
you, Chair.
Scoggin. Appreciate it. Chair calls Joe Patton. Mr. Patton, you've registered as Joe Patton on behalf of the Dallas County Public Defender's Office and yourself against the bill, correct?
Yes.
Thank you, sir.
Thank you for your time this evening. I'm going to defer to the wisdom of my colleagues, my brothers and sisters who are opposed to this. And I appreciate the questioning from the committee, especially pointing out the concerns about potentially hiding evidence under the guise of irrelevancy and the consequences of that. But I wanted to focus on, as a trial attorney in Dallas, some of the other collateral consequences of this. The language, and as you just pointed out, that's been inserted in this bill means that as a trial attorney, we are going to have to go to war on every single piece of evidence that the state gets caught on, whether, if it gets past the relevancy part, we have to ask a judge or litigate whether the request was specific enough, whether it was prompt enough, which goes to one of the points you raised earlier about the timeliness of the disclosure of all the documents you got. Under this current bill, the prosecutors can now say, well, perhaps they should have known about it before. There's other evidence that was there to indicate this is there. Their request for additional discovery was not prompt, even though the disclosure was late. Again, the question of relevancy, the prosecutor's interpretation of that versus the courts and the defense attorneys. What is going to be a fact of consequence in a case? What is the purpose of this action? What is unduly broad? What is unduly burdensome? What is a privacy interest? What is a security interest? What is reasonably necessary? What is actual prejudice? Are we going to start redefining what a party means in criminal justice and trial? The issues regarding remedial alternatives, whether they've been exhausted. And finally, the inclusion of the language knowingly in regards to whether a prosecutor acted knowingly or not provides so much protection for the prosecutors in situations where they have failed to disclose evidence. And I would urge you, and I request respectfully, that you reject HB 3330.
Thank you, Ms. Patton. Any questions? Thank you for being here. Chair calls Richard Miles. And your affirmation shows you as Richard Miles and the founder, CEO of an organization, but it doesn't say which organization.
Miles of Freedom, that's my nonprofit organization.
Okay, so are you just testifying
Testifying
on behalf of yourself?
Yes, sir.
Okay, that'll be fine, and you're against the bill, correct?
Yes, sir.
Thank you, sir.
All right, to this esteemed panel, I would like to extend my gratitude for the opportunity to share a portion of my story as well as my stance in opposition to HB 3330. My name is Richard Miles, and I'm a husband, I'm a father, and I'm the founder and president of Miles of Freedom, but I'm also a Dallas exoneree. May 15, 1994, at the age of 19, I was wrongfully arrested. 17 months later, August of 1995, falsely convicted of murder and attempted murder. I was given a total of 60 years in the Texas Department of Criminal Justice. After my direct appeal was denied in 2000, the filing of my writ of habeas corpus fell on the shoulders of myself and my father. With the assistance of my dad, who passed 6 months before my release, we obtained my police records, in which, through a Freedom of Information Act, because we could not afford my transcripts. We found nothing of importance in those police records, but I filed my writ anyway, and it was denied in 2002. In 2007, Centurion Innocence Organization accepted my case, purchased and sent my transcripts and police records. It was within these police records purchased by Centurion that we found 3 pieces of exculpatory evidence in the police files recorded before my trial but never introduced as evidence, and I add was not disclosed with our Freedom of Information requests. This apparent Brady violation began the ball that would ultimately provide not only my release but also my freedom. HB 3330 seeks to roll back the structural framework of the Michael Morton Act, which could inevitably impede upon the pursuit of justice. I lost 15 years of my life. I will never know why the evidence wasn't submitted or if prosecutors felt the evidence was relevant but not material. But I can share my story and ensure those convicted or guilty victims receive due justice, and no innocent person is incarcerated in prison.
Thank you very much, Mr. Miles. We certainly appreciate your story.
Thank you.
And I think Ms. Jones has a question for you.
Yes, so first of all, I want to thank you for persevering, and I'm thankful that you got somebody who believed in you and actually paid for what you couldn't afford to pay.
Yes, sir.
I just want, if you can, in like a minute or less, What did you lose in the 15 years that you were locked up?
What did I lose in the 15 years outside of my physical family members? I lost who I was. I oftentimes say May 15, 1994, Richard Ray Miles Jr. died. I was going to Skyline High School, headed to TSTC to study engineering. That ended May 15th. Who I am today is subsequent of what I've been through.
Thank you.
And I will say this, I think I visited with you before, I've met with a number of exonerees. The thing that amazes me more than anything is the lack of bitterness that's there.
Yes, sir.
I'd probably be pretty bitter over the circumstance, but it's not only a lack of bitterness, but the kind of the drive to try to help others that were in your position. So
Yes,
we
sir.
all appreciate that, what you do.
Thank you.
Anything
Thank you.
else, members? Thank you for being here,
Appreciate you.
Mr. Miles. The chair calls Sean Dick. And Mr. Dick, I show you on your affirmation as representing the Williamson County District Attorney and yourself. You're the District Attorney in Williamson County, correct?
I am, Mr. Chair.
And you're for the bill, correct?
I am.
Okay, thank you.
My name is Sean Dick, and I'm the District Attorney of Williamson County. My practice has been, I started off in the Harris County DA's office as an assistant DA. I worked there about 5 years. I moved to Williamson County as an assistant DA for roughly 4 to 5 years. And then I went into private practice and fought in Williamson County against a closed file system. And I was a defense lawyer for 11 years before becoming the DA. I'm mindful that I'm the Williamson County DA coming here to talk about a modification to the Michael Morton Act. I'm also mindful that every other DA in Williamson County since the 80s has gone to jail. I joke that I'm in the off cycle, but it's not really that funny, right? Because we have had prosecutors do some bad things. And so I embrace the Michael Morton Act. I think that it was a good change. It was a good paradigm shift. But we're not talking about the 80s and 90s anymore. You heard Mr. Udishin tell you that this isn't the issue that it was before. But what didn't happen, and the problem I'm trying to solve, is twofold. First of all, something that has changed in the last 10 years is the volume of information. So Representative Little, when I hear you talk about your civil case and getting, or your criminal case and getting 400,000 documents, that's what our prosecutors are starting to face. The difference is my prosecutors have 500 cases a year that they're working on, 500 felonies a year. And now, just to give you an example, this is just the log, the Michael Morton log for one of our homicides. It contains 11,500 pieces of digital evidence. Might be a 3-hour video, might be a 20-minute audio, might be a 50-page offense report, but 11,500 pieces of evidence that I want to give the defense. So this is something we feel very strongly about, and we need a way to make sure we're never going to fight over the 11,500 pieces. Usually the fight is over the things that aren't contained here. My second issue, and I really want to focus the committee on A2, O, P, and Q. Those are the problems that really need to be addressed. And one of the reasons is we had a former elected judge in our county that comes back and visits from time to time. And recently we had a child abuse case where the prosecutor discovered that the police had actually taken the defendant's phone at the time of the offense, but no one had ever done a search warrant. So as the case got set for trial and she's got all this evidence to look through, she realizes we need to do a search warrant. So it's the defendant's phone. He knows there's a search warrant being done. And about a month out of trial, the police found child porn on the phone. And not only did they find child porn, they actually found pictures of the children that were victims in our abuse case. And the judge, basically, based on the Heath decision, suppressed it. Not only did he suppress that inculpatory evidence, but he also granted a continuance. So instead of granting a continuance, giving everyone the opportunity to review the evidence, the judge used the Heath decision as a basis to suppress inculpatory evidence in a child abuse case. So that's what I'm thankful to Representative Cook for filing this bill, because those are the kinds of issues we're trying to address.
Okay, we appreciate your being here. Ms. Jones, you have a question?
I'm trying to figure out why you chose to be the elected DA And kudos to you, and I hope you don't go to jail like those before you.
I ask myself that same
But
question often.
I can't see bending the Constitution because you have that for one homicide.
Right.
I mean, it's like, not at all trying to be disrespectful. It's like, oh, please feel sorry for us because there's a whole bunch of stuff and we may not have enough money. And so you need to just give us, please let us admit it.
Sure.
Right. So
Sure.
to he who has all the power to lock everybody up
Sure.
comes great obligations and responsibilities. And one of those is, I don't care how many documents you have, even if they're 400,000, you need to do it.
Correct. And
Right?
we
So
have no qualms doing it. The issue becomes, my prosecutors often say their job is really just a discovery clerk. They're not lawyers anymore. They can't really go to trial because they have to read through all of this evidence themselves. They have to figure out, is there anything else out there? And like I said, we don't have fights over what we actually have and give over, and we give over everything we can possibly get our hands on. The fight is usually over something like, Montgomery County DA Ligon said, it's, we want every police report that's ever been filed by this Texas Ranger. We want every, medical report that this doctor's ever reviewed. So at some point, there has to be a way to have a balancing test in court, and you have to have the judge hear both sides. And the judge could say the same thing you're saying, which is, I don't care, you're the state, go get it. And that's fine. But right now, there's no provision, there's no findings a judge has to make, and we can't appeal it, we can't have any discussion. Like in the suppression issue, all this is doing is saying the judge has to make some findings based on some parameters that you all set. That's it. And if we lost the evidence because it took us too long to find the cell phone, then we lost it. But right now, we don't have a remedy as the state because there's no process or procedure written into the statute.
Actually, I would respectfully disagree. You actually do have a remedy. Your DA could have looked at the evidence and looked in the phone. So the fact that for whatever reason.
Well, we can't look in it without the search warrant, so the search warrant had to be done.
Right, but if your DA knows, because you know what's in evidence.
Right.
If your DA knows that there's a phone in evidence, your DA should have looked. Your DA should have got a search warrant, and they should have looked in it. So, I'm just.
And this bill doesn't stop that, because if you were the judge, you could still suppress it. You just have to make the findings that are in the statute. You could say that it was highly prejudicial to the defendant.
But why?
And therefore.
We have something that's worked. The Michael Morton Act has shown that there's less wrongful convictions. And just because now the Michael Morton Act requires y'all to actually do your job, now it's like, oh, it's really hard. And I feel sorry for the Constitution being trampled on and set back. And I feel sorry for people who are entitled to constitutional rights to be made less important because it's more difficult for the state. And I'm just going to have to respectfully.
Yeah. I don't think the first part of the bill is really the crux of it for us. I think it's really those last sections that are the important part. And I understand. I understand we have good colleagues out here that have a differing opinion.
Any other questions, members?
I would just ask you to expand on those a little bit, if you could. Thank you, Mr. Chairman.
Sorry, if you could.
Yeah, as far as you pointed out a couple specific provisions in the bill, and I believe you said paragraph O and P, is that right?
Yes. So A2 provides for a hearing where we could say, the defense has asked us to go get additional information, that we don't have it in our file, the police departments don't have it, but the defense has asked us to go get additional information, and we can go to the judge and say, Judge, they're asking us to get this. Is this something that the court's going to require us to go get because of the following factors? And so that's A2, and I have it on page 2. And then provisions O, P, and Q on page 4 going to page 5. That basically, O is really hard to contest because it's just asking for a discovery hearing for everybody to talk and get together in a court and make sure everybody has everything. And what P says is a judge can grant a lot of things. I mean, they could say, we're going to give a continuance and we're going to let the defendant out on a bond that they can make because you gave us this evidence too late. They could grant protective orders. But before a judge could suppress inculpatory evidence, the judge would have to make a finding under Q that either we knowingly withheld this information or the violation caused actual prejudice to a party other than remedial alternatives have been, and other remedial alternatives have been exhausted or would not suffice to cure the prejudice. So that's just some standards that a judge looks at. They make a ruling, and this is what judges are trained to do. Judges are asking for this kind of guidance because they really don't know right now how to handle violations of the Michael Morton Act. You know, we've had it on the opposite side. We've had defense lawyers that have actually provided copies of material that aren't authorized under the statute, and they've given it to witnesses, copies of it. What's the remedy for that? We're not coming in here asking to sanction defense lawyers and punish defense lawyers. We're just asking to provide some fairness to the state in this process and allow a judge to make some determinations throughout this process. I hope that answered your question.
Yeah, I think so. I mean, and specifically talking about OP and Q, do you feel like if those provisions are enacted, that those trample on the Michael Morton Act? Or?
I do not in the least.
Okay, thank you.
Any other questions? Okay, thank you for being here,
Thank you.
Mr. Dick. The chair calls David Gonzalez. And Mr. Gonzalez, your affirmation shows that you're David Gonzalez testifying on behalf of the Texas Criminal Defense Lawyers Association and yourself, and you're against the bill, correct?
Yes, sir. Representative Cook, if I can pick up with your conversation about Newell and what the remedy is. For those that are civil lawyers, I think Newell talks a lot about what it means to practice in civil court, in his opinion, and I'll read portions of it because I think it wasn't a big deal for those that practice civil law. I don't think Heath had that opinion because here's what he writes. Notably, under the civil rules, exclusion of evidence that was not timely disclosed is the default. And he goes through spoliation and all the kind of remedies that typically happens, and it doesn't require bad faith. He just says that's what we do in the civil rules. Even inadvertent failures to disclose evidence results in these sanctions. And he says here, look, the trial court has broad discretion, and we don't think that what the trial court did is any different than what we see every day in the civil capacity. And if you look at the Michael Morton Act, a lot of it was kind of based on the 194 automatic disclosures that we stole from civil lawyers. Here are just the things that we're going to ask you for. You don't have to have specificity. Everybody just exchanges these at the beginning. And it was this idea that no longer do lawyers have to go through 40,000 pages. It's just a default to production. And then the defense has to go through it. Finally, I'll just comment related to the OP and Q. I think what you're hearing a lot of complaints are really related to A2 to begin with, which is this new carve-out that you don't have anywhere in civil rules. In A2, that basically says if someone says, I've got a privacy interest of any victim or witness, like I don't want my statement to be disclosed. God, in civil cases, you can't stop that disclosure, but now I don't have to produce the things that I don't want to produce if it says that. As to the other things, I think a lot of that the trial court has discretion on to begin with, but that's what I wanted to address just related to how I read Justice Newell's or Judge Newell's opinion. Thank you, sir.
Okay, thank you, Mr. Gonzalez. Any questions, members? Thank you for being here. Chair calls Brian Middleton. And Mr. Middleton, welcome. Your affirmation shows you Brian Middleton, District Attorney for Fort Bend County.
Yeah, that is correct, sir.
Okay. And you're neutral on the bill.
I am.
Okay.
This morning I think I had real strong opinion, and I admit I'm a bit exhausted right now. But just 6 years ago, I was a defense attorney, and the importance and the value of the Michael Morton Act is still relevant to me. I practiced law before the Michael Morton Act and after the Michael Morton Act, so I know the difference that it made in our practice. And to be clear, no matter what this committee does with this bill or the legislature does with it, it's not going to change how we practice law in Fort Bend County at the DA's office. The expectation is to win or lose on full disclosure. We have pre-indictment discovery, so this is not in any way going to change how we do business, and I think that's what justice requires. And you're right, Representative Jones, you know, we had the Constitution, and I don't think even passing this is going to change the Constitution. So our obligations under the Constitution will remain. So listening, I've learned a lot. I even had some of my colleagues call after my testimony before the Senate, and we discussed some things, and there are some issues with A1 and A2, which is why I'm neutral on the bill. But I agree with Sean Dick that there are some guardrails in here, particularly O, P, and Q, which I think are fair. What we're not discussing is how this shows up. The way this is going to show up in court, there's going to be a motion and there's going to be a claim that you, prosecutor, failed to turn over some evidence. And so when I read the Heath opinion, it gave me heartburn because I accept the responsibility as the state that in its broadest definition, as Heath claimed. But I have supervision over prosecutors, staff, and investigators. I don't have supervision over police agencies and other agencies. So when they certify to our office that they've turned over everything, I don't have a means of verifying that. And so to think that myself or one of my prosecutors could be in a court found to have failed to turn over evidence without some finding that there was some bad faith is problematic. These accusations, I mean, they're traumatic for some prosecutors, but they can follow them in their careers, and that could lead to grievances. So I support the bill as it relates to O, P, and Q. As to A1, I think some of the concern is what we all know is what some judges may do with this type of language, and that's bad faith, either by the judges or the prosecutors. So I think it's a good start, and I think maybe we should look at some revisions to A1 and A2.
Okay. Any questions, members? Thank you for being here.
Thank you.
Milton. We have Jeremy Kaplan-Lyman. Jeremy Kaplan-Lyman. We'll show Jeremy Kaplan-Lyman as registering for himself, testifying for himself, registered against the bill. C.J. Grisham, is Mr. Grisham still here? We'll show C.J. Grisham on behalf of himself, registered neutral on the bill. We have the chair calls John Rayleigh. Thank you, Mr. Rayleigh.
Yes, sir.
And your affirmation is that you are John Rayleigh testifying on behalf of yourself, and you were the Mr. Morton's pro bono attorney for his exoneration, I understand, and you're against the bill.
I am, sir.
Okay, thank you, sir.
I'm John Rayleigh. I was Michael Morton's pro bono exoneration counsel for 7 years. Michael's wife, Christine, was murdered by a burglar when he was at work. For 7 years, we fought against the then DA of Williamson County to obtain DNA testing on a bloody bandana found near the murder scene. During that time, we sent a FOIA request to the DA to obtain the file. They objected, even though the murder was 23 years ago, saying it was an ongoing investigation and they wouldn't have to turn it over. Then Attorney General Greg Abbott disagreed with them and ordered it turned over. We found evidence concealed from the defense at the time of trial, including an eyewitness account of the murderer being someone other than the accused, and sightings of a stranger in a green van parked behind the Morton house that we now know was driven by the murderer. After our 7-year fight, the DNA results exonerated Michael Morton and led to a positive identification of his wife's murderer, a man named Mark Allen Norwood, who had a 30-year record of felonies in 3 states. Michael's request when he was freed was we try to find a way to keep this from happening to other innocent people. So we asked some great minds to get involved, and the legislation was drafted. The key is that the prosecutor cannot be the gatekeeper of evidence. An honest prosecutor, like my late father and like my brother, like so many prosecutors we know, will follow the law, and that's a good thing. But a morally weak prosecutor, like the then prosecutor of Williamson County, may yield to the temptation to conceal evidence, which is what happened. And the defense lawyer, lacking psychic power, would have no way of knowing whether or not the evidence was concealed prior to the Michael Morton Act. And you see what happened, and I'll close with this and answer any questions. If you convict an innocent man, you're letting the murderer go free to kill again, which is exactly what happened in the Michael Morton case. They concealed the evidence of his innocence. They let Mark Allen Norwood go free. And within a couple of years, right here in Austin, Texas, he killed another young mother in exactly the same way he killed Christine Morton. So that's why this is so serious. I urge you, in the name of justice, which I believe God cares a great deal about, to oppose changing the Michael Morton Act. Now, I would answer any questions if you have any.
Thank you, Mr. Raley. Any questions, members? Ms. Jones?
Just one thing. I want to thank you for representing Michael Morton for 7 years for free.
Yes, ma'am.
Not a lot of people would do that. But I also can tell that you have a love for the Constitution.
Yes, ma'am, I do.
And here in Texas, we believe in law and order and the Constitution.
And you remember, Representative Jones, that Alfred Dwayne Brown spent 12 years on death row coming from Harris County. He's now been declared actually innocent. The prosecutor in that case concealed evidence as well. So this is a very, very serious matter, and I know that you're taking it seriously.
And you heard, you've looked at HB 3330, I'm sorry.
I have.
So you've heard comments by some of the DAs saying, well, okay, we know that A1 and A2 might have problems, but is it OP?
They seem to be skipping over the parts that allow the prosecutors to be the gatekeepers again, which was the whole idea the Michael Morton Act was designed to solve.
Right,
They
but-
want to go past that to the end.
So-
I understand why they want to do that, but I hope that the committee does it.
So while they've admitted, for the most part, that A1 and A2 have issues, right? They've said, yeah, but O, P, and Q, they're really not bad. It gives the courts like something. What do you have to say to that?
With your permission, Representative Jones, I would
Absolutely.
like that question to be answered by a criminal defense lawyer. My criminal work is limited to pro bono exoneration of wrongfully convicted people. So I would be concerned of any modifications to the Michael Morton Act. I'll tell you, if you would let me answer the question fully, Representative Little, the whole idea came about, and those who oppose this thing blame me, because Michael said, what can we do to keep this from happening to other innocent people? And I said, I'm a civil litigator. I know that if it just involves money, in discovery, I can find the other side's documents. I don't understand why, if it involves a man's or woman's life or liberty, that isn't more important, not less important. And there being no answer to that question, I was smart enough to know I need to get really smart people involved, and the Innocence Project of New York and all these great lawyers all contributed, and it came about, and it's used almost every day in 254 counties in Texas. And I don't think we can calculate how many innocent people have been prevented from being wrongfully convicted because of this bill. So I urge you not to make changes to it.
Okay. Mr. Little has a question.
Yes.
John, I just want to say thank you for coming. Thank you for all you've done. You and I had a case together years ago. I can't put my finger on it, but it's good to see you again.
Good to see you.
Yeah, thanks. Thanks for being here.
Thank you.
Thanks. Anything else, members? We do appreciate
Thank
you
you.
being here. The chair calls Sam Bassett. And Mr. Bassett, we have you registered as Sam Bassett on behalf of the Texas Criminal Defense Lawyers Association and self. against House Bill 3330, correct?
Yes. There are so many smart lawyers that have taken apart this bill, I don't dare tread into that territory. I'm a criminal defense lawyer. I've been practicing for 38 years. And tired. In 1987, I stood close by Michael when he was found guilty. I was a third-year law student working on the trial team. I saw him almost faint. 25 years later, I helped Deborah Baker's family, the woman who was murdered by Mark Norwood. I helped her children achieve justice by representing them on behalf as a victim advocate. Michael's case and Deborah's situation is not the only one. I'm emotional about this because my career, my legal career, has eclipsed this issue from the start of Michael Morton being convicted to today. And I got to serve on the Timothy Cole Commission with Representative Smithy, and I got to hear a lot of stories. And I think what this comes down to is if you take teeth out of this bill, it de-incentivizes the fringe law enforcement agencies and the fringe DAs, not the ones who are here today. People here today are fine people. But the rogue sheriff deputy who decides not to turn over something to a DA's office because he's certain he got the right guy. And one thing I remember about the Michael Morton trial and the guys that I worked for is we kept thinking, there's something we don't know. We don't know what we don't know. What is it? We couldn't find out. And we didn't find out for 25 years. And that's the gist of the Michael Morton Act, is as a defense attorney, you don't know what you don't know. And I'm sorry for being emotional today, but that's what I think about this situation, and that's why I think this bill should not be modified.
Mr. Bassett, thank you. Good to see you again. Any
Thank you.
questions for Mr. Bassett?
Yeah.
Yes, Mr. Cook?
Yeah, the last statement you said, that's why you think this bill should not be modified. Are you talking about this bill, or are you talking about the Michael Morton Act?
I'm talking about the Michael Morton Act. Yes.
I figured you were.
Thank you very much for clarifying that.
But, so my next question is, do you agree that paragraphs O, P, and Q do not make any change to the Michael Morton Act?
I think they do.
Well, tell me how, because I disagree.
I think the judge, it inserts a bad faith requirement for prosecutors withholding evidence. I think it also eliminates a judge's discretion on how to handle evidence that has been failed to have been turned over. In Heath, there was no bad faith. The judge didn't find there was bad faith.
I'm not talking about Heath. I'm just asking with regard to my bill, paragraphs O, P, and Q, I'm asking you how they make changes to the Michael Morton Act, because I don't believe they do.
It limits a judge's ability to suppress.
Where it says where it says a judge may, a court acting under subsection may suppress, that's limiting? If
He
it said,
may
if it said,
suppress only if the court finds that. I think that is a limitation on the judge.
okay. I mean, do you think do you think that is a change? I'm just asking if you know of any changes to the Michael Morton Act. That's my specific question, like with regard to paragraphs O, P, and Q.
I think that's a change.
Okay. And you think that's in paragraph Q?
I know it says may suppress, but it also says only if the court finds, one, the non-complying party knowingly withheld the required discovery, or the violation caused actual prejudice to a party. I think that is a limitation on the judge's discretion that's not currently in the Michael Morton Act.
Okay, so that's what I'm getting to.
Yes.
You do believe that that's a change to the Michael
Yes.
Morton? Okay. Thank you. Appreciate your testimony.
Thank you. Anything else, for Ms.
Yes, ma'am.
Jones?
Mr. Bassett, thank you. And I think that your tears are authentic, and if you can't cry over this, then what can you cry over? But so here's a question, and it's a leading question on purpose. Would you agree that sections O, P, and Q would materially change the judge's discretion, which is a change to the Michael Morton Act?
Yes.
Thank you.
Okay, any others, members? Okay, thank you
Thank
for
you.
being here, Mr. Bassett. We appreciate that. We have, the chair calls Jeremy Rosenthal. Mr. Rosenthal, as with all the other witnesses, we appreciate you hanging with us this long. And you're registered as Jeremy Rosenthal on behalf of yourself against the bill, correct?
That's right. TCDLA won't claim me, but that's okay. I love them just the same. My name is Jeremy Rosenthal. I'm a board-certified criminal lawyer. I practice in McKinney. Just to kind of clean up a lot of stuff, I mean, we've been kicking this thing around now for a few hours. And just kind of let me talk to you all about the life cycle of a case, because we've been hearing a lot about capital cases, but certainly this impacts a lot of non-capital cases, a lot of sex abuse cases, a lot of drug cases, cases across the board, right? The meat and potatoes of the criminal practice. So when you get a criminal case, let's talk about the discovery and how it works and the information systems and how they work. You have a baseline of zero evidence, right? And then you have the incident that happens, and then you've got body cameras, and you've got witness statements, you've got biological tests, you've got all these things, you've got interviews. So your evidence goes from here to up here. And then we get a true bill a lot of times, and then our line flattens, right? We're not doing a lot of discovery work. Prosecutors are not doing a lot of work in this instance. They're exchanging evidence with the defense, or they're giving it over, they're complying and all these things. But there's not a lot of investigation that happens. And with apologies to the Williamson County District Attorney, he is absolutely correct, and I am sorry that being a prosecutor in the 21st century is about disclosure. But we've also heard that it's working. We've heard that it's working extremely well. When you look at the major famous exonerations in this state, I'll tell you what they all have in common. They're all before Michael Morton. So we know that what we're doing is working, absolutely. What happens in any criminal case is that when the case gets set for trial, because I'm looking at the case and I think I can win it, the prosecutor thinks they can win it, maybe it's a punishment issue, but then what happens is we go from this flat line of discovery to we're 3 weeks away from trial, we're 2 weeks away from trial, we're 1 week away from trial, and we're learning more and more information about it because the DA's office is putting people in the field. They're putting their investigators back in the field. The defense is doing the same thing. We're interviewing people. All lawyers are putting out the hottest fires. That's what we do. And so the prosecutors are doing that. That's why we get so much information in the last 24 hours or 48 hours.
Could you kind of wrap up?
Oh, sir. Well, I think it's important because I am going to address P and Q and all that. This delta of new information that we always get at the very end, okay, it consists of exculpatory material, it consists of inculpatory material, mitigation, it consists of everything in the above. And ultimately, you know who's the first off, what we have to do is we have to flatten the discovery curve so prosecutors are getting this done earlier in the case cycle. And the second thing that we have to do is we have to trust our district judges to make these decisions, to hold, and I'll tell you how we solve this. It's real simple. You go to John Roach's court in McKinney, you're ready. You're ready from day one.
Okay, let me see if there's any questions. Any questions, members?
Yes.
Yes, Mr. Little.
Jeremy, you and I have been friends a long time. I just want to thank you for the sacrifice of traveling here. I know this is very important to you, so thank you for your time.
Yes, thank you.
Anything else? Okay, thank you, Mr. Rosenthal.
Thank you. Oh,
Okay.
yes.
Okay, Mr. Moody, I'm sorry.
You said you wanted to drill down on maybe a couple of the sections.
Right.
So I don't want to deprive you of that opportunity.
Thank you. Okay.
I don't know where,
So when we talk about Q, it does change. The judge has to make a finding that one of two things have happened. There's this issue with knowingly withholding evidence. And Representative Moody, I have never understood this. I was a baby prosecutor one time, and any time somebody said you didn't give me something, oh my gosh, you're calling me names. Oh my gosh, we're going to go outside and fight. Oh my gosh, it's all about me. It's not about me. It's about the jury. Jury doesn't get to see that. And whether a prosecutor has done something on purpose or whether they are, pardon me saying, whether they're lazy and they don't get it done on time, it's about the truth and it's about the jury and what the jury sees. So showing some type of animus or that they purposefully cheated is pointless in my mind. The second part, that's an impossible standard. I've never proven that to any judge anywhere. That they violated, caused actual prejudice to a party other than remedial alternatives. Well, we'll know if it's a guilty verdict, right? If it's caused actual prejudice. That's a really unworkable standard. So I think that those parts of the bill are very problematic.
Well, and I think, and I'll end here, but I think the point you raise is very salient, is nefarious or not, the net effect to the accused is the same.
I'm building a rocket ship when I prepare for trial. If I don't have the right parts, it doesn't fly. It doesn't matter if I didn't get it on purpose, and it doesn't matter if it was never in the box to begin with.
Well, I'll be very clear. I've been in those same shoes as a baby prosecutor, and you're trying to do the right thing.
They are.
And you are trying to make sure that it's all present and everything has come forward. Your case is, I mean, quite honestly, your case is always better when you proffer everything you got, warts and all.
In fact, if you're a prosecutor that's not addressing the warts of your case, then you're not really preparing for trial.
That's right.
And so, you need to protect against both. There are the heightened examples of the Michael Morton case where you have a nefarious purpose and some others that we've talked about. And then you have some that where it's like, this just got missed. But the net effect to the accused and their rights is the same, no matter if there was animus or not. And so I think that's what we're trying to drill down to.
That's right.
And so I certainly appreciate your patience in waiting here with us and testifying tonight.
And
Thank you.
to her point, to Representative Jones' point, you disclose everything, you might just convince me to plead guilty, right? And if we're going to go and fist fight in front of the judge about what's reasonable and not, to the prosecutors in the room, be careful what you wish for. That sounds like a lot of litigation to me. So thank you. Oh, yes.
And I think you bring up a salient point with the knowing, but I not too long ago had a case where there was a ton of evidence. There were probably 60 body dash cams, which meant I had to go through that. And when I was getting to it, I said to the state, hey, I'm looking at these body cams, from all the different officers that showed up, from all the different perspectives, and there's nothing that identifies my client, like nothing. And I said, have you looked? Because if we go to trial on this, I'm probably gonna whoop you. And the prosecutor, we literally got resets for the prosecutor to evaluate the cases. So that happens sometimes, right? And the judge kept giving grace to the prosecution. And we had like 3 resets, which each reset was over 30 days. Meanwhile, back at the ranch, my client is screaming bloody murder. You're not working for me. You should have gotten this dismissed. Those tapes you showed me don't show anything. Why can't you get this dismissed? At the end of the day, like 6 months later, the case finally was dismissed. When if the prosecution, to your point, had just looked at it earlier, the case would have been over. So, and I don't even know if, like you said, there are lazy prosecutors. Trust me, I know that. But there are prosecutors that literally wait until a case is set for trial. They wait for 2 weeks before it's set for trial, and then they look at the evidence. And that happens. And I think that if that happens, then the prosecutor literally shouldn't get any grace. They shouldn't get grace. I know that trials in Harris County are 2-3 years away, at least. When if they would just look through the evidence, cases could be resolved very quickly. And it would save counties money, it would save people's lives, and it would also get rid of a lot of the work that they have.
And I'll end on this. The solution is a strong district judge with full discretion to take everybody in their courtroom, put them on the spot, and ask them hard questions and do what they need to do to move their docket. Thank you.
Thank you, Mr. Rosenthal. Chair calls Nicole to the board. Hoagland? Okay.
That's why I leave the other one in there. So my married name, for those of you who don't know me, is Hotchglobe, and there's a lot of letters in there.
Okay, so you're Nicole DeBoard Hotchglobe. You've registered on behalf of yourself against the bill, correct?
That is correct.
Thank you.
And by way of introduction, I'm a former or past president of the Harris County Criminal Lawyers Association. I'm a former prosecutor from Harris County. I prosecuted with many of the district attorneys who you've seen testify here today, and Joan Huffman. Back in many, many moons ago, I don't have the same gray hairs that Prosecutor Ligon has, mainly thanks to Ms. Clairol, but I want to take some time to highlight some things that cause me a great deal of concern. I'm here in opposition to 3330, strong opposition. So in such strong opposition that I had a trial setting this morning, wrapped up in court, and got myself to Austin as fast as I could so that I could be here to answer any questions that you might have today. Representative Cook, you had some questions that I thought merited me jumping to the end to address, questions that I think are important concerning certain sections of the bill. I would argue that they do significantly change the Michael Morton Act. And specifically, I would say subsection O puts strict time limits on when the defense can raise an issue, which really kind of begs a question that John Raley raised in his emotional, and I have had a chance to meet with Michael Morton, and the emotion is, and that Sam Bassett came up here and gave to you. I mean, what you didn't hear, but I think you know, just to remind you, is that when somebody is wrongly convicted, aside from the people who suffer because a murderer runs free and does it again, Michael Morton had a 3-year-old baby when he went to prison for 25 years for something he did not do. That child grew up for a majority of his life believing that his father killed his mother and lost contact with him. That is a loss that is indescribable. I see I'm almost out of time. It limits the judge's ability, which the judge already has currently under Michael Morton and Heath, to choose correct sanctions. And I see my time is up. If I could finish my thoughts with your permission.
Finish your thoughts.
About what should be done. Heath, as we've already heard, a very conservative judge weighed very fact-specific information and determined that that particular evidence should be excluded. And then what happened is it went all the way up to the highest court, our Supreme Court of Criminal Law in Texas, and that court agreed with the judge's discretion. It was vetted, and it was vetted again, and it was vetted again. And now the case can still be tried, and it will be tried. So this bill does change that kind of discretion. It eliminates what is a fact-specific, flexible standard, allowing the people in the room to evaluate the facts and what are the appropriate consequences. It takes that away. And to me, that's a tragedy.
Any questions for? Yes.
So I guess I just want to flip in for a moment and talk about the victim, because I mean, there's no chance, that I would speak against the Michael Morton Act and what has happened to Mr. Morton. On behalf of the state of Texas, I apologize if that happened, and it's very disturbing. But just I want to ask a question: how you would, if you have an opinion for the legislature, let's assume that the defense counsel does have some type of evidence that the prosecutor truly does not know about, and that the defense just waits until the time of trial, and that basically throws out a case. Let's pick a gruesome case. Unfortunately we have lots of examples from Harris County specifically, or wherever. But if you just pick one of those types of cases, and based on a suppression, and clearly the defense is not being prejudiced in that situation. In fact, I think the defense counsel is being strategic, and obviously, I'm sure y'all do everything you can possibly do to represent your client zealously. But if that results in a case being thrown out for the victim, from the victim's perspective? Is there any type of suggestions that you would have, whether it's for this bill or future legislation or just in general?
I very much appreciate the question, Representative Cook. And I will say, one of the things that really significantly impacted the way I practice law, I was a prosecutor for almost a decade under Johnny Holmes back in Harris County. Very different time, very different administration. And I thought that I knew things. I really did. I believed in, we all marched down there to the courthouse together, thinking we were doing what was right. And believed in it to our core. And we had a boss back then who would say, fire us if we proceeded with evidence that was illegitimate. You got a lab report back after you pled somebody, for example, on, what we used to call turkey dope, fake dope, you were going to get fired. And so that meant you needed to have that evidence and try to make sure you evaluated it carefully. But to answer your question, the realization of the things I did not know when I left and became a defense lawyer was sudden and shocking in such a way as to knock the wind out of me, right? It just emotionally, about the things I did not know that were, the defense was having to contend with. And I cannot think of a time, certainly I'm going to litigate a case, right? And I know you're civil litigators and there's kind of a back and forth discovery. I'm going to do everything I can to litigate a case to make sure I'm getting information. It's not about not revealing information. It's about getting information. And, John Raley really highlights this point. For 7 years, with enormous resources available to him, pounded on the state of Texas with just a do not quit, I'll take you to federal court if I have to, attitude to try to get information, in large part, information they did not know what it was because it hadn't been concealed. And so one of these issues here in the timeline gives me great pause, because you're asking me as a defense attorney to guess what I don't know and ask for it at least 20 days prior to trial. And so you're going to have to bring that home to answer your question. It's not about a complainant. And I had a case just in the last few days that really addresses that point that you're making. That if you'll bear with me, I'll tell you about it. Sure. I don't know what I don't know to ask for it 20 days ahead of trial. All I can do is hope that the state is complying and giving me everything that they should. And this, even the more, what some of the prosecutors have alluded to is the innocuous sections of the bill eviscerate the judge's ability to make discretionary decisions about how to use it. Judges don't like to cut off a victim's day in court. The judges in Texas are elected, and they're going to have to answer for those questions, and they get to employ the discretion about what to do with the evidence already. The bill here before us doesn't add to that. In fact, it restricts it, and it hampers their ability to make these kinds of calls. A case that I just wrapped up ended up getting dismissed. It was, you think about how can you defend these people is a question I sometimes get at PTO meetings. I have 3 kids, right? And, indecency with child by contact, that's pretty awful. Nobody's in support of that. And the prosecutor's giving information as it becomes available. I don't know until, maybe in this case, 48 hours before trial, that there are some therapy records that prosecutor didn't know about that he got. Turns them over to me, which suddenly, within 24 hours, he turns it over to me. So that's 24 hours before I'm supposed to pick a jury on a guy that could lose his entire reputation, his family and everything else on this thing. And buried in those records, that this prosecutor then complies on sort of an extra agency bit of records, turns this over, and I think, lo and behold, I have responsive evidence with metadata in it that kills this. I know this is a lie. This is done, which I elected in that case to share. And it's over. Because I had a prosecutor who was ethical, but I will tell you, I have to evaluate, and it's not about gamesmanship. It's about...
Well, let me stop you there.
Yeah.
So let's say that you didn't get that piece
Right.
of evidence. Let's say you got it from a third party, not from the prosecutor.
Right.
And so, and obviously as legislators, we not only represent someone like Michael Morton, but we also represent the victim of a crime as well.
Right.
That's why I look at it anyway. And so how would I explain to someone that if it through no fault of the state, like let's say in the exact scenario you described, except for that piece of evidence came from a third party, rather, and the state truly didn't know about this piece of evidence. And then this victim's case gets thrown out because the defense attorney doing your job waited until after the trial started, jeopardy attached, whatever you want to call it, and then you raise the issue. The judge throws out the case or throws out the evidence, which results in the case being thrown out. So I guess what I'm saying is, in that scenario, I don't need you to tell me what to tell the victim, but I'm saying, do you feel like that there should be some type of protection in place for the victim?
There already is, and that is the discretion that is available under 3914 and Heath and Watkins. It's already built in.
Okay. So do you feel like, like you said, you decided to come forward, and say, here's the evidence. What if someone doesn't? If they just lie behind the law, so to speak, and do you feel like there should be, any type of protection there for the victim in that scenario?
Well, the quote-unquote victim in that scenario was patently lying, is the issue. So isn't a victim at all, it
Well,
turns
I
out.
mean, maybe in that scenario. But what I'm describing to you is, I'm talking about, let's say someone gets raped. I mean, clearly that's a victim that had nothing to do with a piece of evidence that you obtained through someone other than the state, the quote unquote the state. Just curious. Do you think there's any obligation from the state's perspective to bring that forward at any point in time?
I think that it's already there, right? Like, the solution to that problem is already there, and the state can argue exactly, and you could be the judge. You're making the calculus in your mind right now, and in our discussions, that the judge has to make in order to determine what to do with that. You can be in the middle of trial and have something disclosed, and the other side can say, I want to have a continuance now. And the judge gets to evaluate whether or not that makes sense. That already exists. There doesn't need to be a change in the law to make that happen.
You feel like that the judge has the discretion, is what you're saying, as far as if it's raised and the issue of suppression is brought up. You're saying just because of the judge has the discretion whether or not to grant the suppression or not.
Correct. And the judge can say, go home, come back next week, after y'all have all had a chance to evaluate this. Jurors go home, everybody goes home.
Yeah, and I think a continuance is a good remedy. I mean, I think that's was something that kind of got discussed at the beginning of today. But I think that a good remedy in this situation, because obviously I want to protect Michael Morton, the person that's in those shoes, but also want to make sure a victim has rights as well. And this committee has has heard testimony before today, that really has focused on victims' rights as well. And so that's why I'm just trying to strike a balance there. And I think a continuance. I think a continuance is a much better remedy than suppression in most instances. Obviously, in bad faith, slam the gavel down on the prosecutor if there's bad faith. But if there's no bad faith, I really think a continuance is a really good remedy. And I'll just we'll leave it at that.
And I appreciate your thoughts. The issue is that the judge already has that discretion, and then you have a case like Mr. McKinney's where for 4 years the state just doesn't produce whatever it is they're supposed to produce. At some point, the judge has to make an evaluation about whether or not judicial economy and the victim's rights and every other part of that equation dictates another continuance, or is it time to move on?
Well, I'm glad, since you drove all this way, I'm glad you got to testify for more than 2 minutes, and we had a good conversation, so
Yeah.
I appreciate your.
Sure, thank you guys. Oh, sorry.
Ms. Jones has a question.
Thank you for coming, Nicole. We've known each other for a long time. A long time. And for people who don't know this, correct me if I'm wrong, a lot of part of your practice is you represent police officers who've been charged with stuff, right?
That is true. I did a stint at the Harris County DA's office in our Civil Rights Division, prosecuting law enforcement and public officials. And then later, when I went into private practice, ended up representing quite a few individuals in those roles on the defense side.
Right. So what I can say I know about you is you prosecuted people you thought were bad guys, and were a very good prosecutor. And you defend people as a defense lawyer that some people, I will tell you, like, wonder if you should defend them. Like, cops accused of doing bad things to people, but you fight diligently for them. And I think you've testified with OP and Q that you think that those substantially change the Michael Morton Act.
I do, yes.
And I think I heard you say that the Michael Morton Act already gives a remedy for a judge to grant a continuance if a judge believes a continuance is the appropriate remedy.
100% in combination with the state case law.
And you also just were asked questions about, do you think the victim, their rights should be protected? And tell me if you believe I'm accurate. If I'm not, tell me where I'm wrong.
Okay.
As a defense lawyer, I mean, this system is supposed to work whether state prosecutes for the victim or for society and for the victim, right? They're the complaining witness in the case. Would you agree?
I would agree. I would agree. I would tell you, and this is not going to be a popular comment, but there's a case called Poe v. Collier. Ted Poe was a judge back in Harris County.
I know Poe.
Yeah, I know you do, but the others may not. Very conservative and had been a former prosecutor judge,
And in Congress.
And in Congress as well. And litigated the issue as to whether or not the state had the right to a fair trial. And the answer to that question under current state law since Collier versus Poe is no. The trial is about the accused. That is who carries the constitutional rights.
And so that actually was what I was going to ask. Who knew you were going to jump to the end?
Sorry.
Right. But what I'll say is this. If evidence ends up being suppressed because the state didn't do what they were supposed to do, whether they intentionally didn't do it or whether they accidentally didn't do it, the tie always goes to the accused.
Correct.
And so would you say to a victim where a case got thrown out that you need to talk to the state, they should have done their job?
100%. And on top of that, as a prosecutor, I would have been so mad at a law enforcement agency who kept something buried in their file, like the Alfred Brown case, and didn't turn it over to the person in court until after a person gets convicted. It's unthinkable.
And to the point of a continuance, although I think a continuance may be a remedy, to the accused, like they're literally becoming victims of the system. Like, right? The only victim is not always the victim of a crime. Sometimes the victim is a victim like Michael Morton or all these other wrongfully convicted people, or people that have to stay in jail from this time until the continuance. And I think that as a criminal defense lawyer, it is my job, it is my fiduciary duty to know the rules, to hold the state accountable, to follow the rules, to follow the Constitution, and the system will work.
And tell those police officers, turn that evidence over or you're not going to get to use it.
Thank you.
Thank you for being here. We appreciate it.
Thank you.
Chair calls Amanda Marzullo. And we apologize for the late hour. Your affirmation shows you're Amanda Marzullo on behalf of Austin Community Law Center and yourself, and you're testifying against the bill, correct?
Yes, thank you. And I think everybody who came before me did a great job of fleshing out a lot of the issues with the bill. I just wanted, as a defense attorney who recently expanded her practice to civil cases, I wanted to point out that in subsection A1, just how much of a difference that change makes where they're striking material to any matter involved in. That language that's currently in the statute is based off of an old version of the Federal Rules of Civil Procedure. It's basically a variation of Rule 192. What's discoverable? It's kind of a variation of that. And instead, it's replacing it with one part of the test for admissible evidence. So it's narrowing the scope of discovery from what could lead to evidence to what is evidence. And so that could be a really dramatic change in this case. And also with subsection 2, I can't think of a case that I've worked on over the past 16 years where I didn't submit a broad request for discovery at the outset. And that goes from misdemeanors to capital felonies. And like as other witnesses have pointed out, we don't know what we don't know as defense lawyers. So there is no way that I'm going to be able to make a demonstration to the court that the information I'm seeking is necessary. So those are just the two things that I wanted to point out.
Thank you, Ms. Marzullo. Any questions, members? Okay, thank you for waiting and for being here.
No problem.
The chair calls Jennifer Tharp. Ms. Tharp, glad to have you, and sorry you drew the black bean of being so late in the
Oh,
in
no
the
problem,
testimony.
no problem.
You're listed on your affirmation as Jennifer Tharp, Comal County District Attorney, testifying in that capacity and for yourself. And you are for the bill, correct?
Yes, sir.
Okay, thank you.
Thank you. My name is Jennifer Tharp. I believe I've testified in front of many of you multiple times. I'm here in support of HB 3330. But I'd be remiss to say that there have been multiple things that have been testified to that have made me pause and try to look through this bill through the lens from not just a prosecutor. I don't have the experience or privilege of having served as a defense attorney before being a prosecutor. I only know that role of being a prosecutor. There are multiple things that have been said tonight that I thought were interesting, and I'm happy to answer any questions, but I think when you come down to this particular bill, I do believe OP and Q are the most important aspect of it. I was not a part of the group of prosecutors who originally drafted the language in this. My focus this session will be a bill that'll be discussed later this week. However, what I found so interesting is some of the testimony that has been said by both prosecutors and defense attorneys about the world of discovery pre-Morton. So I was a prosecutor when Morton was happening. I was not in the room. I was a hot 2 years on the job as an elected and in probably way over my head. However, I do remember asking some of the other prosecutors, like, well, why is this exactly necessary? Not in response to Morton, but in response to the big picture of discovery. I came from a county where we had an open file discovery policy. And so I was just honestly taken back to hear that defense attorneys, when they were on a case, weren't getting the entire offense report, the 911 call, the videos, the photos, everything. And so I remember thinking back to Michael Morton Act. I'll try to wrap up, I apologize. Just being shocked because it was truly, in my opinion, a codification of making sure that best practices of discovery was put into statute. I think where we are here today is a need for best practices in terms of when new evidence comes forward, how to handle it. Representative Moody, I loved your questions earlier in terms of how you balance the defendant's rights, because sure, there is an impact to a defendant, and I am not going to sit here and say that that's not an impact. At the same time, I would love to sit down at a table with some defense attorneys to talk through Q, to talk about, is there an avenue where there could be more appropriate language? I get the aspect that if a prosecutor had no idea, but that's not just the whole story. Because I will tell you, there are some judges where you have a prosecutor assigned to that court, and that judge and prosecutor become very comfortable with each other. And this could be flipped on the other side. You could have a judge that says, you know what, I work with this prosecutor all the time. They're a great prosecutor. They had no idea about this. But then you go to that second prong where it really does have an impact for a defendant. And if it really does have an impact for a defendant, that evidence should be suppressed, in my opinion. And so I would welcome any opportunity to sit down. I will tell you, before this hearing, I actually sat down with Lindsay and with Alec from your office. I respect their perspective as being a defense attorney and looking at it from the prosecutor role, because that's how good law is made, is when both sides are at the table and they're truly trying to sit down and drill down what the issue is, not just looking at one extreme case or another bad situation, but let's drill down and look at it from a Texas perspective.
Any questions, members? Okay, thank you. Oh,
No, just a comment, not a question. No, I appreciate exactly what you said, is the opportunity to sit down. Because part of what I was kind of running around in my head is I remember as we did this over 10 years ago, right? You have stakeholder meetings, you sit down and you talk through things, because there's a give and a take, right, when you're doing these things. So I appreciate your willingness to sit down, because I think if we're going to do something, then sitting down with the Innocence Project and their experience, sitting down with TCDLA and their experience, sitting down with Mr. Morton himself. And while that is an example that, you know, is pretty egregious, I think because of what he went through, I think he has a right to be part of those conversations as well, and his counsel. And so I applaud you for wanting to do that, because you've always done the right thing in these conversations. It's a balancing act. We want to get it right. To Chairman Cook's point, there are people on the receiving end of this that didn't ask to be part of the criminal justice system either. And so you got to balance those things. So I appreciate your willingness to do that, because I've always been a big believer if we sit down and we work through this, we can get to a place that works. So thank you.
Ms. Bowers, you have a question?
No, just a comment. Thank you so much. I couldn't have said it better myself. Just the working together and bringing all those voices to the table, along with their ears so that we're hearing each other. So thank you for really not just talking the talk, but walking the walk.
Ms. Jones?
I too am willing to sit down with you. I mean, I actually don't think I have to drive all the way to Comal County, which
No,
I've
I
been
feel like I'm here more.
because you're here a lot, so you're welcome to come to my office.
Absolutely.
All right,
I
thanks.
would love that.
Thanks. Any other questions, comments? Okay, thank you for being here, Ms. Tharp. We appreciate it. Is there anyone else here to testify for, against, or on House Bill 3030? If not, the chair recognizes Representative Cook to close.
If you don't mind, I would close here.
Sure.
Yeah, so I mean, obviously, there's been lots of discussions, and I agree with DA Tharp, her comments at the end. I certainly welcome the opportunity to work with anyone that was here today or otherwise. I do think that we need to strike a good balance here and make sure that the protections that have been established by the legislature back in 2013, that those are safeguarded, but I do want to make sure that we balance those for the protection of victims, and so that cases are not unnecessarily thrown out or evidence suppressed that results in a case being thrown out. I just think there has to be a good balance there, and I just appreciate the committee's time today. I know it's taken several hours, but it's a very important issue. I know a lot more work was done when the Michael Morton Act was passed, and justifiably so. It was a wrong that must have needed to be corrected, and I want to applaud the prior legislature in getting it done, and I would like to have an opportunity to work with anyone that's willing to work together on making changes to HB 3330 to move it forward, and I would be glad to answer any questions if there are any.
Any questions, members, from Mr. Cook?
Otherwise, I close.
So Mr. Cook closes. If there is no objection, the chair will leave House Bill 3030 pending. Unless there's further business to come before the committee will stand adjourned.
Oh, I've got two more bills.
Oh, we've got, never mind. We will not stand adjourned, okay. I mean, we'll leave. We're still here, okay. Okay, so the chair, I apologize, Mr. Cook. I was thinking that was our last bill, but we had done that one before the others.
Wishful thinking.
So, you want to do 3166?
Yes, sir.
Okay, so the chair recognizes Representative Cook to lay out and explain House Bill 3166.
Mr. Chairman, is it okay if I lay it out from here?
Certainly.
Okay. All right, and I do have a committee substitute.
Okay, so Mr. Cook offers a substitute. Any objection to the adoption of the substitute? There being none. Well, actually, we won't even adopt the sub. It's getting late. We'll just lay it out.
Okay, great, thank you. All right, members, during the 87th legislative interim, myself, Speaker Moody, Representative Bowers, among others, I believe Chairman Leach and several others were appointed to the Criminal Justice Reform Interim Study Committee in 2021. We heard compelling testimony from the Yolo County District Attorney about a criminal justice reform concept called prosecutor-initiated resentencing, also known as PIR. PIR establishes a new opportunity for prosecutors to reevaluate whether a prison sentence still serves the best interest of justice while keeping victim input and public safety top of mind. House Bill 3166, as filed, permits the state attorneys to file a motion for computation of punishment in any district court in which an inmate is convicted. The committee substitute would require the district clerk to immediately deliver a copy to the presiding judge of the administrative judicial region to which the district court sits. The presiding judge would be required to assign a district court judge in which the inmate was convicted to conduct the proceedings. On a PIR motion, the court must consider, number one, an inmate's disciplinary and rehabilitation record while incarcerated. Number two, the risk of the inmate committing a future offense based on their age, time served, or diminished physical condition. And number 3, evidence of a change in the inmate's circumstances since the original sentencing, which demonstrates that their continued imprisonment is no longer in the interest of justice. Under HB 3166, victims will be afforded all of the rights that currently provided to them by Article 56A.051 of the Code of Criminal Procedure, including being informed when a PIR motion is filed and being kept apprised of any updates related to court proceedings. Additionally, under this bill, a victim would have the right to inform the prosecutor of their objection to the PIR motion, which the court must then consider when deciding whether to grant the commutation. More importantly, House Bill 3166 makes PIR motions only applicable to nonviolent offenses by excluding 3G offenses such as murder, sexual assault, etc., under Article 42A.054 of the Code of Criminal Procedure. In granting the relief, a court may reduce an inmate's sentence but may not increase an inmate's sentence. The court's decision would not be appealable by the prosecutor or the inmate. I will stop there. Be glad to answer any questions and like an opportunity
this
to close.
kind of goes hand in hand with HR 148 as well. Doesn't it?
That is correct.
Okay, well, we'll discuss that separately, but any questions for Mr. Cook? Okay. We have several witnesses, if you want me to go ahead and call them. We have Jenny Andrews. We show Ms. Andrews on behalf of the Texas Catholic Conference of Bishops who registered for the bill but will not be testifying. Next, Alan Place. Mr. Place, once again, registered on behalf of Texas Criminal Defense Lawyers Association, testifying in favor of House Bill 3166, correct?
Correct. Chairman Cook, this is a really good bill.
Oh, thank you.
Let me kind of comment, give you a little bit of background, and if there's any resource, this area is somewhat in my lane. You know, a lot of things we testify and hear about, you know, maybe a little out of my lane, but there has been a need for judicial clemency or commutation in this area. There is very little in that area, and what concerns me and why I think it's really a quality bill is the judge and the DA and the defense lawyer that you're going back to pretty much. They're the closest to to it, as opposed to going to the executive branch, who is somewhat removed through the Board of Pardons and Parole. And so that's, again, it's going to take and of course the reason that we don't have more of that is the constitutional amendment. That's what it's going to require in order to get it, because basically once you lose the jurisdiction in the trial court, they can't do anything. Even if they want to, they can't help you. And so, only thing I had, and Chairman Cook, I did send this to your office just as some thoughts in terms of, as the bill moves along, in terms of sort of comparing it to executive clemency. Number one, you did limit it in 53001. I would just comment, in the executive branch, they don't limit it. I mean, it's any crime basically there, and so that is something I'd have you consider. The other thing is, as I read your bill, only the state can file it. I would say consider the defendant filing it, but in this case, having the state sign off before you can proceed. I think that would be a little more of a balance. And the last thing is, as I read it, it only applies to incarcerated individuals, and certainly executive clemency can apply to people that have already been paroled. I know it's obviously a bigger deal to somebody that's incarcerated that would like to get out, but there are people that have basically been paroled that still would like to have some sort of clemency, because if they received it in that instance, their sentence would be over with and they would no longer have an obligation to the state of Texas.
Any questions for Mr. Place? Thank you again for
Thank
being
you,
here.
Mr. Chairman.
The chair recognizes Jeremy Hale. Mr. Hale, we're showing you registered as on behalf of For the People, and you're for the bill.
That's
Is that
correct. Thank you for the opportunity to testify on HB 3166. Last session, a similar bill passed out of the House with broad bipartisan support. Ran out of time in the Senate. But I'm Jeremy Hale. I'm with For the People. I'm the policy director there. and we work to support prosecutors on the implementation of prosecutor-initiated resentencing. For 3 decades, I've been interested in criminal justice reform issues since I started visiting prisons as a student at Abilene Christian University. Texas has long led and served as an example for the nation in how to advance solutions that uphold public safety, that protect victims, and lower taxpayer costs. So HB 3166 would build on this tradition by allowing Texas prosecutors to carry out their role as protectors of public safety by giving them a tool to carefully review old cases and make sure justice is served. Under this common sense legislation, if a sentence no longer fits the crime, where the punishment is disproportionate based on current law and practice, and there is new knowledge about the facts of the case, the prosecutor can initiate a review. Victims have the right to be notified and to share their views with the court. The trial judge always makes the final decision on resentencing, ensuring checks and balances to protect public safety and the interests of justice. So this tool recognizes that we can make better decisions with better information. For example, women have been identified in Texas prisons who were victims of human trafficking, which was not known or taken into account at the time of their sentencing. And there are people who have served many decades in prison, worked hard in their rehabilitation, for example, become ministers who could be serving their communities. By design, this is an incremental measure that allows prosecutors to identify people who are deserving of a second chance. It's aligned with Texas values of public safety, justice, and protecting public safety dollars. Thank you for your consideration, and I'd be pleased to answer any questions.
Thank you, Mr. Hale. Any questions for Mr. Hale? Thank you for being
Thank you.
here. Chair calls Nikki Presley. Ms. Presley, you are registered as Nikki Presley, testifying on behalf of the Texas Public Policy Foundation for the bill, correct?
Yes, sir.
Thank you.
Thank you, Chairman. My name is Nikki Presley. I represent the Texas Public Policy Foundation and Right on Crime, and we are in support of HB 3166. As Chairman Cook mentioned, in 2022, my boss, Brett Tolman, who is a former U.S. attorney and our current executive director, was appointed on the Criminal Justice Reform Interim Study Committee with several of you, Representative Cook, Moody, and Bowers, which he had a lot of fun serving with y'all. But this issue came up from the Yolo County District Attorney, and it was studied, and we heard witnesses talking about it, and so this would allow courts to grant a commutation in certain circumstances. It excludes the 3G offenses that Representative Cook mentioned. The whole goal is to allow district attorneys to initiate a thorough and methodical review of certain sentences that were legal and appropriate at the time of sentencing, but that may no longer serve in the best interest of justice. This may be a case where the person has served a lengthy amount of time, has fully rehabilitated, and can be safely released. This bill is also discretionary, so each district attorney can choose whether or not to utilize this, and it's just an additional tool for them to serve the best interests of the communities that they serve. We have long been a leader, as Jeremy kind of mentioned, in innovation in Texas in the criminal justice system, and I think that this is one step that we could take when it comes to resentencing and commutations. So thank you for your time.
Thank you, Ms. Presley. Any questions? Thank you for being here. Chair calls Tara Tucker. And you're registered as Tara Tucker on behalf of the Alliance for Safety and Justice, and you're for the bill, correct?
Yes, Tara Tucker, State Director for Alliance for Safety and Justice in support of 3166. As you guys know, we are a multi-state organization focused on safety solutions that break cycles of crime, and we work with survivors of violent crime and people living with past convictions. We have commissioned multiple survivor surveys on what survivors really want. The overreaching theme is that they want what happened to them not to happen again and not to happen to anyone else. They want a criminal justice system that relies more on healing victims, prevention, and rehabilitation, not just more long prison sentences. HB 3166 would create a system that would allow prosecutors in court to use their discretion to identify cases where new information and changes in circumstances point to the need for different sentences in the case. The court would only consider these cases on recommendations of the prosecutor, and the court would allow the discretion to consider the information and either grant or deny prosecutorial resentencing. While there are a lot of different scenarios that this could be used in, I want to speak specifically about how this could help victims of crime who may have been forced or coerced to commit crimes by their abusers. It is not uncommon for victims to be caught up in the criminal justice system because they were forced or coerced, or are convicted of crimes that is part of the abuse dynamic. This bill would create a pathway for prosecutors to rectify these cases. While the system may identify these cases at trial and make specific prosecutorial decisions at that time, too often victims don't feel safe identifying as victims when they may still be under the control of their abuser and therefore do not provide necessary information to make the appropriate decisions in the case. HB 3166 would provide the opportunity for prosecutors and courts to provide solutions in cases such as these, which are in the best interest of justice. Thank you.
Thank you very much. Any questions for Ms. Tucker? Appreciate you waiting and being here. I think that's Is there anyone else here to testify on, for, or against House Bill 3166? Seeing no one, the chair recognizes Representative Cook to close.
Mr. Chairman, I don't know where all these supporters were on the prior bill, but unless there's any questions, I close.
So Representative Cook closes, and House Bill, if there's no objection from the committee, House Bill 3166 will be left pending. Mr. Cook, you want to do HJR 148 now?
Yes, sir. I'd like to.
Chair
very quick.
recognizes Representative Cook to lay out and explain HJR 148.
Thank you, Chairman Smithy and fellow committee members. Appreciate the opportunity to also lay out this HJR 148, which was obviously related to House Bill 3166, which is prosecutor-initiated resentencing. HJR 148 would send a constitutional amendment to the voters for approval in November of this year. Specifically, HJR 148 would amend Article 5 of the Texas Constitution to permit the legislature by general law to allow a court to grant a computation of punishment to certain individuals. Mr. Chairman, I'm available for any questions the committee may have. I'd like an opportunity to close when appropriate.
So is it your understanding that for 3166 to have effect, the constitutional amendment would have to pass?
Yes, sir, that is correct.
would be the
Two-thirds
enabling
of the House would be required.
All right. Any questions for Mr. Cook? If not, the chair, we have several witnesses. The court, the chair would call Jenny Andrews once again. Ms. Andrews, we'll show Ms. Andrews testifying on, not testifying, but on behalf of the Texas Catholic Conference of Bishops for the bill. Chair calls Jeremy Hale.
Thank you, Chairman. I'll be brief.
And let me show you, so you are registered as Jeremy Hale on behalf of For the People, and you are in favor of HJR 148, correct?
Yes. Like HR 3166, HB 3166, last session, similar resolution passed the House with broad bipartisan support. This resolution, HJR 148, would propose a similar amendment to the Texas Constitution, as Representative Cook discussed. A number of states give courts the ability to adjust the sentences of incarcerated people in the interest of justice. Unfortunately, Texas lacks certain tools to remedy circumstances where new knowledge arises about the facts of a case and where adjusting the sentence may be in the interest of justice and public safety. So this resolution seeks to address this issue by allowing the legislature to provide a narrowly tailored tool for a court to adjust punishment for certain incarcerated individuals in a limited number of cases. Thank you for your consideration.
Thank you, Mr. Hale. Any questions? Ms. Jones?
You understand this is where they can commute it and make it less, not more, correct?
It can only be used to reduce the sentence. It
Okay,
cannot be
thank you.
used to increase it. Yes.
Okay, any other questions? Thank you for being here again.
Thank you.
And the chair calls Tara Tucker. Seems like all of you were just up here.
Deja vu.
And so you are Tara Tucker, you're registered testifying for Alliance for Safety and Justice, and you are in favor of HJR 148, correct?
Correct. HJR 148 would free up the legislature to grant courts discretion to revisit cases and to more quickly adjust to any best practices in new research may identify. Currently, if the legislature passes a law to change sentencing based on changing understandings of what works best, the change can only apply to future cases, and there is no legal pathway for the legislature or courts to apply these changes to people currently serving time for such an offense. It's important to point out that the legislature would be under no obligation to pass new laws. They would just have the ability to do so if that need or desire arose. And of course, this has to pass in order for the other one to work. So, thank you.
Thank you, Ms. Tucker. Any questions? Thank you for waiting us out on this. Is there anyone else here to testify for, against, or on HJR 148? There being no one, Chair recognizes Mr. Cook to close.
Thank you, Chairman. Be glad to answer any questions. Otherwise, I close.
Any questions for Mr. Cook? If none, the chair will leave HJR 148 pending, and the chair would then recognize Representative, the chair would recognize Representative Cook once again to lay out and explain House Bill 4342.
Thank you, Chairman Smithy, and I'll be very brief. We do have an expert witness here that can run through this bill faster and more effectively than I can. But I will just give you a little bit and then ask the chairman to call the witness. So House Bill 4342 would permit outcry witness testimony of extraneous victims to be admitted during the guilt-innocent phase of trials in cases involving sexual abuse of a child or person with disabilities. Article 38.072 of the Code of Criminal Procedure only currently allows outcry witnesses for extraneous victims during the punishment phase of a trial, but not during guilt-innocent phase, meaning it is critical for our jurors to know that the state of mind of the defendant, the relationship between the defendant and child, and the character of the defendant. Evidence of a pattern of behavior towards other children is vital to jurors to determine guilt or innocence. House Bill 4342 permits outcry witness testimony of extraneous victims to be admitted during the guilt-innocent phase of a trial in cases involving sexual abuse of a child. And again, the witness that I have here is from the Tarrant County District Attorney's Office. She's an assistant district attorney there, and her name is Lauren Lawrence. And I know that she'd be happy to walk through any examples and/or answer any questions. And I would appreciate an opportunity to close when appropriate, and happy to answer any questions, Mr. Chairman.
Sure, and so the chair will call, well, first of all, any questions for Mr. Cook? If none, the chair will go ahead and call Lauren Lawrence. And as the others, we appreciate you waiting to testify. The record shows that you are Lauren Lawrence, representing Phil Sorrells, who's the Tarrant County District Attorney, that office, and that you are testifying in favor of House Bill 4342, correct?
That's correct, Chairman Smithy. Members, thank you so much. I want to start just by kind of walking through what this bill doesn't change, first of all, right, which is that this legislature has allowed outcry witness testimony, so the hearsay statements of the first adult, a person over 18, that a child told about each act of sexual abuse. This legislature has allowed that testimony under 38072 since 1985. This legislature has permitted evidence of extraneous victim testimony to be offered in a trial since 1995. And so when I looked back, I thought, well, because they passed 38072 before they passed 3837, it must have been overlooked that the extraneous victim's outcry witness doesn't get to testify in guilt innocence. They only get to testify in punishment. What I found was that that was actually an amendment done in 2009 in HB 2846. And what stuck with me was the background and purpose that was offered in that piece of legislation, which said because children are often ineffective witnesses in criminal proceedings involving sexual abuse due to the pressure of testifying in front of strangers and the defendant, Texas law allows the testimony of the outcry witness, the first adult the child informed about the alleged acts, to be used as evidence in criminal proceedings. This law applies to an outcry witness of the victim only. The purpose of this law is to allow the testimony of an outcry witness other than the victim who has been allegedly assaulted by the defendant to be used as evidence in criminal proceedings. This information would give the jury a better understanding of the defendant's history and could result in a different verdict. That was the background and purpose that was put forward in that bill before it was substituted in the committee that included the language that we're looking to strike with this bill, if offered in punishment. The original intent of the bill was to allow that testimony to be offered in both stages, and then it was changed in the committee substitute. And ultimately, because children can be ineffective witnesses in criminal proceedings, because of that pressure, that's why we allow those outcry witnesses to testify. And so only allowing that extraneous victim's outcry witness to testify in punishment is inconsistent with what we know about why we allow those statements to begin with. And so that's why we're asking the legislature to make this change. And I'm happy to answer any questions.
Thank you very much. Ms. Jones has a question.
So you want for alleged, because I think you said alleged offenses to be used in guilt innocence. And first of all, I don't believe that's constitutional. And I understand the difficulty with little kids. I understand that. But I think it has problems with reliability. There's a reason why it might be important to know extraneouses and guilt innocence, because the jury actually judged the defendant on the crime that they're charged with. They're charged with it. Extraneous offenses of what they might have done to somebody else is absolutely prejudicial for someone to get a fair trial. And I do not believe that this will pass constitutional muster. And a lot of times with committee substitutes, because you brought up the committee substitutes are like, okay, this bill's gonna die unless you figure out a way to change it. So, can we find a committee substitute to make it palatable or alleviate some concerns, which is why the committee substitute probably happened. But I can tell you that any attempts, respectfully, to allow extraneouses of an allegation that hasn't been proven in court to be used in guilt innocence, I believe violates the Constitution. And I think that any probative value absolutely outweighs, it's totally prejudicial to the accused to get a fair trial for what they're charged with.
I understand that, and that's why I brought up the fact that Article 3837 of the Code of Criminal Procedure, which is evidence of extraneous offenses or acts, has been on the books in this state since 1995 and has had all of that time to be challenged to withstand constitutional muster and is still good law in this state. So this bill doesn't look to change the fact that we can offer extraneous evidence and guilt innocence as it is. All it is doing is making the outcry witness consistent, the outcry witness for the extraneous victim and when they can testify in a trial, consistent with when an outcry witness for the victim of the alleged offense on trial, when they can testify as well.
But the outcry witness for the crime that they're charged with absolutely is relevant. But another outcry witness for somebody that has nothing to do with this, it's irrelevant and it's highly prejudicial, and I believe it violates constitutional muster. And I also don't think that just because a law allowing an outcry witness of who's actually the case is trying to, I guess, get justice for them, that doesn't translate to any other outcry witness. And I don't think that just because it's been around since 1995 makes it. I just don't think that it overlays onto some irrelevant outcry witness. Now, if someone is convicted based on the facts of the case that they're actually charged with, then I don't have a problem with extraneous coming in. And then that'll go to, well, how long do we lock these people up? I mean, do we put them under the jail? Do we lock them up for life? But it's absolutely prejudicial, especially if you have a bunch of children, because nobody wants to see a child victimized. But I'll also say this, as a person who's represented a number of people charged with crimes alleged to have been committed against children, children are also manipulated. I have had a ton of cases where there's parental alienation, where a child has been convinced that something happened, or a child has been turned against someone, and so it needs to stay exactly like it is. And if it was so obvious, it would have been in there before. But I'm just letting you know where I come from.
Yes, absolutely, and I appreciate your point of view. I do want to address, when you talk about the reliability of the statements, the reliability of the extraneous victim's outcry witness would be put to the same requirements of a trial, or not a trial, excuse me, of a hearing outside the presence of the jury that we do for the outcry witness for the victim alleged in the offense, because we do have to have a hearing to determine that that adult is, in fact, the outcry witness for that particular act. So this outcry witness would be subject to that same hearing. And on top of that, extraneous victims are also subject to a hearing prior to that testimony being offered in front of the jury for the judge to determine reliability. So there are multiple steps in the process before this evidence is ever presented in front of a jury for the judge to make a determination about the reliability of those statements.
And I'm just going to go back to the reliability of the initial outcry witness of the person, of the complaining witness, absolutely relevant. I have no problems with that. But to bring in other outcry witnesses for the case that's going on, that they don't have anything to do with that, it's highly prejudicial, it's not probative, and it's just one more way for the state to lean the justice system in their favor. And you have a constitutional obligation to prove beyond a reasonable doubt, and throwing in other stuff. And let me be clear, when people are convicted during guilt innocence, and you have a whole bunch of people coming in during punishment saying they've been bad since they were born or whatever, those are the people that get put under the jail. And I don't have a problem with that. But it comes in when it's supposed to come in. And again, I believe it to be unconstitutional.
I appreciate that point of view.
Anything else, members? Okay, if not, appreciate you being here.
Thank you.
Ms. Lawrence, anyone else here to testify for or against or on House Bill 4342? If not, Chair recognizes Representative Cook to close.
I close.
So if there's no objection, the chair will leave House Bill 4342 pending. One more matter. Do I need to withdraw that? Members, a moment ago when we heard House Bill 3166, it was left as pending business. I need to recall that bill if there's no objection and withdraw the committee substitute at this point. Any objection to that? If not, withdraw the committee substitute, yes. And so the chair, then the bill will be left pending. Any other business, members? If not, the chair will stand adjourned. Thanks.